At the request of the learned counsel appearing for the petitioner, list the matter again on
Monday, my lord.
31st of August 2026.
Deeply authorized.
Yes, madam.
My lord, this matter may be listed for admission on Friday, my lord. This matter released to maintenance, my lord.
Okay.
My lord, same prayer, my lord, on Monday, my lord. Obliged.
May I please, your worship, my lord, one item listed in code number 21, my lord, item 3. Item, my lord, regular bail, my lord, that may be taken today, my lord. As because two minor children is there, my lord, mother is the petitioner, my lord.
It is a bail matter. We'll have it on the list if it
Only
reaches
here,
his luck.
here, my lord, my prayer is this only, just issue, my lord, call CD, my lord.
Huh?
Call for CD, my lord, this prayer, my lord. Oh, no more time, my lord.
You have to give a mention memo. Huh? Oh. Let us see. Let us see.
Well,
Okay. Call for it. Yes.
May I please, your lordship? Lordship, I'd like to mention item number 15 from court number 21.
1-5.
1-5, yeah.
Huh.
From court number 21.
Huh.
Lordship, the matter in the lower court is fixed on 38. Matter may be fixed day after tomorrow.
Day after tomorrow. Done.
May I please, your lordship?
We have to give the details to the.
Yes, yes, sir.
Unless you give us a mention memo,
Definitely, your lordship.
please send it.
May I please, your lordship?
Lordship, this is regarding.
And write the court number also.
Yes,
When you are mentioning for that code, please write the court number
Yes,
of that.
sir.
Yes.
Lordship, this is regarding item number 64 of supply list.
Mm.
Lordship, I request you to fix the matter on 31st August. My engaged counsel is out of station.
Okay. At the request of the learned counsel appearing for the petitioner,
Yes.
list again on 31st of August.
May I please, your lordship?
Yes.
Lordship, I beg to mention item number 49 and 50.
Yes.
Consent has been taken, your lordship.
Mm.
Due to some personal difficulty, the conducting counsel won't be able to appear today.
Mm. When do you want it?
After puja vacation,
At the request of the learned counsel appearing for the petitioner with the
respondent.
respondent.
For the petitioner.
You don't have any objection after
No.
puja vacation? No. At the request of the learned counsel for the respondent who has taken the consent of the learned counsel for the petitioner, list this matter in the first week of November.
Both the matter IS interim order.
The interim orders passed earlier shall continue.
Highly obliged, lordship.
Your-
May I please, your lordship, with due consent from my learned counsel, madam, I beg to mention item number 12. Matter may come up after 3 weeks.
Item 12.
Lordship.
At the request of the learned counsel for the petitioner with
My lord, I am for the respondent.
of the respondent
What?
with consent from the learned counsel for the petitioner, list this matter again after again on
And in the month of September, my lord, last week.
30th of September 2026.
Obliged.
Please, your lordship, I am paying for item number 55 from supplementary list. Yesterday we filed an additional affidavit regarding that. I have the requisition application. And the same may be called for. Lordship.
May I please, lordship? I beg to mention item 9 of court number 21, lordship.
Ah,
Can it be listed for Friday, lordship?
give the mention memo, we'll allow it.
Much of.
I beg to mention on Friday, my lord, criminal division.
You have to give the court number of that,
Yes, sir.
you have to say, because otherwise we'll not be able to. Yes.
Lordship, item number 1 for court number 21,
Huh.
lordship. Lordship, tomorrow.
Tomorrow?
Tomorrow, lordship. The bail application of other co-accused is fixed for tomorrow for
Huh.
city, lordship.
Take it. You give a mention memo,
Yes, sir.
requiring to be fixed tomorrow.
May I please, your lordship?
Hmm.
Lordship, I beg to mention an item for listing IA criminal for suspension of sentence.
Hmm.
It was filed immediately after summer vacation. The matter was last listed before Honorable Justice Jahan. But Honor Justice have directed not to place the matter before her.
Hmm.
A. Mbora is on that.
We'll have it on 11th of September. 11th September? Yes. Give a mention memo, it will, otherwise it is not public.
May it pleases your lordship.
Hmm.
I beg to mention for listing of a criminal appeal lordship. Already I had mentioned last week for today, but in spite of mention memo, it did not come.
Ah.
And there is a legal aid counsel.
Ah,
I have
find
even
out.
next I have annexed the filing slip. It's filed in the month of June.
Ah,
So, but
there are no objections in it, I hope.
no, I have rectified the objection
Okay.
earlier.
When do you want it?
As per lordship convenience.
We'll have it on Monday, 7th,
Yes.
appeal?
Appeal and order also will be there because IA is there for delay in filing.
Sometime it will come for admission.
Huh. No, it will come up for orders first for the condonation of delay.
Condonation of delay, yes, lordship.
Does it involve POXO?
POCSO lordship.
Oh, then notice has to go.
Yes.
Otherwise, you could have condoned it.
Made
Yes.
Your Lordship, I beg to mention item number 17 of 421.
Huh.
Lordship, kindly fix it for, allow it for tomorrow, Lordship.
Give a mention memo.
Obliged, Lordship.
May I please, your Lordship? My Lord, on last 17th, my Lord, one criminal petition was listed before your Lordship and it was directed to be listed on 19th, my Lord.
Mm.
But matter has not been listed, my Lord,
Till today.
till today, my Lord.
Have you seen the order?
Yes,
See,
my Lord.
so I hope it is not 19th of September.
It was day after tomorrow.
Acha. কোন number item side দিব? Have a discussion with him, look into. যদি আহিব লাগে mention to allow কৰাই দিব.
May I
Yes.
please, Your Lordship? Lordship, I'm praying for listing of two regular bail application.
Hmm.
Can it be fixed on 2nd of September?
Okay.
Most of And there's one more prayer, Your Lordship, for item number 66 of supplementary leave.
66.
Yes.
Huh?
We have been instructed for withdrawal.
It is with 65.
Yes, it's a tag
Let it reach the other council should be here.
obliged.
Yes.
May I please, your Lordship?
Huh.
Code number 21, item number 41, your
Huh.
Lordship. It may be listed on. May-
Friday? Friday will do? Huh? Give Friday's date. Yes, madam.
Lordship.
Mention. I will-
You have to give a mention memo for Friday.
It is a lordship. Lordship, item number 5 of code number 21, your lordship. Can it be listed tomorrow, your lordship? Obliged, lordship.
You have to give a mention memo, madam.
Yes, your lordship.
Mm.
May I please,
Obliged.
your Lordship? For listing of two AB Lordship, can you Monday, Lordship?
Monday allowed.
Motion.
Me, please, my lord. My lord, I beg to pray for listing of 3 quashing applications. The connected bail applications are listed before this court tomorrow, my lord.
Hmm.
Therefore, I pray that the quashing applications may kindly be listed tomorrow.
Notice you should go to your pen. Please continue. Okay.
Grateful, man.
May I please, your lordship? I beg to mention item number 2 from code number 14.
Hmm.
Kindly adjourn for a day.
It's already adjourned. Court number
14.
14. That is what I was also thinking. You see, court number 14.
14.
14. 14 और कौन वो है? हाँ. But why are you mentioning it here? The only matters from Justice Chahan would be coming here. Find out. If you are allowed to mention it here, mention it at 2. I'll see. Yes.
May it please, your Lordship. Your
Hmm.
Lordship, in item number 28, we have filed an additional affidavit. Kindly maybe requisition of the court.
Yes.
Deeply.
Wait, my lord,
Hmm.
I beg to mention for listing on when it's an additional affidavit we have filed. Item number 70, Lordship. 70.
170. Huh?
70. Additional affidavit, Lordship.
Huh.
It's a requisition slip, it may be called for. Lordship, another matter, it's item number 23, Lordship.
Huh.
We have already taken consent from the matter may kindly be adjourned for today, Lordship.
At the request of the learned counsel, appearing for the petitioner
Lordship,
with the consent of the learned
am I
amicus, list this matter again on
7th of
7th of September. ठीक है?
Lordship.
May I please, the Lordship? Lordship, praying from the listing of criminal filing number 751/2026, my lord. It's a file on my lord 19/8/2026, my lord.
19?
19/8/2026, my lord.
Huh.
So my lord, tomorrow may be fixed, my lord.
Not tomorrow.
My lord.
It is what? It is the bail.
Yes, my lord.
Bail petition.
Yes, my lord.
19 file हुआ आज लगा list के लिए हुआ ना? Bail petition.
No, my lord. Criminal petition, my lord.
Criminal petition. Okay. You have it on the 2nd.
Yes, my lord.
2nd of September.
No, my lord. In this matter, my non-bailable warrant of the arrest of has been. taken
Because
in
you
the-
did not appear.
Yes.
You
my
were running away from that court. Now this court is chasing you till 2nd. What is the difficulty? 2nd. 2nd of September.
May I please, lord?
Yes.
Lordship, item number 29 of court number 21, lordship.
Ah.
Can I put lordship day after tomorrow, lordship?
Yes.
May I please your lordship, in item number 21, we have filed an additional affidavit, lordship.
Of this court?
Yes, lordship, so. Give your lordship.
Please, before lordship, before your lordship for listing a criminal appeal,
Sorry?
criminal appeal.
Ah,
Of 2023 matter.
On
Bokso
23rd.
matter. Day after tomorrow or Monday matter.
I did not get you. You want it listed when? Day after tomorrow. You want a listing for day after tomorrow, criminal appeal.
Monday or Monday.
Monday, let us make it Monday, 31st. 31st of August.
May please, my lord.
Yes,
Number 17, my lord.
17, yes.
7, matter may be adjourned today.
At the request of the learned counsel appearing for the petitioner with prior intimation to the counsel for the respondent, have you informed?
My lord.
No, then they will come and sit here. What happens? Inform them first, then we will adjourn it. Okay? Don't write
Already
the
I
other.
called her, my lord.
Ah.
Over telephone, my lord. I
Ah.
have stated her.
She knows about it.
Yes, sir.
Yes. At the request of the learned counsel for the petitioner, who submits that the consent of the respondent has been taken, comma. List the matter again.
Tuesday, my lord, 1st September,
1st September. Okay. Did you 1st September? Tell position.
only day, the 7th, my lord.
7th of September. Okay. Yes.
Have to mention item number 34, Lordship.
34.
It is not available, Lordship.
Since going. Not 7, my
There
lord.
is an interim, Lordship.
Wait, we'll take up the matter. Yes, when did you want it?
Not 7, my lord. Kindly matter may be listed after puja vacation, my lord.
Okay. On
I-
3rd of November.
3rd November. Highly applicable.
Yeah, please, your lordship. I beg to mention item number 47 of court number 21, lordship.
Ah,
Lordship, the criminal revision petition actually was dismissed on the part of the earlier counsel due to his non-appearance. We have filed the restoration, lordship. The person is in jail for 3 months, so short date may be fixed, lordship.
you take a date, any date. Take it on 31st of August. Next Monday.
Yes.
May I please, my lord? My lord, I am here for mentioning item number 42 of court number 21, lordship. The interim order, it is criminal petition, lordship, and the interim order is still today only, lordship. So it
Today.
may be extended until.
Anile order to extend your pen. You move in and mention memo for today. We'll call it from that code then. Yes. Give a mention memo, it will come from that code. Write the code number. Yes.
Deeply obliged.
May I please, your lordship, listing of a regular bail application, my lord. Alleged to be a fake doctor, my lord. He is 66 years, my lord. Can be on Friday.
How many years?
66 years. my lord.
66 years. Bail petition is behind bars.
Friday, my lord.
Because you see at the age of 68, you don't need to be a doctor. You have enough experience to treat people. Then we can allow him to go. Yes,
Obliged.
Friday,
Friday. Obliged.
May please, your lordship, I beg to mention item 33, your lordship.
33.
Yes, your lordship.
Hmm. Yes.
The CD is not available, your lordship.
Wait for your turn, madam. If the charge sheet is submitted, then perhaps we'll close the bail petition.
Pleasure.
May it please your lordship, I am appearing on behalf of Mr. A. Ahmed. Your lordship, I beg to mention item number 20.
20.
Your
Yes.
lordship, some evidence has been received. We need some time, your lordship, to procure the evidences.
Someone has called for the additional affidavit also in item 20.
Yes, your lordship.
Then
I
you
don't-
don't want to do it today.
No, your lordship, we need some time for procuring the evidence.
Oh, additional affidavit আহিলে তাত গাঁঠি পেলাই পঠিয়াই দিব. When do you want it?
Any day next week, other than 31st of August.
2nd of September,
Okay, your lordship.
item 17, no, item 20.
20.
7th of September,
Wait,
at the
please.
request of the learned counsel for the petitioner.
Wait, please, your lordship. Lordship, I beg to mention item number 18, lordship.
1/8.
We have taken consent from other side, lordship. The mother of the informant died few days ago, lordship. So she is
And-
under bereavement.
At the request of the learned counsel
And for
for
respondent
the
who is-
respondent
Yes.
with prior intimation to the learned counsel for the petitioner, list this matter again
After
on
2 weeks.
after 2 weeks. হলে আপনি 14 তারিখে দি দিয়ক। 14th of September,
Deeply obliged.
May I please, Lordship? My lord, we have filed an AB on Friday, Lordship. May I pray to take up the matter tomorrow, Lordship? Because there are 4 petitioners, one of them is a cancer patient.
Okay.
Obliged. My please, your lordship. Item number 8 of court number 22, your lordship. The co-accused has already been granted bail by the honorable court. So if possible, your lordship, kindly fix it by this honorable court today itself, your lordship.
Today?
Already-
The difficulty is that they will have to call for the CD and everything from the other court, number one.
Yes, lordship.
Number two, we already have 71 matters on the list.
My submission-
Tomorrow morning?
my
We'll have it
submission-
tomorrow.
Yes, yes.
Tomorrow. Give a mention memo for tomorrow.
Mention of- Yes.
You'll have it
Much
tomorrow.
obliged.
Yes.
My lord, item 7 of court number 21.
Huh?
My lord, this matter kindly be taken tomorrow, my lord.
Not.
He is in jail, my lord, bail application.
We do not know whether the CD is here or not. We'll be only burdened.
Motion, my lord, it's a motion.
Only for motion.
Motion.
It's a motion. Yes.
Tomorrow.
Allowed. Motion allowed tomorrow.
My lord.
Code number 21 matter, item number 15.
Ah,
There is some urgency in the matter, let it come up on Friday, Lordship.
okay. You have to move a mention memo here. Only then they will take it up. From that court, if I call the record and then pass an order, I'll be burdened too much. Give a mention memo, we are allowing it for Friday.
Oh. Lordship.
Lordship, I beg to mention a fresh item for listing tomorrow, Lordship.
Tomorrow. Fresh item.
Yes, Lordship.
Bail.
Bail, Lord. Fresh.
May it please, your lordship, I beg to mention item number 32, my lord.
Hmm.
No, on the last occasion, CD was called for, perhaps it is not received, my lord.
Yes.
32. Not charge sheeted.
Not.
Heard Ms. Swensol and counsel appearing for the petitioner. The learned APP submits that the CD is yet to be received. Full stop. List again on
9, my lord.
9th of September. Any interim? No.
No, my lord.
Okay, please, I
Hmm.
mention for item number 42, lordship.
Hmm.
But CD is not there perhaps, and already we have taken a step, lordship, on 14/8/2024.
Pokto.
Service, yes,
Pokso.
service report is not there.
You wait. Huh? Any service report available?
It is not.
Not receive any service.
First that after motion, my lord.
Mr. Swensol learned counsel appears for the petitioner. You are Mr. S. Islam.
Yes, Islam.
The learned APP has submitted that the case diary and report of service of notice on the respondent number 2 is awaited. List again on 10th of September, allowing the learned APP to have the service report and the CD. Any interim?
No, madam.
No. Yes. Yes, sir.
Hello.
My lord. It is notified that court number 21 is not sitting
Huh?
and urgent matters are required to be
True.
mentioned here.
Hmm.
But I have one motion item, item number 19.
Huh?
It has some urgency, my lord. Could it be taken up today, my lord?
Today. We'll try. Give a mention memo, it has to come then.
Might.
You have to give a mention memo.
Might.
May I pray for regular bill application for Monday, my lord, this arms exhibition.
আজি তাতে কোৰ্টখনক খালি কৈ থব ৰেজিষ্ট্ৰিক কৈ থব যে মেনশ্যন মেমো যাব যিকেইটা আজি কাৰণে আছে আজি লিষ্ট পাই দি দিলে হ'ল মোচন হে চিডি কল কৰি হা হা না কোড নম্বৰ 21 মেটাৰ খিনি ঠিক আছে
Item 1.
Please, for it, this is for a POCSO lordship. This is the notice I'll issue and all the city lordship.
application under 483 not looking for PS case number so and so since the matter involves provisions of the POCSO Act. Notice on the respondent number 2 by the prevalent notification. Steps within 2 days.
Lordship.
Call for the case diary list again on
10th of September.
10th of September.
Lordship, this is regular bail application, lordship. In this case, lordship, charge sheet already been laid, lordship.
Hmm.
And subsequently, the victim has been examined, lordship, as a witness, lordship.
Hmm.
So my lord, POXO is their lordship, and in the meantime, lordship, the notice may be, and TCR may be called for lordship.
Application under 483, special case number so and so. Since the provisions of POCSO is involved, notice on the respondent number 2 as per prevalent notification, steps within 2 days. Call for the scan copy of the TCR, list again on 10th of September.
Lordship, deeply obliged, obliged.
I'm giving to you first, please, item 51.
Yes, madam. Item? Item 51 is AB 2006 Majida Khatun. I do not remember sir and madam standing in this case. Huh? This is something to do with GST. Now we would have listened to one of the parties and either accepted or rejected the bill. Huh? Non APS কোন আছে SM মোল্লা অলপ পিছত মাতি দিয়ক
My lord, 51, my lord, I am, my lord.
দিয়ক
51. Oh. My lord, yeah, my lord,
what happened?
I have two notices were given, my lord, by the GST, my lord, under section 35(3), my lord. So lordship may kindly see, my lord, the first notice, page 10, my lord. 10, my lord. They were asked to appear on 17th of August, my lord. On the next page, my lord, below, my lord, failure to attend comply with the terms of this notice can render you liable for arrest under section 35 subsection 5 and 6 of BNSS, my lord. My lord, 3 persons are there, my lord. Number 1 is my mother, 2 is son, my lord, and 3 is daughter-in-law, my lord. There is a, my lord, farm, my lord, in favor of the daughter-in-law, my lord, registered in the name of daughter-in-law, my lord, who deals with, my lord, coals, my lord. There is a registered farm, my lord. I mean, certainly, my lord, on 13/8, my lord, the GST officials, my lord, searched the house of the petitioners, my lord, and also searched the farm office, my lord. Thereafter, seized some documents, my lord. I have annexed the Panchnama, my lord, page 22, my lord. Thereafter, my lord, again on order of seizure, page 23, my lord. And documents seized, my lord, starts from, my lord, 25, my lord.
Only the GST, you appear for the GST, yes, sir? B. Gogoi will appear, but
I have given.
he wants to appear. They are the mother and the mother-in-law and the husband. Yes.
Mother, son, and daughter-in-law, my lord.
Daughter-in-law. One of them has a farm.
My lord.
You have recovered the documents.
My lord, my lord.
Why don't you let them appear? They're apprehending arrest, although you've given a.
After some time.
Huh?
Can it be after some time?
After some time.
My lord, obviously.
52.
Yes.
The only question that Milord was
Section 50.
50 and 50, whether that particular notice was served. My stand is that it was not served because I was in Tihar jail.
And the record show that it was not served upon. Yes. Madam was to clarify whether the notices have been served, number 1. Number 2, whether a production warrant is an arrest warrant.
Yes.
If
So
not,
that is-
under what orders arrested?
Yes, Your Lordship. Now I am coming to the issue that he was arrested on by NIA on 19/7/2023. So he was already under arrest by NIA. And thereafter on production of warrant,
Yeah.
issued by the Special Judge CBI, he was produced and he has been arrested. However, to that effect also, I am coming to, it is their document itself. At page number 20.
20.
20. Though the warrant itself is a ground of arrest. To that effect, judgment is there, latest judgment is there in 2000.
If you have a warrant of arrest from a magistrate, then 48, 47 goes. It is only in cases where you arrest without a warrant, you are required to give the grounds of reason. We are clear on that. Now tell us that there was an order from the magistrate to arrest him,
Yes.
or there is an order, there is a warrant from the magistrate to arrest him.
Yes, it is there.
Where is there?
It is in the CD at page number 97, your lordship. And
Where is the order dated 19/10/2023?
yes.
Is it on record somewhere, sir? 19/10/2023 of the CJM?
97, order is there, your lordship. 19/7 order is here.
No, 1910 is not.
19/7.
7.
And it is in the CD also. I've given a copy yesterday.
1910 order release. Langsai pa pana.
You bring the
1910 order release. Ha? Teka mo yung verbals ito. Tap na to. King ba no? Hindi 1910 do kailan ito.
Kuntu asa CD naman ako.
Tawag ko yung
This is 910. Third paragraph will clearly indicate last one. Accordingly, issue production warrant against the accused person, namely Morantham Anand Singh. And in the first paragraph, second paragraph, that is based on the application filed by the I.
You CBI Manipur.
Yes, your lordship. Who is presently lodged in Tihar Jail Complex, New Delhi, in connection with the FIR so and so. A copy of this order is to be sent to the Honorable Special Judge Mia Patiala House, New Delhi. And it also has the warrant. This is the warrant, your lordship. Warrant, yes. Warrant is issued. Chief Judicial Magistrate, Kamrup, Gauhati. And to that effect, your lordship, I have the judgment which has been distinguished the.
In view of the
enhanced
prayer of
case.
the IO for shown arrest of the accused is accepted.
My lord, I'm
And
coming
then
to
she has a warrant.
now, this is on pursuance of an production warrant. That is in pursuance of the section 267 of CRPC. And this court has distinguished that my lord will find, I'm handing over.
You are trying to say that a production warrant is different from an
No,
arrest
I'm
warrant.
coming
Yes?
to that. I'm coming to that.
No,
I'm
what is
coming
the
to that.
submission? I have not understood. What does the judgment say?
My S has been distinguished by this court. Now this is on production warrant. On production warrant, I was produced. Hereafter, I was arrested. Now this honorable, even I'm arrested, it is a fresh arrest where ground of arrest is to be given.
No. If the magistrate says that I am allowing the arrest and this is an arrest warrant given so that you can arrest him, then you don't.
My lord, if your lordship kindly appreciate, I'm just handing over a decision of this honorable court.
So we are here to appreciate whatever we can. Okay.
This is an order dated 27/1/2026 passed by this honorable court. My lord, I respectfully take my lord to para 25. That my lord will find in page 6, para 25. Para 25. Copy extra layer. 27 1 1 2020. This is regarding
Yes, in my case it's, it was, I was there, no? There. It is left,
Yes. Done. We understood.
that ground of arrest is, and another, judgment is given.
Ground of arrest.
There was cause in relevance, even in that case.
तो वाइफ को बताया गया है ना।
And I feel because.
There are 10.
Goes on. Coming back to the 20%, this one is to 5 years eventually another case. These are press errors. And then, therefore, compliance with 22.
We do not know whether, was this also on on a warrant of arrest?
Yes. Because he was.
They have a warrant of arrest.
Arrest of warrant will, I can understand that. Now, arrest of warrant, even then it's an arrest, it becomes a fresh.
So therefore, the other judgment will be there, not this one.
That
They
is
have
what-
not arrested you on the basis of a production warrant when you were produced by VC and we arrest you. That is not the case here. In this particular case, Arun Sharma, the court has differentiated between production warrant and warrant of arrest. What we had been saying from day before yesterday or yesterday. So this clarifies our issue. They are different. Now, even on arrest by a under a warrant of arrest, still the grounds of arrest are required to be supplied. 50 is to
It
be
has been
given.
given page number 20.
Page
Their
number
petition, of their petition,
20.
20,
This is an arrest memo.
yes. And his wife has also been.
No, where have you given the grounds?
Because the warrant itself is a ground of arrest. It is given in the judgment.
Where is the warrant given to him? If you say the warrant is the ground of arrest,
Yes,
have
sir.
you given him the warrant that this is why we are arresting you?
So that
We'll
is,
come back to you. I'm just raising the question. You have your answer ready. He's continuing. Have the answer ready.
because at that point of time, there is an order of the court while arresting. So that is reflected in the TCR, your lordship.
Yes,
Then
sir. Yes.
we need some time to get the copies.
I was in Tihar, sir. I was in Tihar, sir.
No doubt.
Now, when it was given when it served, I have no knowledge about it. But right now, they said it warrant under in process of arrest, warrant of arrest, I was arrested. Now, the question is, even though this is under warrant of arrest, my humble submission is that the ground is to be given. That is what our Honorable High Court also has said. Because the ground of arrest, so that I can seek the legal remedy.
Ready, Burwa?
In clause number 5, it has been said that the name and the particular of the person informed about the arrest.
Page
the
number
accused and his wife.
4 লেখে 1 to 4 মুখ photocopy করে এখানে ঘুরাই দিও হ্যাঁ
His wife has been given the information, her phone number is there, everything is there. Not see.
Even the warrant of, even in custody case, even the warrant of arrest is given. Well, I can, but the ground, it has to be accompanied by the grounds of arrest. Simply, because I'm already in judicial custody. I'm already in judicial custody through a production when I was produced before the court. Then the formal arrest was allowed, but still then I have to supply with the grounds of arrest because.
No, that we have understood, sir. Your argument that you must be given the grounds of arrest even when you are arrested on the basis of an warrant of arrest, because otherwise Article 22 will be violated. Although Section 50 and 50 of the CRPC may not require it, BNS 47, 48 may not require it, still to comply 22(1), even under a warrant of arrest, you must be supplied the ground of arrest is your case.
Yes,
Yes?
yes, in view of
This is
Article
the judgment
20.
you are
Yes.
relying upon.
Yes,
Yes.
I am also coming to the Kasi Reddy case, your lordship. It has been, the Sahina case, pehle dijiye. Before that, Sahina, who has relied Kasi Reddy case, at page number from 14, we have given the
Judgment ko likha hai, sir.
PDF lordship. We have arranged and page number has been given. Wherein Pankaj Bansal's case has also been distinguished very clearly. Last one.
You are going for Sahina.
Sahina.
No number.
Paragraph 14, page number 13.
Yes.
Merged hole 300 ho gaye. Separately diya. We have given separately of lordship and merged one.
Page number, para number
14.
14.
Para 40.
What does it say?
I'll go through. In Pankaj Bansal's case, a bench of the Supreme Court has observed that we hold that it would be necessary henceforth that a copy of such written ground for arrest is furnished to the arrested person as a matter of course and without exception. However, paragraph 15. However, in the decision in Bihan Kumar's coordinate bench of the Supreme Court clarified that the Article 22(1) of the Constitution of India does not stipulate informing the ground for arrest in writing, and went on to observe that what was stated in the decision in Pankaj Bansal case were only a suggestion that merit consideration. The following observation from Bihan Kumar are bail application number so and so. We have already referred to what is held in paragraph number 42, 43 of the decision. In the case of Pankaj Bansal, this court has suggested that the proper and the ideal course of communicating the ground of arrest is to provide a ground of arrest in writing. Obviously, before a police officer communicates the ground of arrest have to be formulated. Therefore, there is no harm if the ground of arrest are communicated in writing. Although there is no requirement to communicate the ground of arrest in writing, what is stated in paragraph number 42 and 43 of the decision in the case of Pankaj Bansal are suggested that the merit consideration, we are aware that in every case, it may not be practicable to implement what is suggested. If the course as suggested is followed, the controversy about the non-compliance will not arise at all. The police have to balance the right of a person arrested with the interest of the society. Therefore, the police should always scrupulously comply with the requirement of Article 22, para 16. Indubitably, the above decision of the Supreme Court proceed on two different lines. The difficulty lies in the question as to which this decision should be High Court follow, especially in the light of the principle that even an obiter dictum for the Supreme Court is binding on the High Courts. 17. While confronting the situation where divergent views are rendered by the Supreme Court benches of co-equal strength of bail number so and so, the optional available with the High Court are, if there are two irreconcilable decisions.
Madam, just tell us the crux of it. We can read the judgment, the
Then-
pages and pages.
19,
Criminal code, huh?
paragraph 19.
What does it say?
Viewed in the backdrop of the above principle of the precedent, it is evident that since the decision of Bihan Kumar considered the decision in Pankaj Bansal and Praveer Purkastra and clarified that the communicating the ground for arrest need not necessarily be in writing, though would be advisable. The said ratio become binding on the high bail application. High Court bail application here. Case number so and so. Now in para 20 from fourth line. K.C. Reddy, Upendra Reddy versus Andhra Pradesh, so and so, the Supreme Court clarified that the ground of arrest in respect of a person arrested on warrant is not required to be furnished to him separately. It was also observed that the ground of arrest must be communicated not only to the arrestee but also to the family member. This has been done. That apart, we have also given the.
How
other
do you,
memo. And
how do you convince the court that the grounds of arrest had been communicated verbally?
Yes, because over phone, and when he was.
What did
when
you
he
say
was
over,
arrested
what did you say over phone?
To his wife.
What did you say? Where is the transcript?
Then I will have to. bring the
Therefore-
set phone.
therefore-
It is there, we have preserved it in the. DVR.
Therefore, it is a common concept that it is, the burden is on the prosecution to show when the ground is taken, that the grounds were communicated. The best way to do is grounds in writing.
We can give the WhatsApp.
Now, if we go to, which one, Mihir Rajesh, where Justice Singh had given that part where it has to be communicated to the family members in writing. How do you overcome that with a judgment from the
To family member,
Ernakulam?
to his family, it is.
So what has been given to his family member? Kindly show us that. This has been given to the family member. You have filed your objection.
Yes, your lord.
You have your documents with you. Kindly show us, madam.
We have to bring the we have to give the printout from the DVR WhatsApp message is there. We have to take out the
What's
call to
sending the
them.
grounds
Yeah.
of arrest by WhatsApp is not sufficient, is what?
Her phone and the message has been preserved also, your lordship. Her phone number is there. I have given in the my objection also on affidavit.
We will again take up the matter at 2. Unless you can show us that the grounds of arrest has been conveyed both to the arrested person and to the family members, that these were the grounds which we had communicated. Taking this round and round is not helping any one of us.
In short span of time, how I will get the certified copy from the.
A man is behind the bars. You show us from the records, whatever you are carrying, the grounds were given by you. Is it not?
Because warrant,
Grounds were given by you.
we have informed.
You
over phone.
have not given the grounds. You are trying to use the word I have informed. Informed about the arrest or informed about the grounds of arrest?
But it is not mandated because it has been clarified.
You have
in
not
the-
answered my question, madam. Have you informed about the arrest? Have you informed about the grounds of arrest? That statement you don't want to make.
Because
You will not make that statement whether it was the intimation of the arrest or intimation of the grounds of arrest.
that is in our objection we have given.
Yes, read out that objection.
Mới objection này đi vào mới counter mới counter. Counter mới phải
Should I help you with paragraph 18?
18.
Ah.
18.
That is the paragraph you are looking for.
Yesterday also I did it.
Please go ahead.
With regard to the averment so and so,
Mm.
provision under section so and so were not complied with as the ground of arrest were not furnished to the petitioner. And this also violate it is their contention under Article 22. The accused petitioner himself admitted in his petition that on 19/10/23, the learned Chief Judicial Magistrate allowed for effecting an arrest of the petitioner and pursuant to which the petitioner was informed that he had been arrested in the instant case. So this order is there in the lower court records on the date of arrest.
19/10/2026.
This order-
2023. 1910, yes. You have a certified copy of that order, and I have taken a photocopy of that order.
certified and nine.
I have given it back to you, if I am not wrong. ঘুরাই দিলে certified copy to আমার photocopy to রাখিছে
Again, there is two order, 1910 and
Yes,
2010.
1910.
2010.
1910/2023
Yes.
has allowed the arrest.
Yes.
So 23 I am not concerned with as of now. 19.3 is the order. Now tell us what is the 19.3 order. If you want to argue it separately, then argue it separately.
But
Para 18, we were at para 18, let us continue.
allowed for
Ek-
effecting the arrest of the petitioner and pursuant to which the petitioner was informed that he had been arrested in the instant case, section 50.
Just, we'll wait for a moment there, madam. The petitioner was informed that he had been arrested in that case. Yes? So the grounds of arrest not there. The information that you are arrested in connection with so and so case is there. Okay, then
Section 50 CRPC
Ah.
read that every police officer of the person arresting any person without warrant shall forthwith communicate to him full particulars of the offense for which he is arrested or the ground of such arrest.
Ah.
The arrest was made in pursuance of the order of the honorable court, and that the ground of arrest has been duly intimated to him that he was being arrested in the instant case.
yes, we'll wait here for 1 minute. Just give me 1 minute. The prosecution's argument that the communication of grounds of arrest are unnecessary because the arrest was pursuant to a warrant or a judicial order is fundamentally flawed. That is what this court has said in bail application 144 of 2025 by
That
the
is
order dated.
The production warrant.
No. Now, a warrant or production order merely authorizes physical custody of the accused. It does not communicate the accused why his liberty is being curtailed. Article 22(1) does not distinguish between arrest with a warrant or arrest without a warrant.
But Article 22
Will you-
also said that the writing is
can I go beyond this?
But above that Supreme Court judgment is.
Where
also-
is it?
That is Kessi Reddy, your lordship.
Kessi Reddy says what? Again, please let us read it.
Then
For
I-
this reason, Honorable Supreme Court in Kassi Reddy, Upendra Reddy.
Analyzed 22.
Now, one more sentence. For this reason, Honorable Supreme Court in Kassi Reddy held that custodial arrest requires stricter, not diluted compliance of 22(1). This is what this court has interpreted from Kassi Reddy Upendra Reddy.
But the
Wrong, it
parity.
may be wrong, it may be wrong, it may be wrong, it may be wrong according to you. According to us, we are bound.
Finding it wrong, but the parity won't apply to all the
The
cases.
concept of showing arrest is a legal fiction. Constitutional protection attaches to the substance of deprivation of liberty, not to the terminology applied. Have you gone through this order?
Yes, that is, I was there in that case.
No, you were not there in this case.
Maybe that is a different one. Because I am totally relying on the Supreme Court's lordship case. This,
Kassi Reddy case,
yes, your
which
lordship.
has been interpreted in a certain manner by a coordinate bench.
It has been also, that is up to the lordship how it will be interpreted. But looking to the background of this case. And this, because UAPA Act is also.
You may have all the reasons to arrest him once we say that the arrest and further detention is wrong because the arrest part is wrong. You are at liberty to arrest him again, following the due process of law. That has not been curtailed by the Honorable Supreme Court. In fact, it has been very specifically stated. Give him the correct grounds and re-arrest him. That you do not do.
This honorable.
That you do not do. You try to prove a wrong arrest to be right.
But even Article 22 does not say that the writing is mandatory. That has to be also appreciated, which has been distinguished in the Sahina's case also.
Sahina is something that the some other high court has understood in a particular manner. It will be persuasive.
Persuasive.
What
but
we have in this high court,
but
that will be
Kessi
binding.
Reddy has also distinguished taking into account.
So
the-
your ground is that once there is a warrant of arrest, 50 need not be complied with, 50 need not be complied with.
Because it says that warrant itself is a ground of arrest. It
Okay.
has been clearly said. And that.
Did you give him the ground of, did you give him the warrant?
Yes, definitely.
Where?
By the court's order.
Where?
Because he was already,
He was in Delhi.
we have to give.
He was in Delhi appearing through VC.
No, jail superintendent. It
Ah.
has to be executed through jail superintendent.
Did you send it
So,
to him?
Yes. In the,
1910.
is in the.
1910 order, and the jail superintendent tells you I have given a copy to him.
It is there.
Again.
All in handwriting it is there, your lordship. Unless and until it will be executed, how he will be brought through VCR? That is also the question.
Through VC.
VCR, no, through VC, yes.
Through VC he was brought because the court had informed that you
Yes.
please produce him.
That is why. And
That you-
he's been informed about all this. And we need to have another order of the honorable court, reason being trial court, because here it is next date is not given. One order sheet is there. And while arresting your lordship, which I have, with my little knowledge, I have seen in other cases, the magistrate has written there that whether you have the complaint, you have been arrested, whether you have been informed. It is written specifically in Arun Kundam's case, same CBI matter, Manipur matter, and Kiran Mehtai's case. We have brought this order
You say
sheet.
the next date is not given on 1910, the next date is fixed on 30th of
Order sheets are also there.
30th of October 2023 for production through VC again.
So here it is written, received the accused Morang Tham as Anand Singh and police custody remand of CBI along with one warrant issued by the court of
Who
CGS.
has received it?
It is there.
Ha,
Their superintendent Tihar jail.
I am not being able to convey my question. He received the warrant. The accused received the warrant, understanding why he was put under arrest. Is it there? It is not there.
So what, these are the procedures we followed.
We send a notice from here to some place. That officer does not serve it to the particular relative or family. We say the notice is not complete.
No, his family has been, his wife has been.
In this case, he has not been
Detail is
given.
there.
In this case, he has not been given.
In this case, he has been informed. All detail is there. I can ready to produce your lordship.
When? 2 months? 1 month?
Never thought.
20
that would
days?
be-
What?
We have to obtain the call detail. It has been informed your lordship.
Anything else?
But looking to the gravity of the case, and
Yes.
we have already informed, and it is already day to day. steps
Your,
are
your,
being-
your stand is you have informed.
Yes.
Now tell us the full sentence. You have informed the petitioner what and the family what? The fact of his arrest, the intimation of his arrest, or the grounds of his arrest? For your records. We will not put it in your mouth. We will ask you to have it from the records. Was the intimation given of the arrest or was the ground of arrest intimated?
Let me have the order sheet, day-to-day order sheet. of
The
it.
court order would not reflect what you have given. It is your client who has to tell you.
When he was produced before the magistrate, either by virtually or physically, every magistrate used to inform that, look here, you are arrested, whether you have anything to say. It is the magistrate, because magistrate has issued the warrant,
It would
and
be,
the magistrate has to inform.
it will be to your peril if the magistrate has not recorded any such thing and the person continues behind bar despite the arrest being wrong. Someone would be responsible. Someone somewhere who has to be responsible for an illegal detention.
For all intent and purposes, this is not illegal arrest. Reason being, we have informed day-to-day noting is also there, file noting is also there. Supreme Court judgment also says that the warrant.
Did you
itself is
inform
enough.
him about the arrest or about the grounds of arrest? One sentence we want from. You want some time to find out? They can go through the CDR and tell us. We will trust you on that.
I will have to obtain I have no alternative than to obtain the certified copy of lords,
Of what?
PCR, trial court's record. Because it is the magistrate who used to inform, whatever in my little experience I have seen.
Now the
Other cases,
magistrate has to inform the grounds of arrest, yes? According to you? That is what you said.
magistrate has also that you are arrested in this case and you are informed whether you have anything to say. It is written, I have seen in other case also, your lordship. And since warrant is issued, it is in the hand of the IO. That is a ground itself, and to that effect, Supreme Court has already clarified, your lordship.
We'll
There is a
pass our
category
orders.
says I have given.
We will pass our orders. You'll have it at 4 o'clock. Disposed. When you go round and round, you do not give the correct answer, we cannot give you so many answers.
Slightly technical deviation is not going to affect the case, lordship, looking to the gravity of the case.
এইটো ৰেকৰ্ডিংটো থাকিব নহয় হেৰিটো মই গোটেইখিনি চেণ্টেঞ্চ লিখিব লাগিব পাৰ চেণ্টেঞ্চ লিখিব লাগিব আছেতো all the three are on the same grounds.
No, no,
No.
Now what
Because
is the
there is a
other?
different case.
there is a difference.
Okay, so this is 52 disposed.
So for 53 and 54 is confirmed. The arrest was on 15/7/2023, before Pankaj Bansal came into effect. Let me concede here very fairly.
Okay.
But in this particular case also, right or wrong, the ground of arrest was not communicated. That hits Article 22 of Constitution of India. But as Pankaj Bansal has said, is specifically, I'll consider that henceforth. I'm on that. Now, whether that Article 22 will still apply, even if that was before Pankaj Bansal, that is, I leave it to the wisdom of Honorable Court. I don't need to argue on that point because I have to be very fair enough. Now, my only humble submission, so for this matters, what the matters are concerned, their involvement, just the allegation is very serious. It's 302 under UAP also. Now, how I'm attracted under 302 in UAP, that evidence will show. Apart from that, we have to go to the merit of the case. Now, already charge sheet has been filed in these matters.
When?
And I have been behind the bar for the last 3 years. But there's no progress in the case, and it is still in the stage of framing of charge.
Charge sheet filed when, sir? In this case, madam, when was the charge sheet filed?
Charge sheet was filed within 90 days.
Huh?
7/12, first charge sheet,
7/12/2023.
23.
No,
Arrested on 14?
15/7/2002. I was present on
15/7/2023, you were arrested. In both the cases?
In both the cases.
Charge sheet was filed on 7/12/2023. Thereafter, another charge sheet filed?
Another charge sheet.
Huh, when? say, পঠিয়াই দিয়ক, scan copy to side him. We'll call for it.
Add to lordship.
We do not know, it will reach on its turn.
Oh, that's right. That's right.
Item number 60 কিমান ক'লে? নহয় নহয়, তেওঁ কিমান কৈছিলে? 68, সেইটো TCR টো অহাৰ পিছত মাতিব, হ'ব? Yes.
51 item number. my lord.
Tell us.
My lord, I have, lordship has seen, my lord, notice, but each of the petitioner, two notices were issued, my lord. But they failed to comply, my lord, because, my lord, of that, my lord,
Here.
charge has been made, my lord.
Huh?
A charge seizure has been made, my lord, by the GST, my lord. And all the documents and mobile phones have been seized, my lord. Now again, my lord, they send notices.
This was prior to the notices or after the notices?
Prior to the notices, charge was made, my lord.
Prior to the notice, search was made.
Made.
You were present at the time of search.
One accused petitioner is present, my lord. Mansur Alam was present, my lord.
Present, he was not arrested.
Not
Why
arrested.
do you fear?
But again, my lord, they have sent notices, my lord, under section 67.
They want to talk to you. They cannot do it over the phone. They have to call you for under a notice.
67 to again, they want to make.
You want to arrest him?
No, Lordship, first there has to be a formulation of reason to believe to arrest him. And it has to be communicated as per the statute and the Supreme Court decision.
Yes.
Then only we can go ahead. And here, Lordship, page 21, last, just about
After that formulation, do you inform them that we have formulated it now?
Yes, sir. That has to be communicated. The authority
then.
cannot.
Come then.
Applicate.
My lord,
We'll record his statement that without formulation and supplying a copy of the order of the commissioner upon you,
As
they will
witness
not arrest you. That is what he submits. Therefore, this anticipatory bail petition is not required. You go and you appear.
And Lordship, page 21, last paragraph. He has failed to attend it.
my lord,
Failure.
that's the fear, my lord, of my arrest, my lord, because in the notices, my lord,
He was just called for
your lord, you may
investigation.
kindly see, my lord, page 11, my lord. Page 11, my lord, the last bottom part, my lord. Failure to attend, comply with the terms of the notice can render you liable for arrest, my lord. And my lord,
When were you required to appear?
because of, my lord, I have failed the, my lord.
When were you required to appear? Date?
Date was, my lord, it was
21st of August.
August, my lord.
You come to this court on
My lord, I have filed this application on
24th of August.
And I did not appear, my lord, because of fear, my lord, because they may arrest, my lord. And my lord, section 132, my lord, 5,
First, he
subsection
was
5, my
asked to
lord.
appear on 17. Thereafter, again, notice was issued on 21st.
21st, my lord. Two notices were issued, my lord. Lady is there, my lord, two lady, my lord. Kindly protect me for some limited time, my lord. We will appear, my lord. And if anything come, my lord, your lordship may reject it, my lord.
We can let them appear. You
My
find out whether you propose to arrest them.
My lord,
And then in the meantime, they'll appear
my lord.
before you
7 days or 10 days.
under some protection.
Lordship, I'm just relying upon the apex court decision
See?
recently given. Lordship,
No protection.
issuance of notice doesn't amount to that apprehension of for
We
coming
understand.
for pre.
That we understand.
And
that we
Lordship, there
understand.
has to be a communication as per section 69 of the CGST Act.
Then we'll record that and say that since then communication has not been made.
Yes.
And arrest will not be done on the date of communication. They appear, you give them the communication and arrest them, what remains? They'll be trapped.
Yes, Lordship, because apex court has stated that only after communication, they can challenge that reason to believe also. And they can come for free as well. Only after communication,
How much time after communication?
no time period.
Then it can be a half
It's
an
not
hour.
in the apex court, Lordship.
Where is it?
From
para?
Paragraph 13 onwards, Lordship, we have to see. Basically, paragraph 17 and 20. 17 and 20, Lordship. 17, 18 and 20.
নেক্সট যেটা কেস হইব এটা প্রডিউস কৰিলে হ'ল এতিয়া এতিয়াৰ ৰিটাৰ্ণ কৰিব নালাগে। So ডিসপোজ হৈ যোৱাৰ পিছত চিঠিখন ৰাখি কি কৰিব? Supreme Court says you have to intimate the grounds of the reasons to believe, the grounds to believe. That you have to intimate by email or by phone. Grounds have not been intimated to them till now. Therefore, we will ask them to appear before you on or before the 10th of September. Till 10th of September, we protect them.
Right.
Yes?
I leave it
That
to
they
it.
would not be, because in the absence of the grounds of arrest, they cannot be arrested prior to 10th of September 2026, because now we have to.
No.
In case they receive the grounds of arrest prior to 10th of September 2026, they'll be at liberty to come back to this court.
That liberty lordship, anytime they can come.
Huh.
But lordship.
What we, once a man is before us, once someone is before us, once two ladies are before us, in fact, we do not want a situation where they go and appear before you, something is handed over to them, they are taken into custody. That is what we want to avoid.
Lordship is just at the preliminary stage. It's at the just nascent stage because search and seizure was made.
We understand from your submissions that you are not in a mood to arrest them. Then why resist the protection? And if you want to arrest them, if you think that their arrest is necessary, tell us so. We will consider it on merits, whether the arrest is necessary.
Necessity lordship, that only the, because today only first day of lordship, that instruction I will have to.
Because what, the thing is simple. If the arrest is necessary, we'll consider on merits whether the pre-arrest bail can be granted or not. If it is that we are not in a mood to arrest them, we need to know. They can go and appear. You can let them go. If it is that after their appearance, we'll decide whether to arrest them or not. We'll allow the communication of the grounds. They'll have their own remedies. But it cannot be that no, now I'm not in the mood. Suddenly on their appearance, I come in the mood.
Because
That should not be the procedure.
Whatever the pleading is there.
That stop the pre-arrest, stop the interim and then arrest them. That should not be the procedure.
Lordship-
Arrest them or don't arrest them.
Lordship, whatever pleading has been made,
Hmm.
lordship, from there, I cannot say how much.
We'll let you have your instructions. We'll have it on Friday.
Yes, lordship.
If they can go and appear, if you just want to want information from them, we'll record so. And on the other notice, that 69 or whatever notice, once it comes,
And that they will.
challenge as and when, but now for them, we'll allow them to appear then. And if you think that their arrest will be necessary, communicate the grounds. We'll say that you go and challenge them. And then pray for a anticipatory bill. Yes? On Friday, can we have
Yes.
it?
Friday.
We'll have it on Friday.
Till then, protected.
No, you remained from 17th of August to 28th of August. No, today is
6, my lord.
6th of August without protection. Tomorrow and day after you can manage.
My lord, kindly see, my lord. 2 notices were issued, my lord. Kindly, my lord, have a look, my lord.
Mr. Counsel,
My lord.
we are at the 6th item for the day. Yes? Number 1. Number 2. We have told him our mind, what we were proposed to do. Number 3. We initially told you what we had in mind. This is an official request for you to go and appear. You sleep over it. We are not happy. Clear? We cannot allow them to give you notices and then allow people to sleep at home. Come back after the date has gone, saying that I am now afraid. You are required to be afraid. Student does not prepare for his exam. He fails. He fails. Yes?
My lord,
You had the opportunity to appear twice. You did not. Appear.
because of, my lord,
Next.
arrest, my lord.
Day after tomorrow.
Oblige.
You can do.
I I the matter may pass up for the timing, Lordship.
Why?
My senior is on less than another court, Lordship. After some time, Lordship.
There's something.
P6. P6. P6.
Well, this case involves 105, so case diary may be called for.
Hmm?
105 is there, so CD may be called.
Call for the case diary list again on
9th.
9th. উপর খালি এখানে লিখিব, হ্যাঁ? Yes,
9th.
9th of September.
Highly obliged.
So maybe item 3.
Mate, this is your Lordship.
Hmm.
Lordship, this is a PRS mail application, FIR and cross FIR is there, Lordship. We lost the FIR first, thereafter they lost the FIR, Lordship. Their FIR, Lordship, will find on page 13, Lordship.
Hmm.
And our FIR on page 21, Lordship.
When?
Lordship, may I pray, Lordship, what happened? All the sections are except, Lordship, 118(2). It is a non-bailable, others are bailable, Lordship. Now, allegation that in the FIR, Lordship, one Noor Islam got injury, Lordship, grievous injury. But in the rejection order, Lordship will find on page 26 and relevant portion on page 28, para 12.
Hmm.
With blunt.
Yeah.
Then 326 will not come, Lordship. 118. Earlier
Hmm?
326, now 180. Now it will come under 117(2), Lordship.
Yes.
As per the order,
FIR of
FIR that is on page 13, Lordship.
16/6/2026. 14/6, yes,
14/6.
page 13.
Yes, Lordship.
16/6, you have not arrested them. Last 2 months.
As per the order, not comfortable with
Heard Mr. B. Chaudhary, learned counsel appearing for the petition. Also heard the learned APP. This is an application under so and so, so and so. The learned counsel for the petitioner submits that the FIR had been lodged on 14/6/2026, alleging that the victim had been assaulted with sharp weapons over their head, hand and chest, etc., with threats to kill, full stop. The learned counsel has then drawn attention of this court to the order passed by the learned additional session judge FTC, Lakhimpur, where at paragraph 12, it has been recorded that the injuries have been caused by blunt weapons, full stop. Call for the case diary list again on 18th of September 2026. No, 22nd of September 2026, full stop. In the meantime, the petitioner shall appear before the investigating officer to participate and cooperate. In the event of their arrest prior to the next date of listing, the petitioner shall be released on bail on furnishing a bond of rupees 5,000 each to the satisfaction of the investigating officer.
highly obliged.
Tempo. Tempo.
Application 482. Rotabari PS case number so and so. Matter involves the provisions of POCSO Act.
My lord, yes, another thing, my lord, here in this case was filed in 16/1/2025, my lord.
Uh-huh.
And till date, my lord, charge sheet of
The-
final form has not,
the
1.5
provisions-
years has been passed.
The
my lord.
provisions of POCSO Act being involved, comma, issue notice to the respondent number 2 in accordance with the prevalent notification, steps within 2 days. Call for the case diary, list again on 11th of September 2026, along with the service report and CD.
My lord, as there is 1.5 years left, my lord, so on that basis, my lord,
In a
praying
POCSO
for-
matter, madam, when we are convinced that no offense is being made out, it is only then we consider something in the absence of the informant or the victim.
Obliged, my lord.
11. May it please your lordship.
Ah,
Lordship created bail application lordship. Allegation is this lordship, one Hanif Ali, who is brother-in-law of the informant lordship, took his wife to Rangamati Hill on the pretext of cutting wood and killed her and concealed her body lordship. That prime accused is not the petitioner hearing.
first correct your translated version of the FIR. You have given us half the translation.
Particular maybe.
Huh?
Yes,
I
Lord.
find it difficult to read that twisted turns.
Sin lordship.
No. When you say it is a certified true copy, you give us a certified true copy. Page 9. Last line. Therefore, it is prayed that your honor would be pleased to number 2 Mongol SK. We don't know what was thereafter. We don't know who is number 1.
Number one particular maybe sin lordship.
Learned counsel for the petitioner is given opportunity till 28th of August to file an additional affidavit bringing on record the corrected translated version of the FIR. Day after tomorrow,
Lordship.
list again on 28/8/2026.
But that
Yes,
affidavit
sir.
of arrest, have shown arrest on 10/6, I've brought into record.
Uh-huh.
You have directed me to file the affidavit with order sheet showing arrest 10/6. That is in the record.
I forgot, sir, what happened that day.
Oh.
Well, what was the matter about?
My lord, what happened? Petitioner was initially arrested on 29/5/26. He is a local journalist, my lord,
Journalist.
a journalist, and honorable, since he has
Several FIRs against him. Now these POCSO matters are popping up.
court has granted bail, then when he was trying to give the bail bond, that he was shown arrested, my lord, on that day, on 10/6.
It involves POCSO, does it not?
A FOXO, that is filed after 3 years.
But yet, when there is POCSO, sir, we have to await the service of notice on the respondent number 2.
But when, my lord, there is no explanation. The 3 years she has came from Dehradun, that now I came to know that he is inside the jail.
It can be read in 2 ways. Once she was sleeping.
Yes.
Second, you were the threat, she could not come back. We'll have to find out which.
My lord, your lordship asked for this order sheet, my lord.
There is a notification, sir, which says that we must issue notice.
But that is true,
Yeah.
no doubt, my lord. But question is that whether this arrest was legal.
Once the person is arrested, in another case, she mentioned that she has the courage to come and.
Whether the shown arrest part is correct. Without a warrant, it has been done.
Yes.
It has been done without a warrant that shown arrest. Now, what about 48? What about 47?
Record.
Without a warrant. 47, 48.
Well, 10/6
Tell us.
order may kindly peruse, my lord, 10/6 order.
If there is a violation of 47, 48, anything else applies? 22(1). 37 of the NDPS does not apply.
No ground was
Yeah.
shown arrest given.
That is there, but without verifying the record,
Hmm?
without verifying the record, it is difficult for us.
Additional public prosecutor to have his instructions on the matter. That is the last order.
No, yes, but
It was fixed on that today, my lord, because to take the instruction. My lord, I referred the apex court judgment.
Sir, we are tackling the matter.
After
Yes.
some time,
Huh?
MP Goswami has appeared on that demand, maybe.
After some time.
After some time.
Only on that ground, when you are shown arrested, whether you are required to give
Yes.
47, 48 month. And our earlier order passed in similar cases? That will help us.
Yes,
If you
well, I
can
have seen
collect that also.
A long argument was there actually.
Give us that order when you are not giving us. that. Yes,
Your lordship may take up item number 62 and 63 also, madam. Same FIR. Yesterday matter, today your
we'll take it up after some time. Let us finish some matter.
Madam,
Huh? At 2.
at 2
We'll take it up.
of light.
A2, 62, 63. Kindly inform the other side. Other side. At 2. Yes.
Your lordship. So this is in 482 application, your lordship.
Huh?
It's a 482 application in connection with Nagaon PS case 583/26, which is registered
What is
under
the allegation?
FIR is at lordship, page number 13, your lordship.
Page number
13.
13.
Yes, your lordship. May I read that?
7, 8. Huh? Noticing presence of police, so and so managed to flee, search conducted slaughterhouse, slaughter situation in so and so. Kali Mandir. FIR of 782026. Why approaching now?
It is filed on lordship on. It is some defect, lordship, it's come later. your lordship. Filed in 28 hours, your lordship.
The
article C is
the bar,
lordship.
as per the act, there is a bar for slaughtering within 5 kilometer radius, around 600 meters. 31 kg beef was suspected beef is there, and another 3 cow is there. Suspected beef along with your knife, dao, etc. has been seized. As per the
Yeah, along
FIR,
with the live cattle.
along with the livestock.
Which is also suspected also to
Call
be.
for the case diary, উপর হেকিন লিখিব হ্যাঁ heard Mr. So and so, this is an application under so and so, তাৰপিছতে হ'ব call for the case diary, list again on
Nagaon Mallet on
8th of September.
Protection, your lordship.
Huh?
Some protection, I only.
Oh, from August to 7th of August, no protection, you are still safe. 8th. Yes. Yeah, next.
May I please, lordship? Previous bail application, lordship.
Hmm.
FIR page 11, lordship.
Huh?
FIR page 11, lordship.
Huh?
And lordship, accused number 1, Roshan Al-Kabir, he's the husband before your lordship. The informant is the wife.
Roshan Al-Kabir is the husband.
Yes, he's before your lordship. The allegation
General-
only is
General-
that there's solemn.
Just a minute. You mentioned examination. This also mentioned.
He is still the registered marriage, lordship.
Custody not required. Heard Mr. So and so at council appearing for the petition. I also heard so and so. Application under 482. In connection with Lakhipur PS case number so and so. The allegations in the FIR to the extent that the petitioner number 1.
No.
How many petitioners are there?
One, lordship, only one.
That the accused number 1, who is the petitioner herein, had enticed the informant to have physical relationship with the temptation of registering a marriage, full stop. Call for the case diary, list again on 22nd of September 2026. In the meantime, the petitioner shall appear before the investigating officer of the case to participate and cooperate in the investigation. In the event of his arrest before the next date of listing, he shall be released on bail on punishing a bond of rupees 10,000 with one surety of the like amount to the satisfaction of the investigating officer.
Madam.
May it please your lordship. Where's the 3LS bail, my lord? Your lordship will find the FIR at page 8, my lord.
8. Yes.
May I read, my lord? Respectfully begs to state that today on so and so at around 2:45, according to CCTV footage, an unknown person broke into our office located on so and so center and stolen rupees 22 lakh so and so in cash from the cash drawer. Now, my lord, the the IO was asked to investigate the matter.
Ah.
Next page, your lordship will see. With due respect, I would like to state you that you had based on the FIR given by the complainant so and so, I visited the place of occurrence and checked the available CCTV footage.
Ah.
From the footage, it is evident that two marksmen, wrongly marksmen, entered in the account of office so and looted so rupees, my lord.
Hmm.
My lord, those two persons already got arrested, my lord.
Ah.
My lord, I have the order, my lord, and they were released on bail due
Ah.
to some.
Who are you?
I have narrated my fact, my lord. Your lordship will find that
You
page.
can tell us in short,
Page
who are you? Why do you,
I'm a driver, man. I have
they
narrated,
use your vehicle?
not my vehicle. I had handed over the vehicle, man.
Acha.
Page 3, paragraph 5, my lord.
Yes, main accused on bill.
Main accused bail on technical grounds, maybe on, but whether he is associates or not, it has to verify from the face. 22 lakh has been looted,
Hmm.
Lordship, kindly have a look at page 3, my lord, paragraph.
Maybe he is waiting as a driver, he is waiting,
Ladies did.
Two lady and one male person, man.
He is the male person.
No, male person, arrest is Amir Khan, man.
The vehicle has been seized.
Seized, man.
You are the driver of the vehicle,
Yes.
usual driver.
Yes, man. That I have narrated, man. Lordship, have a kindly look at page 3, paragraph 5, man. I had handed over the vehicle and now the vehicle is run by Amir Hussain, who has been arrested.
No. Accused driver has been arrested.
Yes, man.
Then who are you?
But I am the driver. I was the driver up to 14/8/2026. I was a driver.
Of the vehicle.
Then I handed over the vehicle to the owner, my lord. And this.
Yes, sir.
This
The driver who was in charge of the vehicle has been arrested as per the grounds of arrest.
and the
We'll
incident.
allow him to appear. Bring on your report whether he was a party or not.
Right.
You heard Mr. Dotto Koridibo, application so and so. Learned counsel for the petitioner has submitted that the petitioner, who was earlier a driver of the vehicle involved in the offense, allegedly involved in this offense, is apprehending arrest. Full stop. He has submitted that the current driver of the vehicle
Right.
and two other persons involved in the incident had been arrested and were granted bail. Full stop. He accordingly prays for an opportunity to the petitioner to appear before the investigating officer and participate and cooperate in the investigation. Full stop. Learned APP has submitted that the involvement of the present petitioner requires to be investigated into, and granting him a protection at this stage may hamper or tamper with the investigation. Full stop. Having gone through the materials, I am of the considered view that the petitioner can be allowed to participate and cooperate in the investigation during the pendency of this petition. Full stop. Accordingly, the petitioner shall appear before the investigating officer on or before the 3rd of September 2026 to participate in the investigation process. In the event of his arrest, the petitioner shall be released on bail on furnishing a bond of rupees 5,000 to the with one surety of the like amount to the satisfaction of the investigating authority. Full stop. Call for the case diary list again on 23rd of September 2026.
I'm authorized, man.
এখন ঘুরাই দিয়ে দিব। There is another mistake, Mr. Dotto, in the translation.
I have seen.
If you see
No, I
the
have seen,
translation,
I'm sorry, man.
no, the translation has made it funny, not.
Then what marks, man? They have given marks.
এইখন চাওঁচোন আগৰ ফাইলখন বৰুৱা আগৰ ফাইলখন চাওঁচোন।
Instead of marks, man, they have
No,
marked.
this is just for a lighter note. I want. They had said kapur mari, something like beaten up with cloth or something like that. It is said, CCTV footage shows two men being hit in the face. Kapur mari. Mari is hit. Google is not always right.
All right.
Yes, next. Item 10.
Well, it's the only allegation against the applicant in this case is that certain articles that were stolen by some other third party were sold at my business outlet. That is the only allegation. I'll take your lordship straight to the
I
FIR,
also found all
which
the-
is annexed at page number 14 minutes.
What is 18?
Right?
14.
14. The relevant portion is at page number 18. If I may read it out, Millards.
Okay, but someone stole material from the informant's house, 5 lakhs.
Yes, worth
worth.
5 lakhs.
Then what happened?
Then what
These materials
next-
have been found in your shop.
No, Millards. So what happened is that 2 people were arrested by the police, which is not us.
Hmm.
And then during the course of their interrogation, they disclosed that they sold some of those stolen articles to me at my shop. However, Millards, those materials were never recovered from me. They were recovered from someone else's house. And that is also part of the seizure memo. I'll take your lordship to the seizure memo.
Yes, I will allow him to appear for the time being.
Yes, yes.
Maybe Malad sold in his shop and.
Then he sold it to someone. Maybe. And we'll allow him to appear, have his full story.
Yeah.
You are Mr.
Esahul.
Someone
Yes, sir.
helping because of this cycle is going on, Malad. Theft, then sold, then
Resold.
cycle has to run, Malad.
Third Mr. A. Sahul and Council appearing. Baki kini di dibo. The petitioner shall appear before the investigating officer on or before the 7th of September 2026 to participate and cooperate in the investigation process. Full stop. In the event of his arrest, he shall be released on bail on furnishing a bond of rupees 10,000 with one surety of the like amount to the satisfaction of the investigating authority. Call for the CD list again on 23rd of September 2026.
So grateful, Millards. So very good.
May I please, Your Lordship?
Huh?
Page 16 is the FIR, Your Lordship.
Hmm?
Page 16 is the FIR, Your Lordship. Herein the allegation is against one Zuhail Ahmed, Your Lordship. And the name of the petition.
Yes.
He has not been named, Your Lordship, in the FIR. Your Lordship. And the allegation is that the FIR, Zuhail Ahmed, he collected some documents and biometric data of some.
Why are you apprehending arrest?
I am apprehending arrest only because one person, Your Lordship.
Who?
Yes,
The petitioner, Your Lordship, he is a student, Your Lordship.
Ah.
And he used to do part-time job, Your Lordship. And one Akbar Hussain Mondal, the petitioner worked under him and he was arrested in connection with this case. In 15 days, in the second half of June 2026, the petitioner worked under one Akbar Hussain Mondal, Your Lordship. And that man has already been arrested in connection.
Malad, as
with
per
this
the
case.
FIR, Zuhail Ahmed is the main culprit. No, now another person arrested. So that.
That
how
10
he-
has to be traced out.
Yes, but how he is connected with that person and what the role of that person, Malad?
This is your education certificate, yes?
Yes. Presently, Your Lordship, he is pursuing, Your Lordship, postgraduate course as well as B.Ed course, Your Lordship.
Where?
In KK, Your Lordship, and
In
B.Ed
KK,
is-
KK
yes.
Handy,
And
third
B.Ed is-
semester 2025.
and B.Ed is in Calcutta, Your Lordship.
No, this is for 2025. Nothing of 2026. And Baba Saheb Ambedkar, this is of 2024. Yes, when? CD when?
Lordship, in the meantime, since his name is not there, Your Lordship, why?
Sonitpur, Malad,
The change. Quickly.
Malad. Third.
3rd of September. And bring some updated educational certificates. 2024 is not helping you now. Hmm.
57.
May please.
Yes,
But
yes, sir.
pre-arrest bail, my lord. Lordship may kindly have a look, my lord, at page 17, my lord.
17.
My lord.
Huh?
Kindly see, my lord, the reference, my lord. Auli PS GD number so and so, dated 17/5/26, my lord. So earlier I approached this court, my lord. Now lordship have a look at page 25 for a once, my lord.
Yes.
My lord, first paragraph, my lord. The learned APP submits that the charge sheet by CS number so and so,
Yes.
dated 13/5 has been submitted, my
Hmm.
lord. We inquired, my lord, no charge sheet is late. Because the FIR is of, my lord, 27/05/26 and the charge sheet is dated 13/05/26, my lord. But some mistake maybe on the part of the.
Maybe, my lord.
So
Huh?
at this stage, well, I am just.
You are not yet arrested.
Not yet, on diary, my lord.
Huh?
At this stage, diary may be called. Second bail application. But some mistake on their part, my lord.
Maybe.
Yes, can you verify it by Friday or something?
My lord, obviously, this is the notice,
Huh?
date is not.
Date is wrong.
Wrong.
Date is apparently wrong or the number is wrong.
It's an NDPS case.
When?
Any only diary, my lord. I'm
Call
not
for the
saying-
case diary list again on.
8.
Huh?
ঠিক আছে।
8 of no.
8th of September.
I'm obliged.
Your lordship.
Yes, sir.
Well, the FIR, your lordship will find, my lord, at page 20, my lord.
20.
In fact, my lord, your lordship may like to read the, my lord,
18.
typed copy at 20,
Yes.
28, my lord. It's a long FIR, my lord. The main allegation is that, my lord, the petitioner of your lordship, he's a, my lord, real estate agent. And the complainant informant, my lord, he is a politician of Arunachal Pradesh. And my lord, he had some business dealings. And eventually, my lord, he paid about 10 crores of rupees to the, my lord, to the, my lord, petitioner. And that money he has not returned. And my lord, the allegation is also that, my lord, there is a conspiracy in this matter of taking money of the entire family of the, my lord, petitioner. If your lordship finds, my lord, page 20, paragraph 1, my lord, he states that last but I had invested about rupees 10 crore towards several properties in various projects in Gauhati. Then, my lord, he has alleged that the petitioner has shown him various properties. Eventually, my lord, he did not, he gave some documents which were not genuine. And he had also shown the account number where the transaction has taken place. And I'd like to draw your lordship's attention to, my lord, one paragraph, one sentence at page 22. Last third paragraph, my lord, may I read it? I request that a case is registered immediately investigating into an exemplary action taken against him and his family so as to send the right message across the region and justice is done apart from helping me recover my hard-earned money. So, my lord, the transactions had taken place in 2022. That your lordship will find, my lord. Next page. Next page, my lord, the question was put to him. Question number 2. When did you have first transaction with Mr. Saurabh Kumar Jha? Saurabh is the, my lord, petitioner. Answer is, though I was in touch with Mr. Saurabh Kumar Jha, I have my first financial transaction in 2022 during the month of August, which is on record and have duly furnished a copy of the transaction. Now, my lord, the period of limitation for recovery of that money has expired. And that is the reason, my lord, this FIR has been.
But you admit today in court on affidavit that you took the money from him.
My lord?
On affidavit, you have admitted that you took the money from him.
My lord, yes, there were transactions.
Now.
There were transactions, well. And that transaction.
Anyway, you need him in custody.
My lord,
It's all transaction
My lord,
through bank.
318, booked in under section 3184.
Ah.
It's maximum up to life, my lord.
Could be, but do you need him in custody is what we're asking you.
My lord.
To find out whether transactions have taken place or not. And whether that money is recoverable money or not, whether it is a suit or what. Huh?
Considering the amount is huge amount, my lord, that is how, my lord. At least, my lord.
Amount will not determine whether the custodial interrogation is necessary. I heard Mr. M.K. Chaudhary, learned senior advocate, assisted by Mr. S. Bothakur, learned counsel, appearing for the petitioner. এখানে দিয়ে দিব 482 Jalukbai PS case number so and so. The learned senior counsel has submitted that the transactions alleged by the informant in the FIR were done through bank as reflected in the FIR itself, and the custodial interrogation of the petitioner for the present would not be required for the police to investigate into the matter. Full stop. The learned APP has submitted that that allowing the petitioner the privilege of an interim protection may hamper or tamper with the investigation. Full stop. I am, however, of the considered view that the petitioner should appear before the investigating officer on or before the 7th of September 2026 to participate and cooperate in the investigation process. In the meantime, in the event of his arrest, he shall be released on bail on furnishing a bond of rupees 20,000 with 2 local sureties of the like amount to the satisfaction of the investigating officer. Full stop. The call for the case diary list again on 23rd of September. Yes.
My objection one.
Oh, yes, I have recorded that already.
Highly obliged, madam.
The interim bill granted shall be reconsidered on receipt of the case diary. 23rd of Dilu. Yes, sir.
May it please, your lordship.
Hmm.
Facility bail application, my lord. Case 15 is the FI, my lord. My lord, the the mother, my lord, then two is the, my lord, her son, my lord, and three is their daughter-in-law, my lord. And case 15, it shown, my lord, that allegation is that, my lord, the informant was kept at the residence, my lord.
Just a minute.
My lord. In fact, my she is around 27 years now, and my lord, initially she stayed with her grandmother, my lord, in a different place. So, my lord, now what has happened, my lord, now some altercation with the petition number 1, my lord, the mother, my lord, she is around 62 years, my lord. So she wanted a mobile, my lord, and some altercation, she went away, my lord. Thereafter, we lost one FI, my lord, page 24, my lord. Petition number 3, my lord. She is the daughter-in-law, so she lost an FI, my lord, before the police, my lord.
No, petition number 3
She lost.
scolded her. She lost an FIR.
Yes, against the, my lord, present informant, my lord. Page 24, my lord.
Page 24.
Yes, ma'am.
Okay.
So she left the house. She was not there for 2 days, my lord. We lost one FIR, and in fact, here, my lord, possibly, my lord, custody may not be required. Lady, my lord, 2 are ladies and 1 is the son, and specific allegation possibly against number.
We'll allow for 1 and 2 for the time being.
Only, I want to say only one thing, my lord. My lord, kindly page 21, page 21, the FIR, my lord. Janara Begum. This is the victim, my lord. Page 21, particular. Ejarkari Janara Begum, boy, Hanumani, 18 বছর. Now, my lord, may come page 24.
No, we say 15 years, yes. We say she's 27 years.
Janara Begum, my lord, first paragraph, I am writing report showing Janara Begum staying domestic here since last 15 years.
Yes. She is 27 years, my lord, and she has let it be on record.
From the age of 3.
Cannot be, my lord, improbable, my lord. And we have stated why, my lord, because initially she used to stay with her brother in the outhouse, my lord, not at the house. And she is around, and we have all photographs and everything, and she don't.
No, you are saying that she was staying as a domestic help for 15 years in your FIR, not in your pleadings.
Yes, yes, that language I have.
We'll allow it for 1 and 3. 1 because of the age. 3 being a lady.
2, there is nothing is 2 also possible, my lord. Absolutely, my lord, nothing, my lord.
No, you chased her around with a pressure cooker. Does it look good?
My lord, mother. Cannot be, my lord. We have stated everything in our petition, my lord. Kindly, my lord, be proceeding. And all are, they could not issue that notice also, my lord. No. You are 7 years, my lord. All available except 2 sections, my lord. Those are
the number 2 has chased her around with a pressure cooker.
mother, my lord, possibly.
No, both of them.
Kindly, my lord.
Heard Mr. Chaudhary, learned counsel appealing for the petitioner, also heard learned APP, তাৰপিছত এইখিনি দি দিব। The learned counsel for the petitioner has submitted that the petitioner number 1 is aged about 61 years and the petitioner number 2 is aged about 41 years, both being ladies. He has further submitted that the informant in the present FIR, in which they seek pre-arrest bail, had been staying with their family, along with other family members
Initially.
from a very young age.
Yes, yes.
And it is and it is only recently that there have been altercations between the two parties.
Yes, ma'am.
Regarding what? Altercation between the two parties, full stop. He has also pointed out to the FIR lodged by whom?
Petition number 3, my lord.
By petition number 3 against the informant on P82026, whereby allegations have been made that that the informant in the present case had stolen money and other property. Full stop. The learned counsel has further submitted that the petition number 2 was not involved in any act of assault on the informant in the present case, and the same has been a cooked up story. Full stop. Call for the case diary list again on we'll have it on 16th of September. On 16th of September 2026, full stop. In the interim, it is provided that the petitioner number 1 and 3 shall appear before the investigating officer of the case to participate and cooperate in the investigation process. In the event of their arrest prior to the next date of listing, the petitioner number 1 and 3, namely Miss So-and-so and Miss So-and-so, shall be released on bail on furnishing bond of rupees 5,000 each to the 5,000 each with one surety to the satisfaction of the investigating officer. Full stop. List on 16th as directed above.
All this can do also, because he have to kindly, my lord, try to kindly have a look once, my lord.
He should not be roaming about with a pressure cooker in his hand.
Try to, my lord, no, yes, sir. Kindly, my lord. Try it, my lord. Kindly have a look once, then I leave it to your lordship, my lord. Kindly.
We don't see a ground for the respondent number 2, sir. It is only because the 1 and 3 are ladies.
Hello?
One who has lodged an earlier FIR and the other is 61 years old that we are granting the interim.
Kindly have a look once, then I leave it to your lordship discretion.
What?
Kindly have a look once, try it to, my lord. No assault, my lord. Try it to, my lord.
You are roaming about with a pressure
Try
cooker.
it to, my lord. No assault.
Nowadays, these drums and pressure cookers are very dangerous.
Kindly have a look, page 16, my lord. Today, my lord, kindly see once, my lord.
Chased me, trying to assault me with pressure cooker.
Yes,
What
my
more do you need?
Try it, my lord. So, no,
Oh,
no injury, nothing.
if the pressure cooker had been used, then the FIR would be by someone else.
Possible, my lord. Kindly, my lord.
We'll give it for 1 and 3. On 16th, we'll see.
Obliging.
60. 60. Yes, sir.
My lord, only one annexure, my lord, page 17.
17.
My lord, is the notice, my lord, which I could annex, my lord. Lord, this case has been registered, my lord, in the cybercrime police station, Raichur, my lord, in the state of Karnataka, my lord. Allegation that the sum amount has been, my lord.
I have not been able to understand the FIR.
No, my lord, it is not an FIR, my lord.
It's a notice.
This is a notice under section 35.
Case has been registered under cybercrime so-and-so regarding fraudulent transfer of money in the complainant account. In the complainant account.
My lord,
In this case, complainant has lost to, accused transferred the fraudulent amount to various accounts.
My lord.
This has come from Raichur.
Raichur, my lord, in the state of Karnataka, my lord. Pro the Barpeta Road Police Station, my lord, and the Barpeta Road Police Station is now summoning me, my lord, on the strength of this notice to appear before the Barpeta Road Police Station. Now, my lord, the issue is that if I go there, my lord, I will be handed over to the Raichur Police Station, my lord. So, my lord, I will go and I will cooperate with the investigation, and my lord, this is actually, my lord.
Investigation where?
Investigation in Raichur, my lord, and in Karnataka. Probably for a transit bail, my lord. That's
Allowed.
my lord.
When?
My lord, within
When will you report?
45 days, my lord.
Heard Mr. So-and-so learned counsel, learned senior counsel appearing for, learned senior counsel assisted by learned counsel for the petitioner, full stop, also heard the learned APP. The petitioner in this case has paid for transit bail in connection with cybercrime police station Raichur FIR number so-and-so, huh? It up on page 17. Full stop. Prayer for transit remand is transit bail is allowed. The petitioner in the event of his arrest prior to the next date.
My
When will you appear?
my lord, at least 40 days time may kindly be given, my lord.
Prior to his arrest.
As
No,
part
the
of
petitioner shall appear before the Raichur police,
My lord.
cyber police crime case, police station on or before the 30th of September 2026.
As per PI injury, they have to approach the jurisdictional court.
Yes, sir.
हाँ,
No,
हाँ.
that I will do, my lord.
हाँ.
Seeking bail or
Full stop. Then we will not say the police station, we will say to approach the learned court of jurisdiction
My lord, my lord.
on or before the 30th of September 2026. তাৰ পিছৰখিনি মই লিখাই দিম দিয়ক ভিতৰত disposed of.
Obliged, my lord. Deeply obliged.
Dictate কৰি থাকিলে correct কৰি দিব 21 কিমানটা আছে কেইটা গ'ল What is this?
My lord,
Why is
this is a
Mr.
bail application. My
What
lord, on the
happened?
last occasion, your lordship gave me the liberty to check the records. Now, on perusal of the record, my lord, I have seen that there is an absolute non-compliance of section 42. And non-compliance of section 42, way back in 2004, the Supreme Court have said that this is a factor which can be gone into while considering a bail application.
Hmm?
Now, my lord, under section 42, what contemplates is this. If the police officer gets a prior information, then it has to be reduced into writing. Now that I could not find in the lower court. I mean, in the TCR. Section 42's compliance is not there. This is number one. Number
If
two.
he does not have the time,
Pardon, my lord?
if he does not have the time to record it in writing, then what happens?
Then he comes back. But my lord, there are
Then he sends it.
my lord, there are two different situations. One is in a sudden NACA checking if the recovery is done. Then, my lord, they will do the needful and then go to the police station and make the required entry in writing. But if they have a prior information, then the writing is mandatory, my lord. That is what at least, my lord, the Supreme Court has held, my lord. This is one. Two, my lord, may kindly take up my additional affidavit which has been requisitioned today morning, my lord. The section 50 notices. Now, my lord, the section 50 notices running page your lordship will find 36, page 36 and 37. In fact, my lord, my submission for petitioner number 1 would suffice for petitioner number 2 because the notices are identical. 36, 37 is petitioner number 2. Now, my lord will kindly see, this is the notice under section 50. You are hereby informed that I have reasonable ground to search you as per section 42 of NDPS. My lord is there, page 36. You are hereby informed that I have reasonable ground to search you as per section 42 of the NDPS Act, which empowered me to enter, search, seize and arrest without warrant or authorization. I do hereby inform you about the provision of search of section 50 of NDPS Act, and you have agreed on the following ground to be searched. Number 1, to proceed the search under section 100 of the CRPC and politely decline to be searched in front of nearest gazetted officer or magistrate. Number 2, to be searched in front of nearest gazetted officer and magistrate only. So, my lord, as far as my understanding of English goes, my lord, these two are self-contradictory. This is my understanding, my lord.
Number two, my lord, what I have understood by going through section 50 is that section 50 gives a right where the investigating agency will communicate the right that a person has to be searched if his body search or person search is done, to be searched before a gazetted officer or before it. He has to be apprised about his right. Section 50 does not contemplate that there is a provision for search under section 50. That here they have merely, my lord, this notice can be assailed in three fundamental grounds, my lord. One, the right per se was not communicated. Simply a provision was told.
Just a minute.
My lord.
Was your body searched?
Yes.
How do you find, where do you
My
find
lord,
it?
how do I find? I made a statement, and moreover, my lord, had my body not been searched, what was the requirement of this 50 notice?
Oh, now they give notices of every section possible before they do anything.
So it at their peril.
I did. Yes.
The more stringent the provision.
Was there a body search, sir?
It was recovered from the vehicle so far as seizure is concerned.
Hmm?
So far seizure is concerned.
Recovered?
Recovered from the vehicle.
Why the notice when body was not searched? Notice is wrong.
Notice is wrong.
So unless you take a stand that I never searched the body, whether there is a notice or not, I don't care.
My lord.
Convince us that the body was not searched even after the notice.
Let's expect, my lord,
Ah.
because my lord, this petition affidavit filed today, my lord. Every now and my lord, if a new ground come, my lord, we cannot, my lord, must get the opportunity, my lord. There is not the ground. So today only he has filed the affidavit. Minutely I have to check from the my lord. Elsewhere, my lord. He have checked it, my lord. Whether he can also say, my lord, that if it is there that the body was searched, my lord. Because he has very minutely searched it yesterday, my lord.
Then following the NDPS procedure, informant gave notice under 50 to each suspected person to search their body.
Yes. Notice, my lord, I will not go the language of the notice, my lord.
No, he does not even take either of them.
And also, my lord, two are contradictory. I agree.
That is what he had to take either of them.
That whether he searched or not, because so far.
PCR is here.
TCS is here.
When will you answer the ground?
3 o'clock. Now, he has seen this. If under section 50, my lord, he said that after going through the entire TCR, he found that the section 50 notice were given, my lord. Whether
Yes.
he has anything to suggest, my lord, that yes, my body is also searched from the TCR, my lord. Whether he can say.
He says the notice is there, body is searched.
That
I'm
cannot
making
be,
an
my lord.
I'm making an
That cannot
assertion.
be, my lord, ground. If his body, your lordship's query, my lord, whether if notice is done, he said that perhaps it is searched, then cannot be a ground. That cannot be, my lord, because that thing has to be, my lord, clear from the TCR, my lord. Yes.
This is only a tip of the iceberg, my lord. There are larger
Yes, my lord,
issues.
yes, my lord, it will be helpful perhaps in the trial if this 41, 42 not. Then it is a very good ground, good case for him, my lord. 41, 42, my lord, is violated, my lord.
No, I'll demonstrate from judgment. 42 is, Supreme Court says 42
Yes,
can
my
be,
lord.
so 42 in bail application, 42 can be gone into.
Now, PWs are going on.
I'm coming to PWs also.
What does it say? Accordingly, general diary entry was made by the officer in charge of Azhara PS.
Yes.
Ah.
Where is that general diary entry? It is not there. And in the general diary entry also I'll show. Your
12.
lordship is
General diary entry 12.
Your lordship is reading from the FIR. Kindly, I have also verified that, my lord, that there is a general diary entry of 12 dated 5/10/2000 and
25.
yeah, even that GD entry is there in the reference. Your lordship has seen?
We
The
tell us
general
what-
diary. So that general diary entry would amount to compliance of 42. That would be a possible argument that was reduced into writing. Kindly turn to page number 9.
9.
9.
Oh.
Now, my lord, before that, my lord, when was the interception done? 7:30 to 8 o'clock in the evening of 5th. 7:30 to 8 o'clock in the evening. My lord will kindly see, 1, 2, 3, the fourth point, there is a general diary reference, date and time. Does it tell you, my lord? When was the general diary made? At 11:30 in the night.
No, this is regarding the arrest.
No, my lord, this is general diary. It is clearly written, my lord. General diary reference, entry, page
Number
9.
16.
The entry number is different. It is 16. Date is 6/10. And the time is 11:30 in the night. How it can be, my lord? The FIR was received on 5/10 at 11:30 in the night, and the general diary was also made. The number is 16. It is rather made on 6/10/2026 at night 11:30.
Yes, Mr. Goswami, go through the records, tell us at 2. Huh? Tomorrow morning. Tomorrow morning.
And
Let him go through the
Absolutely. Let him.
list again tomorrow. Kaile kiman tarikh? 27th.
My lord, there are 1,
At the
2 more
request
grounds,
of
so that should I, because again tomorrow they may.
42 is one of yours.
42 is one of them.
GT entry does not match.
Yes. And 50
50
is.
body search
50 body
notices,
search is
notice.
there.
Huh?
And then, my lord, this coupled with the fact that the memorandum of arrest is attested by 2 persons whose name does not figure out in the list of witnesses appended in the charge sheet.
Okay.
Now,
And that will be a matter
yes.
of trial. And
My lord, because, my lord, just my one-line submission here is this. Here is a case, the Caesar witness does not test. Now, since the TCR has come, your lordship,
Mr. Biswas, the next ground, please.
because the Caesar witness does not testify seizure of the goods.
Okay.
There are no witness to testify arrest. The GD entry says something else, FIR says something else, this is something else. Fourth, my lord, my lord, these are, by and large, these are my.
Yes, Mr. Goswami, tomorrow morning.
I
Yeah.
reply each and everything so far I could, my lord.
Tomorrow morning.
But
I'm deeply obliged.
Lordship, may kindly peruse last order is at 24/8/2020.
My lord, here I have received the information, my lord, at 2, my lord.
We are thinking we are finishing the list, but we are keeping it for all for 2.
My lord.
Lordship, regular bill application, matter has already been charged on the.
so the my lord, TCR, my lord, up to that TCR has been called for. My lord, it is received, my lord, regarding the earlier evidence. Evidence of my lord PW 1, 2, and 3. But the victim statement, victim evidence is scheduled to be taken on 11/9, to be taken on 11/9.
Huh?
11th of September.
11th of September, my it was fixed for victim evidence, my lord. So, my lord, I pray.
Lordship, we also applied for the certified copies if Lordship wants to peruse. The notice was received on behalf of father of the victim for the victim statement on 29/6. But after that, 3 witnesses have already been examined, but she has not turned out.
On 14th, it is examined 3 witnesses, my lord. It has
29 June, father has received notice on behalf of the daughter. Lordship may peruse the last page. The rest is already there. But yet the victim has not turned up. The case has been investigated into charge sheet has been filed 97 days. We are behind bars. Then the allegation of any heinous offense, Lordship, it's of misrepresentation or cheating at best that has to be established during trial.
What was the?
It is my lord, their own on their own prayer, my lord. The last occasion, my lordship may kindly see the order, my lord. It is not our prayer, my lord. It was held that, my lord.
You are saying it is what? Misrepresentation?
Of what? Cheating. There was a relationship. Later on, it was relationship between the two.
Later on, it was the assertion that the girl did not know that such was the identity of the boy. Then apparently they were taken to the Akrasu office where they were handed to the police. So even if your lordship goes through the witness list, lordship will see a pattern emerging. Now, some statements say that she went to Gauhati with him. Other statements say that she stayed with him, but the police has not investigated any of those aspects. When did they go? Where did they go? With whom they stayed? None
We'll
of-
have it on 14th. Let us see if she appears.
Yes,
What does she say?
Lordship.
Hmm?
Kindly, just not 14, my lord, because on 11 it will be taken. So if we requisition for the my lord is here, it will perhaps.
No, he'll have the certified copies with him.
Yes, then it will.
We'll have it on the 15th. 11th
If
is
he
a
can bring,
Friday.
my lord, then-
11th is a Friday.
Lordship.
Second.
Monday you
12
take
will
the
be a-
certified copies. We'll have it on
12 will
Tuesday.
be a holiday and 13 is a holiday.
So we'll have it on 15th.
15.
15th. The learned counsel for the petitioner has submitted that the informant has not appeared for adducing her evidence before the learned trial court, although the notices were received in the month of June itself. Full stop. The learned APP has submitted that the matter has been fixed on 11th of September for adducing of evidence by the victim. Full stop. For PWs and victim. Full stop. Accordingly, list this matter again on 15th of September 2026. Learned counsel for the petitioner would be at liberty to obtain certified copies of the further proceedings in the trial and produce the same before this court.
His lordship, the case diary and forensic report was called for. While order dated 6/8/2026 in item number 25.
The entire edifice of this case is that purported rhino horn. The FSL report is negated, man, it's fake.
So he did not carry any rhino horn.
In
No, the cheating part you are not concerned with. Whether he would sell it to someone or not. It is not a rhino horn. That much we know. Okay.
Fake in the bottom of
in the offense report also, they have mentioned that suspected. Therefore, I had to wait for.
And what about you? Together?
Yes.
Both were arrested together.
He is appearing for item number 20.
Do you need custodial interrogation?
Well, if the entire edifice falls, now they can sue each other, my lord. They have tried to sell.
Heard
fake
Mr. D. Chaudhary, learned counsel appearing for the petitioner in BA number 2214 of 2026 and Miss appearing for the petitioner in BA number
BA number 2363.
236. The Mr. D. Gogoi, learned standing counsel forest,
Special PP.
special PP wildlife has produced before this court the report of the forensic examination which reveals that the seized article is not a real rhino horn. So, in view of the above, the time of the considered view that the petitioners can be granted the privilege of bail in connection with offense number Omukha at page 134, so and so. Accordingly, the petitioner shall be released on bail on furnishing a bond of rupees 5,000 with one surety of the like amount to the satisfaction of CJM Kamrup Metro. Bail applications are disposed of. Hmm. Hmm. 25, 26 goal. 27 to ki hol? 28 matter.
28.
Yes, sir.
Made DJ Lord. One previous question, the DD was called.
Sir, sit let down.
Your Lordship, even if charge sheet has been laid down, our case both on merits and point of law is that he was produced after 24 hours, that is around 30 hours. Your Lord. That may I submit on that? Page number 15. Page number 15 is the FIR.
Huh?
Page number 15 of the
1-5,
One
yes.
is the FIR, Your Lordship,
Hmm.
which in second paragraph of the FIR, may I just read?
Hmm.
Not exactly fourth line, Your Lordship. The fourth line says
11:40, huh?
11:40 AM, Your Lordship.
Okay.
This is the time when he was intercepted and he was questioned.
Hmm.
This is on 23rd of 23rd 5, Your Lordship, 23rd of
Hmm.
May. Page number 19 is the forwarding, where he is shown as arrested in the police station in page number 19 on 24th 11:30 AM. And thereafter
24th,
24th 10:30 AM, Your Lordship.
10:30. And when was it produced?
On the late evening of 24th,
24/6.
24:05, Your Lordship, and 23rd 05, which clearly indicates that after detention, 24 hours later, he was shown as formally arrested and thereafter produced. However, the exact time of the production is not mentioned in the order sheet, but in the late evening of 24th May, Your Lordship.
Yes, sir. What do you say?
11:30.
Hmm. (24/520). PCR is here.
Remand order, madam.
Huh?
24/5 is the remand order.
24/5 is a remand order. We do not know the time.
No, and
If arrested
arrest is
at
also
11:30,
24/5, 11:30.
no. He was detained on 11:40 on 23/6.
I have seen this.
And place
Page 15. At about 11:40 AM, we saw the vehicle being registration number so and so.
Yeah, in the next paragraph, Your Lordship, it is written upon questioning the apprehended driver, which means he was already apprehended.
Hmm?
Section 15 notice was also served. Your Lord. Even if you go by the forwarding report, Your Lordship, it is written as 10:30 AM and the place of arrest is the police station, Your Lordship. In the arrest memo also, page number 35, Your Lordship, place of arrest is written as outpost, police outpost, and time is written as 11:30 AM, which means only 10 minutes of difference to reach before the judicial magistrate, Your Lordship.
Where is the arrest memo?
Page number 35, Your Lordship. Page number 35. Place of arrest at Shimaltapu outpost and time of arrest 10:30 AM. That means the place is not the court
Page
premises.
number 35, time of arrest is 11:30, 24/5/2026.
Yes, Your Lord.
Kindly come to the forwarding report, sir. Brief of the case is that today on 24/5 at 8:30 AM,
Lodged.
the FIR is lodged.
Yes.
However, in the FIR, the informant submitted it on 23rd, undersigned by him on 23rd. Page number 17 of the FIR, Your Lordship. Page number 17 is that he has submitted the FIR on 23rd after apprehending him. It was registered on 24th. Two signatures are there, Your Lordship. In page number 17, page number 17, right bottom, Your Lordship. The informant has submitted it on 23rd 5 and it was registered on 24th 5. He has submitted after apprehending him, Your Lordship.
Yes, tell us.
Lordship, may I kindly see my, as per forwarding, madam. At about 11:40 AM, they saw the vehicle, madam. Thereafter, madam. After that, my lord, the vehicle has been apprehended, madam. The independent.
12 o'clock.
The complainant immediately.
The independent witnesses were examined and before commencing complainant anything. And
I think you are not quoting the time anywhere.
forwarding is, forwarding date is 24/5 again. The remand order is also. No,
Acha, is page 15 the FIR?
Page 15 is the FIR, Your Lordship.
Huh? Page 15 is the FIR.
yes,
Date is 23/5.
23/5.
Now come to the forwarding. Brief of the case.
Yes,
Today on 24.
on 23/5, my lord, the information was received, my lord.
Eh?
Indeed, Your
Are reference Simolu so it's OPG GD
On
number so and so
23/5.
23/5/2026.
Yes, 23/5 at about reliable source was informed. Yes, my lord, 23/5.
When does he sign it?
23/5.
23/5, Your Lordship.
23/5 at page 17A.
Okay. 23/5, after 11:30, he has been detained, man.
He has lost the FIR on 23/5.
23/5, man.
FIR has been lost on 23/5. Come to the forwarding.
The forwarding, I have. Yes, sir.
Today 24/5/2026.
Yes.
So and so has lost an FIR.
Yeah. There may be some error in the matter, but in the below at this PS to the effect that on 23/5 at 10:30 AM, my lord, that is there. My lord.
Add about it, huh?
And after getting the reliable information, my lord, that
Okay.
is there.
Even thereafter, Your Lordship, total discussion concludes that he was there more than.
Have
20
your instructions, your GD entries?
Yes.
Huh?
Yes.
When did they reach back with the confiscated articles? And when was he moved to the court?
Court.
These two things, please give us.
And
That
the
is his only ground. There is no
and-
other
and
ground.
Remand order.
Huh?
And remand time, my lord, that or.
If
when
you
he
have
was
moved
produced,
out within the first 24 hours, we can still
then-
consider it that you were on traffic.
There even.
But
2
if
hours
you did
is-
not move out,
2 hours, my yes.
if you do not move out, then you are in trouble.
Yes, ma'am.
Friday?
Right?
Friday some difficulty, Your Lordship.
Monday then.
Then Monday?
Monday.
31st. 31st was it?
If that is your only ground, Friday you can have it on VC also. We don't have a.
Friday, Your Lordship.
Have it on VC?
On Friday. Deep.
List again on?
Which day?
No. Friday, 28,
No.
28 August.
No, can we have second, my lord?
Second, okay, on 2nd of September,
Yes.
allowing the learned APP to verify the time of the GD entries relating to the
Yes.
time of arrest. No,
Time of
time of
arrest and
returning,
production.
time of reporting back to the police station after the seizure. And the GD entry relating to the time when the accused arrested had been forwarded to the remand magistrate.
Even if he is detained, my lord, earlier, then he will get the benefit, my lord.
Huh?
If he is detained earlier, my lord, then.
That is why your return time will show.
Yes, then he will get the benefit.
Deep, Your Lordship.
27. Time of arrest.
Is niki?
Yeah.
At 2, my lord. Time. One judgment is required. Which I,
Huh?
One judgment I will collect.
At 2. এখন তো ভিতৰত থাকিব হা লাঞ্চৰ সময়ত ফোনটো অলপ কৰি
Yes. Lordship, the relevant portion of the FIR is at page 22, Lordship.
Case
It
diary
is a
received
recovery of case diary.
FIR page
Page 22. Lordship, 286.5 kg of ganja were recovered, not from me, Lord. From one other accused, Lordship. It was recovered on 4/6/2026. And after 25 days, I was arrested on 29/6/26. Lordship, the ground of arrest mentioned in the forwarding report, Lordship, as at page 33, Lordship.
Tell us.
The ground is that I had
frequent telephonic connection, connection with the co-accused. That is the only ground. I was arrested after 25 days. They got sufficient time. What is the material that I had delivered the contraband to so and so?
There are two accused. One is absconding, one is arrested.
Yes, Lordship.
You are having connection with both.
Lordship, so far as telephonic connection is concerned, Lordship, that cannot be a ground. That cannot be a ground to book me under this.
You are accused number 2.
Lordship, here in this forwarding report, I am accused number 1, Lordship.
You are accused number?
Surut Gurung. No allegation is there that I am transporter, purchaser, importer, exporter, user, or manufacturer, or preparing the manufacturing of the drugs. Nothing allegation, Lordship. In order to book me under section under 20B2, C and 25 and 29.
Yes.
The Lordship, the 47, the grounds, it is not sufficient, Lord. There is not a ground at all, Lordship. So far as 47 is concerned, Lordship, this cannot be a ground.
Which one? Where is your 47 notice?
Yes, 47 notice, Lordship. Page 36.
Why this is not a ground?
Lordship, after 25 days of my arrest, of recovery, I was arrested, Lordship. They cannot connect me, they failed to connect me with the contraband, Lordship. Simply they have said that I had telephonic connection, telephonic conversation with some of the accused. In these days, Lordship, telephonic conversation can be made with anybody, Lordship. But only because of this allegation of telephonic conversation cannot be a ground that I am involved in this.
Yes.
Here from the statement of the my lord, this my lord, from whom it was seized, my lord, one Doi my lord. He is my lord, clearly stated that there are 4 persons. We are in a group, my lord. We go to Arunachal. Thereafter we bring back my lord, contrabands and sell it, my lord. And the other 4 accused also, my lord, stated about these effects, my lord. And there are frequent severe analysis was taken, frequent contacts between them. My lord. So, my lord, we are now in the my lord stage of my lord in the bail, my lord. So, at this stage, my lord, we can consider the statements rendered by the other witnesses, my lord, against them, my lord. Because he is, and also the statement of his own statement, my lord, he has also stated that we 4 are in the numbers and we are associated and we are transportation of.
How many days have you completed?
Is a commercial quantity, my lord, completed
From 1st of
58 days.
1st of July, 58 days.
58 days.
58 not may not be sufficient.
Huh?
And it is not recovered from me, Lord. I am innocent, Lordship.
Recovery may not
37
be-
comes in, sir.
Recovery may not be, my lord, absolute
37
criteria.
comes in when there are telephonic conversations amongst yourself. One of them being a habitual offender and all that. Our presumption that you may not be proved guilty during trial, that is not coming to us. At this stage, huh?
At this stage, my lord.
Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard the learned APP. The case diary called for has been produced by the learned APP. Contents of the same have been considered. At this stage of investigation, I am not inclined to grant the privilege of bail to the petitioner. The recovery of contraband is of commercial quantity. Huh? I am not inclined to grant bail to the petitioner at this stage. Instead, accordingly, the bail application is rejected at this stage.
Okay.
1 PM, my lord, regarding
1 minute.
item number.
Ek minute per India.
Yes. Regarding item number 21, my lord, can the LCRB kept here, my lord, because they will carry that, my lord. Regarding 21, my lord.
Huh.
Can the LCRB kept in the, my lord, court, my lord, for
Item number 21,
21
LCR.
just fixed for tomorrow, my lord, for the reply of. our perusal, my lord.
Item number 21 to immediately ঘূৰাই পঠিয়াই নিদিব। LCR টো তেওঁলোকে TCR টো তেওঁলোকে চাব খুজিছে। Even if the file goes, TCR টো থৈ দিব তেওঁ কাইলৈ ফাইলটো আহিলে আকৌ হেৰি কৰি।
We can, because it was perhaps it kept sometime in the other court.
TCR খন থৈ দিব। Yes.
May I please?
Yes, sir, quickly, huh?
My lord, he was arrested on 9/7, my lord. Today is 49 days. And my lord, here section 50 was not complied. 3 persons were arrested, my lord, by same forwarding report.
Have you seen your relevant typed copy of the relevant portion of the FIR?
Yes, my lord.
Page?
Page, my lord, that is 11, my lord.
Page 9. You say is the typed
yeah.
copy of relevant portion of FIR. Tell us what is there in the FIR, reading from that page.
But page 14, my lord. Sorry, my lord, page 14. 14 is the FIR, my lord. It was relevant portion, my lord, the total weight of the contraband was 62.63 gram suspected heroin, my lord.
62 point?
62.63, my lord.
Intermediate quantity.
Intermediate, fine.
Yes, my lord, to below 250 is intermediate.
But
3% they were driving the vehicle. In the meantime, my lord, in Nagasaki, my lord, the police stopped them and my lord charged the personal charge also mentioned here, my lord. My lord, I'm reading that in relevant portion here. 49 and 2% already, my lord, same ground released on bail, my lord. I have annexed the bail order also, my lord. Page 19 and page 22.
Page 19 you want us to?
Yes, my lord.
Page 19, yes.
Here, my lord, the one of the co-accused, my lord, from the same forwarding. The honorable court, my lord, observed the section 50 was not complied here. And next bail order, my lord, that is another accused. Page 22, here also, my lord, not complied. Because personal charge was there, but
They are the same footing, but my lord, he is the person from whom the contraband has been recovered. My lord. Under section 50, my lord, already there is an observation, my lord. But
We'll allow it, we don't have an option.
period of
Heard
detention,
Mr. Ainuddin, huh?
detention 14.
49 days.
49 days. Heard Mr. Ainuddin, learned counsel for the petitioner, also heard Mr. Goswami, learned PPA paying the matter. The learned counsel for the petitioner has submitted that the recovery of the contraband has been shown from a body search of the petitioner.
Yes, ma'am.
And he has also referred to two earlier orders of this court passed in bill, application number 1952 of 2026 and 2194 of 2026, to submit that this court has already held that the notices under section 50 of the NDPS Act as served upon the petitioners therein had been found to be defective, and therefore the petitioners therein had been granted the privilege of bail. The learned counsel for the petitioner has submitted that since similar notices have been served upon the present petitioner also, the notices would fail to meet the requirements of law, and therefore the petitioner at this stage would be entitled to the privilege of bail. Full stop. The learned APP, Mr. Goswami, has submitted that the recovery of the contraband is from the petitioner. And therefore, the petitioner may not be at this stage and granted the privilege of a bail. Full stop. Since this court notices that the contents of the notices under section 50 of the NDPS Act as alleged to have been served upon the petitioner does not suffice the requirements of law, the search of the body of the petitioner in the prima facie view taken by this court, is that the recovery cannot be attributed to a recovery from the personal search of the recovery of the contraband cannot be attributed to the lawful legal search of the body of the petitioner. Full stop. Accordingly, this court is of the considered opinion that the petitioner would be entitled to the privilege of bail, also considering that the period of detention of the petitioner as of now would be around 49 days for the recovery of an intermediate quantity of heroin from the petitioner. Accordingly, the petitioner shall be allowed to be released on bail on furnishing a bond of rupees 50,000 with two sureties of the like amount to the satisfaction of the learned CGM Kamrup.
Lord, special judge.
Of the
Kamrup
special
Kamrup.
judge,
Earlier when it was
special judge,
Kamrup, I mean.
Kamrup Amingaon, full stop. The learned session judge shall be at liberty to impose such other conditions as may be required to ensure the participation of the petitioner in the further investigation process, full stop.
I'm glad.
Bail application accordingly disposed of.
Look.
Come back to.
Item number 71, may I be allowed to peruse the TC again?
Called for, my lord. That has not come, my lord. Therefore, I'm praying before your lordship, my lord. Since the interim is there in respect of petition number 2 and 3, my lord, that may kindly be extended and a separate date may kindly be fixed, my lord. Item 36.
The TCR call for is yet awaited. Learned counsel for the petitioner is present. List the matter again on
In the first week of, my lord, September, any day, my lord.
9th of September.
My lord.
Interim order passed earlier continues.
Deeply. Item 6. Now it's and 62 and 63.
I'm praying your lordship may kindly take up item number 63 first. In all the cases, same FIR, my lord. Since I am prepared in that matter, my lord. Voting mirror.
Yes.
My lord, the
Mr.
challenge.
Gogoi,
My lord, I have
the
given.
compilation of judgments.
But today, my lord, he is moving the bail application. The one he is now, my lord, referring to is the, my lord, criminal petition.
Petition,
Must
yes.
the FIR. There, my lord, he has moved for a, my lord, interim bail in the criminal petition. The honorable court held that, my lord, there is a
That's
specific,
why
my
I-
lord, provision. So he has moved the anticipatory bail. That liberty was given.
So your lordship may, because my lord, hearing for stay of the proceeding amounts to hearing entire matter.
No.
If
So
your
far, my
lordship
lord, so if
feels
this part is
it may
concerned,
be
my lord,
heard.
let him first move the, my lord, bail application. That part is clear, my lord. Quashing is something or not, lordship will issue notice, my lord, lordship will look into that.
Okay.
But I'm
Cannot
praying
be the
for
very first.
bail is separately listed, my lord, and other for stay of the proceeding, your lordship. So I am first, your lordship may kindly take up item number 63, my lord.
63.
My lord.
3.
Three. My lord, the FIR in question, your lordship will find at page 49. And I'm taking your lordship to page 52. And your lordship will see subject, my lord, FIR against Sri Rishikesh Kalita.
Page?
Page 52, my lord. This is the FIR which I am seeking quashing, your lordship. Page 52. Subject, my lord, FIR against Sri Rishikesh Kalita, proprietor so-and-so and others for offense of cheating, forgery, use of forged documents, criminal conspiracy under BNSS Act.
Okay.
Thereafter, my lord, they have given details of Kalita, and thereafter, my lord, they have given the names, and I am one of the accused, my lord, serial number 2. And so far as this petitioner is concerned, my lord, his name is not in this FIR, but I have been behind the bar. Item number 62, name is reflected.
Stick to 63.
63, my name is not.
63, your name is not there at all. Very well.
Now, my lord may kindly come to page 53. But I have been arrested in this connection. Page 53, my lord. During the course of investigation conducted. So this investigation was conducted by, my lord, State GST Authority. Under Assam Goods and Service Tax Act, it has been revealed that the above mentioned taxpayer in connivance with other accused person fraudulently availed input tax credit amounting to rupees 12,1076 so and so.
Yes, we have read the paragraph.
My
Next.
lord. Thereafter, my lord, kindly come to bottom, my lord, last paragraph. Why this FIR has been registered? Although, this is very important, my lord. Although the state GST has initiated proceedings under the relevant provisions of GST law
the scope of investigation required to unearth the entire criminal conspiracy, identify all associated person entities, trace the complete money trail, and establish the role of the beneficiaries extends beyond the departmental jurisdiction and resources. So they are admitting that they have already initiated investigation, and since they are not well equipped, so they are giving to my lord STF. I will show in the act, my lord, they are more than equipped than STF. My lord. Now, my lord, kindly come to the FIR lodged by State GST, page 41. And your lordship will see in the matter of page 41, an application under section 132, your lordship has got it, page 41, my lord. Case number is given, my lord, and state so-and-so, and versus Rishikesh Kalita, the name which is reflected in STF FIR, my lord. And allegation, my lord, kindly see, para 3. That based on actionable intelligence and system-based data analysis from GSTN and e-waybill portals, a
In
large
substance, the same allegation.
same allegation. So in my humble submission, my lord, there cannot be two parallel investigation on same FIR, same subject matter, my lord, hit, my lord, as held by Honorable Apex Body, TT Anthony case. My lord. Number one, your lordship. Number two, my lord, in the GST Act, if your lordship will see, for every action, my lord, every offense, there is a special provision has been enacted by legislature, parliament in 2017. Prior to 2017, my lord, penal provision was not there. When GST Act came into existence, my lord, they have given penal provision. That, my lord, will kindly see. Just I would like to show, my lord, section 67 onwards. GST Act.
Do you have GST fund?
In fact, I have quoted, my lord, in my petition.
Where?
पूरा नहीं किया 69 से किया एक्ट इज नेसेसरी क्या my lord section 67
67.
This is a chapter relating to offense, my lord. Chapter, my lord, 14, my lord. 67 says, my lord, about power of inspection, search, and seizure. So that power is given to GST authority, my lord. Your lordship may.
We are reading different books. No.
No, same.
The power is inspection, seizure, search,
And
seizure, and arrest.
Arrest 69.
No. The chapter is inspection, search, seizure, and arrest.
Chapter is there. But power has been given under section.
Under 67. Acha, arrest is different.
Thereafter 68 was inspection of goods in movement. 69, my lord, can you see power to arrest? May I read your lordship? Where the commissioner has reason to believe that a person has committed any offense specified in so and so, so and so, so and so, under section 132, which is punishable under clause so and so, so and so of the said act, he may by order authorize any officer of central tax, perimeter, AGST Act and CGST Act is perimeter, to arrest such person. So, my lord, precondition is, my lord, there has to be reason to believe, my lord. And Apex Court in Radhika Agarwal case, in compilation, I have given, my lord, reason to believe it has to be given when the person is going to, they are going to arrest that person, my lord. In the present case, my lord, since they invoke, my lord, IPC, now BNS, my lord, bypassing, my lord, the special act. So they have not given commissioner power to give reason to believe is not required, my lord. So they have arrested me. So arrest is also under challenge before this honorable court. Whether, my lord, I will place decisions, my lord, whether bypassing the statutory provision of special act, can the resort of, my lord, general act be taken when the special act has been enacted for the purpose of the offense?
Who has arrested you?
STF, police, on the basis of that FIR.
It is not the.
GST already started proceeding that I have shown, my lord. They have given to STF saying that we are not well equipped, so you also initiate proceeding. In that proceeding, in STF proceeding, they arrested me in item number 63. Thereafter, my lord, section 74 says about, my lord, if the heading is 74, my lord, can you see? Determination of tax not paid or short paid or erroneously refunded or input tax credit wrongly availed or utilized by reason of fraud. This is important, my lord, or willful misstatement or suppression of facts. So section 74, my lord, empowers the GST authority to make an assessment if there is a fraud and all. So power of assessment has been given to my lord GST authority. Your lordship may kindly skip over and kindly come to section 132, my lord. Punishment, my lord. Punishment of for certain offenses, my lord. As I already submitted before your lordship, my lord, if amount involved is less than 5 crore, my lord, then this is bailable and non-cognizable. If it is above 5 crore, your lordship, then it is non-bailable and cognizable, and maximum punishment is, my lord, 5 years. Your lordship may subsection 5 says offenses so and so shall be cognizable or non-bailable and 5 years. Section 134, my lord. It says, well, no court, your lordship has got it, no court shall take cognizance of any offense punishable under this act or rules made thereunder except with the previous sanction of the commissioner. My lord, in every step your lordship has seen, my lord, there is a rider, my lord, that it has to be in the notice of learned commissioner, my lord, before taking any penal action, my lord. But in the GST Act that has been given, your lordship, a decision I will place, my lord. But in general law, it is not there. So can they bypass, my lord, the special provision where the protection has been given to the individual that unless to apply brain of the commissioner, my lord, whether arrest is necessary or not, because apex court, my lord, in a Katina decision held, my lord, that arrest cannot be made if it is everything is documented in GST Act, so far as GST Act, and my lord, without determining, my lord, the liability as per section 74, because my lord, determination can only be done by, my lord, the taxing authority under section 74. They are alleging that 12 crore or something. I am not saying it may not be, maybe, but that figure will only come, my lord, after determination under section 74. I will place my decision. Now, my lord, kindly come to my compilation first. My lord, page 1, these orders were compiled, my lord, only for the purpose to show before your lordship that in view of, my lord, Arnav, page 1, my lord, of compilation. In view of, my lord, the judgment given by Honorable Apex Court, my lord, in Arnav Goswami case, wherein, my lord, what has happened, criminal questioning petition was filed before, my lord, Honorable Bombay High Court, your lordship. Bombay High Court, in that criminal petition, my lord, prayer for release was also there, your lordship. But what Bombay High Court has done, Bombay High Court only issued notice, and so far as, my lord, for bail part, your lordship, petitioner was relegated to, my lord, regular bail, your lordship. Against that, an SLP was prepared, Honorable Apex Court, your lordship. Apex Court held, my lord, that in that case, when the Honorable High Court was on the view that case may, my lord, and there is no bar to grant regular bail or anticipatory bail, my lord, under, my lord, in criminal petition, your lordship. Since the High Court was not, bail was not granted, my lord, the Honorable Apex Court directly granted bail. On that score, my lord, a number of cases were filed before this Honorable Court. Page 1, my lord, kindly see. And in this Honorable Court, my lord, in tax matter, GST matter, granted interim bail, my lord, during pendency. Page 1, my lord, page 5, my lord. In writ petition also, this Honorable Court granted bail, my lord. So I am not taking your lordship to Arnav Goswami and all, only for that purpose, my lord, I have compiled all these decisions. Now, my lord, kindly come to first page 188, my lord. Well, this is the division made decision of Honorable Punjab and Haryana High Court, your lordship. And I am taking
your lordship to page 191. I'm sorry. And your lordship may kindly see serial number 3, 191. Roman 3, your lordship.
191.
For a central excise officer or an officer of so-and-so empowered and authorized in this behalf to be satisfied that a person has committed an offense under so-and-so option would required to be conducted by giving an opportunity to the persons sought to be arrested to explain the materials and circumstances gathered against such person. My lord, that was subsequently, my lord. Thereafter, my lord, Roman 6, your lordship. Because the provisions were perimeteria, my lord, apex court in this judgment held that in GST it is applicable. Roman 6, my lord. In the case of Make My Trip, my lord, Delhi High Court decision, without even an so-called notice being issued, or without there being any determination of the amount of service tax arrears, the resort to extreme coercive measure of arrest followed by the detention so-and-so was impermissible in law. That was based on, my lord, Make My Trip, and Make My Trip judgment was upheld by Honorable Apex Court, my lord, page 194. Para number 10, my lord. Conceitedly, Honorable Supreme Court by order dated so-and-so was upheld the aforesaid decision of Delhi High Court. So, my lord, the judgment given by Delhi High Court attained finality by Honorable Apex Court, my lord. So, determination part is, in the present case, my lord, they are saying alleging, my lord, without determining, without issuing any so-called notice under section 74. So, in my humble summation, without determining by issuing notice under section 74 or a passing order, my lord, one cannot say that this is the amount and this is not the amount, because, my lord, I may dispute also, my lord. If the proceeding may be initiated, I will get opportunity to place my records and all. No, why, my lord, I should be arrested? Unless until amount has not been determined, my lord. Why should I arrest it? And now, my lord, kindly come to Radhika. Arnav Gautam, I am not placing, my lord. Radhika Agrawal, page 165. Start from 165. Taking your option. Para 52, my lord, first. Para 52, 165. After dealing with, my lord, provisions of PMLA Act, of in the case of Arvind Kejriwal, my lord, Apex Court dealt with the provision of GST Act. My lord, kindly see first, para 51, page 165. We shall now draw our attention to the provisions of the GST Act. To a large or reasoning or ratio of applicability of the code of would equally apply to GST Acts in view of the section so and so and so. I'm skipping, my lord, thereafter my GST provisions of GST Act were taken into consideration. And, my lord, page 171, 170. Para 62. It says, my lord, the findings and ratio recorded in para 32 to 49 above with reference to the Customs Act would equally apply insofar as maintenance of records as well as obligation of arresting authority and rights of accused person arrested are concerned. Compliance in this regard must be made. And what, my lord, para 39 and 32 to 49 says, my lord? Para 34, page 158.
Para 34.
Page 158, para 34. The contentions of so-and-so that while grounds of arrest were mandatorily required to be supplied to the arrestee, reason to believe, being an internal and confidential document, need not be disclosed. It is a submission, my lord. Was decisively rejected in Arvind Kejriwal case. It was held that reason to believe are to be furnished to the arrestees such that they can challenge the legality of their arrest, so and so. my lord, since they resorted to, my lord, other act by initiating proceeding under GST Act, my lord, those provisions which are giving me, my lord, protection under special law, my lord, I have been deprived, and my lord, it amounts to infringement of the protection and liberty given under the GST Act. Now, my lord, kindly see, TT Anthony, I have annexed, my lord, your lordship knows, my lord, page 372. There cannot be second. And para, my lord, page 385. Page 387, my lord, can you see? After of the 387, my lord.
Yes.
From the above discussions, it follows that under the scheme of the provision so and so, so and so, only the earliest or the first information in regard to the commission of a cognizable offense satisfies the requirement of section so and so. Thus, there can be no second FIR. And consequently, there can be no fresh investigation on receipt of every subsequent information in respect to the same cognizable offense or same occurrence or incident giving rise to one or more cognizable offense. Regarding, my lord, special act, silver drop page, silver drop.
738.
362.
Huh?
My lord, page 362. Regarding, my lord, special act will prevail over, my lord. Page 362.
Okay.
And paragraph, my lord, kindly see. Para 17, page 367. To 27. In this context, we may also deal with the provisions of so and so, which have a bearing on the issues before this court. Section so and so defines cognizable offense as an offense in which a police officer may, in accordance with the law for the timing in force, arrest without warrant. In the present case, FIR prima facie, this does not constitute a cognizable offense so as to register the case. Section 4 was, my lord, reproduced. Section 20, paragraph 20, my lord, 2021. Section 5 of CRPC also provides that nothing contained in this code shall, in the absence of a specific provision to the contrary, affect any special or local law for the timing in force, or any special jurisdiction or power conferred, or any special form of procedure prescribed by any other law for the timing in force. And accordingly, my lord, the FIR was quashed by this honorable court. Regarding GST, my lord, judgment. Yes, my lord. Same question came up before, my lord. Punjab and Haryana High Court.
After this, more.
My lord, after research, my lord.
Deserts. Main course gone now, deserts.
Your lordship may kindly first take Sushil Kumar Singla. And paragraph 17, my lord. 17. Page 7. The question, it starts from, my lord, the question.
We have read it.
My, the question.
We have read page para 23. Yes, next.
My lord. And para 21, my lord. And accordingly, with para 21. In this decision, my lord.
21. 21.
It was quashed, my lord. Next is, my lord.
Deepak Singhal.
Deepak Singhal, my lord. Question is section 1, para 3, my lord. It deals with, my lord, power of GST, power under GST. And all the sections were quoted, my lord. And page 18, paragraph 10. In view of the above, this court has no hesitation in holding that GST office cannot bypass procedure prescribed under GST for launching prosecutions by simply invoking penal provisions
under IPC without invoking penal provision under GST, especially when the allegations so revealed as a result of such and seizure conducted by GST authority constituted offence covered under the penal provision of GST, as that would amount to bypassing procedural safeguard as provided under section so and so, which requires sanction of the commissioner prior to initiation of prosecution, which is to the prejudice to the prisoner here, letting so and so authority to adopt such course of action would amount to abuse of the process of law which cannot be permitted by this court. And this Madhya Pradesh High Court relied on a Supreme Court decision there. It was in respect to IT Act, but the ratio is same, your lord, same ratio. So I'm not repeating, my lord. In the GST Act, my lord, there is a provision that if they are handicapped, they are not, then they can take help of police, railway, other department, my lord. Provision has been made by legislature, my lord. That you will also will see. Cognizance I have. Fine. Provision, my lord, page, section 72, my lord. Officers to assist proper officers. All officers of police, railways, customs, and those officers engaged in the collection of land revenue, including village officers, officers of tax, state tax, officers of union territory tax, shall assist the proper officer in implementation of this act.
Yes.
So, my lord, that plea, that cannot be, my lord. So, in my humble submission, my lord, this is a fit case, my lord. There cannot be, my lord, two parallel proceeding, my lord. And, my lord, investigation by, my lord, STF will amount to trenching open a power, my lord, given under the GST Act. Rather, it can be said, my lord, to bypass the procedure prescribed under the Act without determination of tax under section 74. My lord, they can't come to the conclusion that this is the amount involved in the case. This is my humble submission.
On the part of my this quashing petition, I will make my submission tomorrow. But regarding the bail part, my lordship may kindly have a look at item number 6 for a moment.
Item number?
Because he is praying for my lord bail in this criminal petition too, my lord. Just now lordship has paid. Item number 6. Order. In fact, the criminal petition filed by that petitioner is also listed before his honorable court. There, my lord, prayer for bail was prayed for by the petitioner.
We have been
Anticipated bail.
relegated to.
Yes, lordship will see what.
That's why
what
I
is
have
the
filed
bail.
bail, ma'am, separately. Since I was in criminal petition, this honorable court relegated me to file, my lord, this under this provision.
Not relegated, they stand down, my lord, his prayer for.
My lord, kindly see. Order, kindly see.
Lordship will see page
Yes, I have
58.
annexed it.
Page 58 for a moment.
58.
58. Criminal petition 1153/2026, this has been listed along with the one lordship has just now perused. Here lordship will see, my lord, finally. Para, my lord, 7, page 60. It is to be noted that an order under section 482 restraining, arrest or directing no coercive steps that effectively amounts to anticipatory bail without satisfying the requirement of section 482 B and SS is legally impermissible. The inherent power cannot be used to bypass the statutory bail framework. Therefore, this court is not inclined to pass any order directing the respondent authorities not to take any coercive action against the petitioner. Instead, it is relegated to avail a remedy under section 482.
What I said, ma'am, this is correct, ma'am. That's why I have filed.
That's why, my lord, so far as the prayer made.
He did not interrupt or say a word when you were arguing. I would not
sorry.
appreciate
I'm
two persons talking at the same time.
I am obliged, my lord.
Yes.
Now, my lord, so far as this particular criminal petition is concerned, there also, my lord, he has prayed for bail. Lordship will see the prayer made, my lord.
That will be the, this is Subhrajit Bhattacharya.
No, not one, my lord. The Vivek Kumar Gupta, my lord, criminal petition 1154. Their lordship will see the prayer made, my lord, page 38. The interim part, my lord. And to release the petitioner on bail as per the terms and conditions as may this be.
No, we are not granting anything interim today. Tomorrow we discuss your, when you make your submissions on
These
the,
are, yes, two
on this
different acts,
particular
my lord.
criminal petition, when you make your submissions, it is then we will go to this petition back.
In fact, my lord, in my Radhika Agarwal, what he has said that, my lord, there will have to be a prior determination by of an assessment. Only then, my lord, we can go for, my lord, any punitive action. This is already clarified in Radhika Agarwal's case. Para 61 lordship may kindly see in the back.
This is what you are, this is on the criminal petition you are making submissions. And we are not on that. You want to make your submissions tomorrow? We'll hear you tomorrow on that.
On the
This AB.
AP part, my lord, so far as, yes, my lord, the new one, my lord, item number 6.
See, on this is an order passed in the criminal petition.
This is the case, my lord.
See, 1153-2026 is the other criminal petition
Yes.
listed today. Yes.
Yes, sir.
There, if you see in your bail petition, if you see at page 60, page 60,
Well,
para 6. Are you equipped with it?
well,
Are you equipped with the case diary?
no, not there. I can place it, my lord, by evening probably I will get the, that's why
Tomorrow you can
yesterday also
play-
I said I can.
tomorrow you can place it.
I can place the report at least. The status of investigation and whatever is there against this particular petition, what we have.
Order dated 18/8, since it is an anticipatory bail, where certain questions have come up as to whether you can legally arrest him or not.
My lord. No, that part also, my lord, will come, my lord, while hearing this particular criminal.
So but
because
when there's
these
when
are
there's an
different
order
petitions.
asking you to have the CD ready on the next date fixed, which was 25/8.
My lord, I was
Today we are on 27/8,
My lord.
26/8.
By evening.
You would still have time till 27/8 to have the CD, but that is tomorrow.
I will
Tomorrow
place
we
it.
expect the CD.
Yes, yes, we do place.
Your ground probably is that only, that I cannot be arrested without all these things being done, and therefore I should be granted the interim bail. And this is this bail is in connection with the
Same,
uh,
my lord. STF. case
with
number-
the STF.
Yes.
So far as the STF is concerned, you would defend as to you would defend the proceedings that you have initiated.
Two proceedings, one is the complaint.
You would represent the PP also,
On behalf,
because the STF part is the PP's part.
yes.
If I'm not
On a
wrong.
legal submission, I can make, my lord.
Okay. Tomorrow. Tomorrow we'll try to take it up in the second half, not on the first.
And my lord, you'll also may fix at 2, my lord. No.
No fixing at 2. When we say at, in the second half, we usually take it up. Let's tomorrow at the request of the learned additional AG. That can there be 2 affairs?
My lord. Two, in the sense that, my lord, I will also place.
We
my
try
lord,
to,
pro-
in our mind, we try to distinguish. One is whether offenses under GST has been done, and the other whether
cheating and all.
the
my lord. If
fraud,
there's a
and everything,
cheating,
the
that part will come in, my lord.
The
Under
Punjab
the
and
PLS.
Haryana High Court or some High Court
That, my lord, I will
clarify, it
check.
clarifies that.
Fine.
Give him the copies. Yes, next.
Deeply over.
Well, they were supposed to tell whether this notice was served on the petitioner or not, also. To the relative of the petitioner. Okay.
But there has been no reply from Khagaria.
Report is there, my lord. So, kindly para thereafter, my lord. 6, 7, 8, my lord. 10.
6 we have seen.
My lord. 7, 8,
Email
my lord.
was transmitted
My lord.
to action addressee on the same date at 2:35 PM.
My lord. Thereafter, para 9, my lord.
During course of my official report.
9, 8, 9, 8, my lord. Thereafter 9.
Yes, sir.
I have not. got
Any
that
clears
copy,
are
but
being
written,
Have your instructions.
Lordship.
The address supplied by the petitioner.
Lordship.
Police went there.
Lordship.
The family left 20 years ago.
In fact, Lordship, if my instruction is there yesterday, Lordship, I have talked. When OC called the brother, Lordship.
That is
That
there.
Brother all part is the former part.
Lordship.
That is the former part.
Lordship.
The wireless went from here.
Lordship.
Mansi PS got it.
Lordship.
Officer in charge, Mansi PS got it.
Lordship.
He sent one person running to your address.
Lordship.
And the report has come that the family left a particular address 20 years ago.
Oh, that
So
is,
this is a deliberate attempt to bypass 48.
no, so in my petition also, Lordship, I have given my address, Lordship. That address is there. Probably that is the address where he is residing, Lordship.
The address which was given by you, confirmed by your brother, and the place where you used to reside.
Lordship.
What is that? Seema parking.
My lord, para 5.
Seema parking. There is a Seema parking somewhere. That man has also come and said that yes, this is the address given to us also. Your brother also gives that address. You also give that address. 20 years ago, your family left that address.
No, in my petition, Lordship, the address which I have mentioned and the forwarding report, the address mentioned is same, Lordship. He is resident of that place only. And if
Then
you
do we disbelieve the police?
Annexures are also.
No, Lordship may fix it tomorrow and one copy may be given to me, Lordship, if I will instruction, Lordship, which address they have mentioned.
Mahashaya
to verify
Pandav
that,
Kumar.
Lordship.
Mahashaya Pandav Kumar, Pita so and so, Mansi Khagaria. जो 20 वर्ष पूर्व समथिंग से सारा संपत्ति जमीन बेचकर चला गया है.
So as per my instruction, he is resident of that.
Now, if we probe into this deeper, we would request the sale of land documents to be brought here. Fresh case will start against your client if the land is found to have been sold. Fresh initiation of trying to dupe the court.
No, I can produce the Aadhaar card also because if they
No,
say.
you are giving your addresses somewhere here and there, documents are being made,
Aadhaar
doesn't
address
mean.
and this address, if it is similar, Lordship, then your Lordship will consider.
Oh.
That is why.
When the specific report says that 20 years ago the land was sold off.
Lordship.
My daughter, myself, we all have an address in the Aadhaar card. I sell off that property. I go and I reside somewhere else. I don't change it in the Aadhaar.
So they
And
may,
to avoid 48 notice, I keep giving my address everywhere so that I will never be traced out in my life. Somehow I am caught. I give the same address. Part and parcel.
No, here one thing, Lordship, I kindly consider that the address which I have disclosed at the initial point of
Without
time.
going into all that, presently we are of the opinion that based on the report received from the Mansi PS, that 48 has been done.
No, Lordship, may kindly give
Anything
me one
else?
copy tomorrow. I will attend on this. Lordship.
Anything else?
And anything else?
You may have your instruction
Lordship.
to the extent whether the land had been sold off to anybody else.
Lordship.
If he says no, then we will record your statement
Lordship.
that on instructions the land has not been sold. We will keep this in abeyance, asking for a report from the state of Bihar regarding the sale of land. If that comes up,
Lordship may take it up tomorrow.
Your
also.
process of law would follow, huh?
Lordship may take it up this matter tomorrow, and I will submit my other ground also, because 36 along with illegal detention is also there.
36, what is that? Tell us.
36 Lordship.
Why not today? Why not address us today?
So that already I submitted that address is correct, Lordship. So I want to get my proper instruction from
That, we will ignore that ground if it in any way
Lordship.
makes you uncomfortable. Any other ground you have? Tell us.
Section page 23, your Lordship may kindly see.
23, yes, 23.
Signature of witness is not there, Lordship.
Huh?
Signature of witness or relative friend, nothing is there. So in view of the division bench judgment, Lordship, if there illegal detention is there, then also your Lordship can consider.
Arrest memo, why does it not contain the signature of a respectable member of the society? Or is it a 47 notice?
No, arrest memo, page
Just a
23,
minute.
heading arrest memo.
Just a minute, sir. They may come up with another arrest memo.
One after another.
Oh, yes, you have to be prepared with all the plea. Are we giving him time today? We are not. Why should we burden ourselves? You have shown us a report that despite best efforts, it was a lie we could not serve. We have accepted that. Now now show us why 30. Whether if either there is a signature or there is no signature of any respectable member of the society. Since his friends and family family has sold the land, friends are not available. So respectable member of the society. Not there. What is your next ground?
Next, your Lordship may kindly see page 15, that is the FIR.
1-5.
Yes. This, they have received the information at Lordship on 24 April 2026 at 11 hours. And Lordship, the seizure list, which I could not annex earlier, Lordship, it was prepared on 1:12 PM on the same day. So even if we take that to be the detention period, Lordship, that he was produced in the second half of the on 25th, beyond 24 hours.
Seizure list is of 1 o'clock.
Yes, 1:12 PM. 24/4/2026. Forwarding is of 25.
25. 25 what time? Where is the GD entry?
That is there in the
My question to him.
Lordship.
GD entry, what time did you move from the police station?
We'll have to.
Huh? When were you arrested?
I was arrested on 24/4/2026, but they mentioned in the arrest memo as 25/4/26.
On 25 days soon.
They have shown that detained on 24.
Okay, after some time, one of you look into it after some time. We can't keep everybody waiting.
I may be also allowed to go through the record also. I will, if I can.
Go through. Go through whatever records you want to. PPA kole mati dibo to next. Kya kole mati dibo?
27.
The petitioner is an HIV positive patient, my lord.
Oh,
And the main grounds is, my lord, non-compliance of section 50, my lord. And
50.
Section 50 of. My lord, kindly see that 50 I have flag marked in TCR, my lord. That's here, my lord. Kindly see that 50, my lord. So my lord,
Below, my lord,
according
tell us below.
below?
In section 50 notice, my lord.
this, the legal rights.
He agrees to that without any magistrate, he can be, my lord. Last line.
He agrees to?
In absence of magistrate, he can be charged, my lord. Arrest, my lord.
When did you inform him of the right that he has the right to refuse search totally. He has the right to be searched in presence of a magistrate or to be searched in absence of a magistrate. Yes. Where is the conveyance of the right? That, sir, you may refuse to be searched by me in the absence of a. I've been informed and understood that so and so, I do not require my personal search to be conducted in the presence of the nearest gazetted officer or magistrate. You are in possession, therefore your personal search will be conducted. Tell me, do you need a gazetted officer? That is not the intent of 50. Intent of 50 is, would you like to refuse? You have the right to refuse. Search you, I will. Have a look. Heard, Mr.
H.R. Chaudhary.
Learned Counsel appearing for the petitioner also. We are only dictating the first part of the order. You may still convince us otherwise. Yes. H.R. Chaudhary, Learned Counsel appearing for the petitioner. Also heard Mr. K.K. Parashar, Learned APP, full stop. The Learned Counsel for the petitioner has submitted that. No, this is an application 483. Jabaruddin, who was arrested on
1/3/2026.
1/3.
Yes.
2026.
Also detained on 28/2, my lord, but shown.
Who was arrested on 28/2/2026 and had been forwarded for remand before the learned CJM Sribhumi on 1/3/2026. The Learned Counsel for the petitioner has submitted that a body search of the petitioner had been conducted and allegedly. What is this?
May I read again, Malad?
What has been recovered?
Yaba tablets, Malad.
Commercial quantity of contraband has been recovered from the petitioner.
May I read again, Malad? Second, yes, document articles is in offense under.
You would first tell us.
Therefore, your personal search is to be conducted by the undersigned.
Huh.
If you so require, such search will be conducted in presence of nearest gazetted officer.
Suppose he says that I do not want to be searched at all in the absence. Where is that part? In the absence of a gazetted officer,
yes,
I will not be searched.
But subsequently, I have been informed and have understood the notice so and so and so. I do not require that my personal search may be conducted in presence of. I do not require that my personal search may be conducted in presence of the nearest gazetted officer.
I am going to search you. Would you require Mr. Goswami with you?
But
is one issue. I want to search you. You may refuse to allow me to search in the absence of Mr. Goswami. If you want, I can search you in presence of him. If you want, I can search you in absence of Mr. Goswami. So I have given you the right to refuse till Mr. Goswami arrives. Don't touch me. Where is that? That is what the Supreme Court has said, sir. That is the law, what to do.
If you so require.
And this court in 2 orders have said you need to change the.
That format.
Has it been forwarded? Our last order has been forwarded. So all arrests between that order and today, same notice will come. We will draw a deep breath and then we'll pass an order. The Learned Counsel for the petitioner has submitted that during the body search, commercial quantity of contraband has been recovered, full stop. The Learned Counsel for the petitioner has submitted that during the alleged body search, where the contraband had been allegedly recovered, the petitioner had not been given a right to refuse his search in the absence of a gazetted officer or a magistrate. He accordingly submits that the arrest of the body search of the petitioner having been rendered illegal, comma, the continued detention of the petitioner thereafter on the allegation of carrying commercial quantity of contraband on his body is rendered illegal also. Accordingly, he has prayed that the petitioner may be granted the privilege of a bail at this stage for the reason that the body search and further detention is not in accordance with law. Full stop. Learned APP has submitted. Learned APP, Mr. K.K. Paras has submitted that the notice under Section 50 CPC had been served upon the petitioner, informing him about the requirements of about the contents of Section 50 of the NDPS Act, and after being so informed, the petitioner had agreed to have his body searched without the presence of a gazetted officer or a magistrate. Full stop. In response, the learned counsel for the petitioner has submitted that the petitioner had never been informed about his right to refuse the body search by the police officer in the absence of a magistrate or a gazetted officer. Full stop. He has submitted that the right to refusal not having been told to the petitioner, comma, he had no other option but to agree to be searched. Full stop. I have gone through the materials on record. I have also perused the TCR and I have considered the submissions made. Full stop. This court in BA number so and so by the order dated so and so had held that the comma, referring to the different judgments of the apex court, had held that the absence of the information to the petitioner regarding his right to refuse a search in the absence of a gazetted officer or a magistrate having not been conveyed, comma, the arrested accused would be entitled to the privilege of bail. Stop. The following extract of the aforesaid order would be relevant. Order number to publish. In the present case also, a perusal of the Section 50 notice does not reveal that the petitioner had been informed about his right to refuse a body search in the absence of the gazetted officer or the magistrate. Accordingly, the petitioner is found to be entitled to the privilege of a bail. His privilege of a bail, since his body search and further detention cannot be said to be in accordance with law. Accordingly, the petitioner shall be released on bail on furnishing a bond of which?
Tribhumi, madam. Special.
Tribhumi, and you are a resident of where?
Resident of Tribhumi, madam.
Same resident.
Tribhumi.
Furnishing a bond of rupees 50,000 with two sureties of the like amount, comma, one of whom shall be a government servant, to the satisfaction of the learned special judge. Tribhumi. Full stop.
Petitioner is an HIV patient, my HIV positive patient. So my lord, to take
There are 34 HIV patients presently in the Gauhati jail.
39.
39.
take
We'll have you put it in the same cell. You cannot. No.
so government servant, my lord, sometimes it's very.
What does HIV have to do with the government servant?
Your lordship, my lord, give privilege regarding to any, my lord, government servant, if your lordship may consider in this aspect. Otherwise, my
NDPS, sir, you are carrying Yaba tablets. Are you denying it?
My lord.
Petitioner shall not leave the jurisdiction of the learned special judge. Has it been, it has been charge sheeted, na?
Charge sheeted.
Special judge without prior written permission, the special judge shall be at liberty to impose such other conditions as may be necessary to ensure the continued participation of the petitioner during the trial process, full stop. Bail application accordingly disposed of.
My lord,
এই উপর লিখে দিব, it has been submitted that the petitioner is in, no, I don't think we bring that on record. You have brought it here, na?
my lord, Prohibitions mentioned as section 50 of CRPC. NDPS.
CRPC, we said CRPC, make the necessary correction, NDPS. Huh? Huh? 50 CRPC?
It should be NDPS.
It should be NDPS, huh? NDPS?
If I
48 হলে BNS হবো, 50 হলে NDPS হবো, 50A হবো, 50A, huh? Yes, sir.
May I please, Your Lordship? Matter came up before Your Lordship on last Monday, and and Your Lordship directed me to file an affidavit annexing this order of the 10-6, when he was shown arrested. That we have done.
You have given us 19.6. Is it 10.6 or 19.6?
19-6.
Okay.
And well, the factual metrics of the case is that I was arrested in Lamding PS case number 80, and bail was granted to me on 17/6/26. When I went to give the bail bond, on that day I was shown arrested, 19/6. Without following 47/48.
No, 48 there.
48 is there.
Later on, you can have your affidavit.
Pardon?
Have your affidavit.
25.
You-
IO has submitted compliance report with arrest memo, notice under 48. Again, notice under 48. Why two notices under 48?
No, my lord, which arrest memo, notice under 48, and its connected papers.
No. Arrest memo thereafter read.
Yes, two times 48 inserted.
One would be 47
But my lord,
and one would be 48.
48, man.
If that is so, Mr. Biswas, if
Yes, then I'm coming, my lord. The affair was lost after 3 years. POCSO. My lord, the lady got married in Dehradun. She was called under the behest of local political party, because I being a journalist,
where is the affair?
my lord, page. After the form. My lord, page 58 kindly, peruse it. $52, my lord, I'm sorry, 52. My lord, your lordship will find that Priyanka Lama, aged 20 years, father of such and such, permanent resident of such and such, that in November or December 23, she doesn't know the exact month. In November 20 or 23, accused Arijit Das, son of Ajit Das, resident of Charles Road, Jangli, Kalibari, Lamding, police station, Hojai, introduced himself to me as a media person. After some time, the accused told me that my younger brother smoked marijuana, and if I did not give him 50,000.
Just a minute. Page 53, top paragraph. That is the only allegation.
Thereafter, one day accused took me from our European national. And
No medical will ever prove it.
no, man.
No eyewitnesses to
Cannot, man.
support or deny.
Cannot.
Word of a major,
Sir.
now major, alleging something when she was a minor.
Neither.
After 3 years.
No. And thereafter, yes.
After 3 years,
Yes.
she can get married after attaining the age of 18, but she cannot make an FIR at the age of 18.
Yes.
And she said like that.
From 23 to 25, that is.
You are
next
granting the
paragraph.
bill.
Next paragraph.
You are granting the bill.
Next paragraph, my lord.
Huh.
From 23 to 25, accused
Hmm.
repeatedly subjected me to physical.
So 25, she was a major.
Major, my lord. Yes, my lord. It was an incident of 23. And thereafter, my lord, other allegations are also there. If your lordship may kindly see the first, fourth paragraph, my lord.
Now, just tell us one more thing.
That's
From 23, this FIR is lodged in 26,
26.
when she's 20 years old.
How much?
2023, she would have been either 17 or 18. Yes?
17 or 18?
So 17
Either
plus.
17 or 18.
Yes.
Has she given her birth certificate?
Lordship may kindly see annex of page 59, my lord.
59.
59.
Huh.
Accused person, second paragraph,
Hmm.
accused Arijit Das has been physically produced for me and such and remanded to custody. Case diary of such and such, this case, my lord, edit.
When there is no allegation
Yes.
of any
Yes.
penetrative sexual assault,
6 will not apply.
how do you bring in 6?
Six, my
By
lord.
later on developments in the statement before the police? No.
Have been, my lord, perhaps 8, my lord. No, I am not.
6 will not again come in.
Yeah, it will come. Yes,
Did we issue notice here to the respondent
has to
number
be-
2?
Not only this, another POCSO case has been added. It is before in the other court. This is projected by the local political party, because I was working for a media and I projected so many stories against the local MLA. And I filed a writ petition also in the High Court to intimate me how many more cases are coming up. This is like how the liberty of a person. is
Yes,
cut.
it is in Lamding, Hojai.
Yes.
We'll issue notice on the issue notice to the respondent number 2, but we'll have it on something very early, 7th.
Not 7, but please earlier, my lord. Because I am apprehending, my lord. What
4, 5, 6 closed.
Oh, right.
2, 3 open, 1 closed, 31st is open. You will take steps tomorrow, 27th.
27 tomorrow.
28 he will get it.
29, 30.
29 Saturday he will try to serve it. Second the report will come, or third the report will come. I am having it fixed on 7th, sir. How much more?
No, my lord, only thing is that, my lord, the FIR was lodged after.
You are already inside another 10 days
I mean, other case, probably I am going to get bail in that case also.
today.
Not today, it is fixed tomorrow, my lord. Because court wanted to give me interim bail even. That's such a
Even we
illegally-
want to.
Yes.
Even we want to. Without the service report, it is a bit difficult. Even if we don't issue notice, it becomes a bit difficult. Otherwise, we are convinced you need not be kept.
My lord, what happened? I
for custodial
projected a story
interrogation.
against the brother of this person, who is a drugs mafia, and he is still in the jail, Nagaon jail. And now he is trying to kill me inside the jail. Now you have come inside the jail.
It's 3:15. I have got time till 4:15. A long list. Heard Mr. S.C. Biswas Learned Counsel appearing for the petitioner. Also heard Mr. Goswami Learned APP full stop issue notice on the respondent number 2 in accordance with the prevalent notification, since the case involves involves the provisions of POCSO Act full stop. Steps within 2 days. Call for the case diary list again on 7th of September 2026, along with service report and case diary, full stop done it. And Mr. S.C. Biswas Learned Counsel appearing for the petitioner has submitted that the FIR has been lodged when the informant had attained 20 years, alleging that the accused herein, that the petitioner herein had taken the
Inside the jail now.
the informant in a four-wheeler to a secluded spot on the national highway and threatening to kill her, molested various private parts of her body against her will. Full stop. The Learned Counsel has submitted that the petitioner has submitted that the petitioner is in custody in connection with some other case.
Yes.
Other case.
Lambding with 80.
namely Lamding PS case
80,
number
2026.
20 of 20.
Where I got bail from the.
Where he was granted bail and on the petition when the process for having the petition released from bail had been was underway, comma, this present FIR was brought into existence, full stop. Be that as it may, list the matter again on 7th of September along with service report and case diary. We have just recorded, sorry, we remember. Give next.
65 and 66.
Please, Lordship. Lordship, item number 66, as instruction for withdrawal.
66 you want to withdraw at the
Yes.
request of the learned counsel for the petitioner. There is a bill petition. Bill petition number so and so item 66 is closed on withdrawal. Yes. What about 65?
Full or full? 65, my lord, I also gone for the TCR, my lord. It takes some time.
You want to go through the TCR?
My lord, any day
What
we
was your
can-
ground, sir?
My ground, Lord, first of all, they say it is a commercial quantity,
Huh?
2.7 kilogram, but it is in the raw form. That
Oh,
weight
Pitakani.
measure- Yes, ma'am.
Weighing machine
The weighing machine, they have procured from a local shop seller. The name is included in the FIR itself. Kindly come to page 20.
And you had information prior information.
That device is not here.
What was used? The Dagapala one or the something
Probably-
electronic?
Yes, yes,
Dagapala.
Dagapala.
Huh?
And there no mention in the source sheet about that device.
Then what kind of a device did you use?
And one more interesting fact, my lord, the vehicle that is being seized, my lord, that is not mine. Of the other, the co-accused petitioner, my lord. His vehicle is, we were acquaintance, we know each other, we are the same vicinity. So,
He wants some time to go through the, we have asked you so that he can know what to look for.
that's correct, yes.
After
already-
some time.
More than 220 days.
After some time.
Some other day.
Some other day. Day after tomorrow? No, 31st.
31st.
This is BA.
BA.
Day after tomorrow. Pukurba koi do, huh?
31st, my lord.
Etaro dispose koi do.
Little bit day
66
after
DO.
tomorrow.
66 disposed of on withdrawal. 65 list
Day after tomorrow. Huh?
on 28. 28. Day after tomorrow.
Yes.
Yes,
All right.
Lordship, I am behind the bar for 58 days, Lordship, it is a 60 days offense. Only charges of 87 BNSS, this is earlier 366 kidnap, this is
Huh?
fifth day of listings. This is
What?
today, fifth day of listing, Lordship.
Charge sheeted.
Charge sheeted.
Charge sheeted.
Lordship, custodial trial will not be required in this case, Lordship, my FIR is at page 15, Lordship. It is only a missing entry.
And why have you been arrested?
When I went.
The child was recovered.
Yes, Lordship. I was detained when I went to drop the victim at a relative's house. At page 16, Lordship, that part is there.
Sixteen-year-old.
16-year-old.
Then,
He
Lord,
was
page 20,
apprehended
Lordship.
along with the accused, then only is the girl is recovered.
Yes,
Huh?
Lordship.
He was apprehended along with the accused, my lord.
Yes, yes.
Then only the my lord, girl was recovered.
If Lordship
not
looks
there.
at page 20, Lordship,
What is the age of the girl?
16 years.
16 years. My lord.
Did we not issue notice?
No, Lordship, POCSO is not there. Lordship.
16 years and POCSO is not
No,
there.
not simply I went there and police caught
It
me,
is
Lordship.
regarding my 87, under section 87. my lord.
87, Lord, kidnap only.
Kidnapping.
That is the kidnap,
Kidnapping,
allegation of
my lord.
kidnap, Lordship. And even 36 has not been
Huh?
complied with.
Yes.
Was suscited, man. That is what I'm.
Till he receives
him-
this, till he receives someone,
Lordship.
till he receives someone, let him be out.
It will be before the trial court, my lord. whether-
Huh? Usually,
because
yes.
it is- Because if
Usually, yes. Usually,
it is
yes.
AB, my lord, then it is, okay, my, till he received the summon, my lord. But it is now he is behind bar, my lord. So let him try.
No, Lord. 36 violation is also there, Lordship. Page 20, if you Lordship looks at. no
Page
signature.
20, huh?
No signature, Lordship, of witnesses.
Oh. Hey.
Page 20, Lordship, at column 12, signature of the informant persons. No. No relative. No respectable person.
No. No, no, okay, to solve it.
Arrest memo, whom are you arresting?
Jahidul Masud, Lordship.
Zahidul Masud, man.
The active petitioner here, Lordship.
Then we have to see the 48 then, my lord.
Hmm?
36 is, my lord, referred to, my lord.
30 it is?
36 referred to, then we have to again see the 48.
No, 48 is not relevant. Even if 48, our division bench has held that
It is our,
even compliance of 48 is of no relevance.
our honorable court has clarified it. my lord.
48
That
is of
if
no
36
relevance.
there is no signature, then 48 has to be.
48, yes. If 48 is okay, my lord, then 36.
That is there.
No, that
That
part
is
is
there.
as per division judgment, Lordship. 48 is there, Lordship. As per division bench judgment, Lordship. Even if compliance 48 is not rectified, the
That is
mistake
not
on
the- that is
36,
not the
Lordship.
Hmm?
36 is a pre-arrest part, 48 is after arrest part, Lordship.
No, no,
So even if 48 is complied with, violation of
That
36.
is what he says. Once there is a violation of 36,
Lordship.
but 48 is complied.
Then also our division bench clearly held it, Lordship, in that judgment, Lordship.
36 violation is for others are all compliant, then.
No,
Only 36 will not help.
Lordship, second part, once POCSO is not there, Lordship, custodial, the only.
Now, why do you need him in custody?
Definitely not, Lordship.
That is prerogative of them now. Now we don't, now it is upon the
I have-
trial court.
Uh-huh.
Because now when the search sheet is laid
Let-
down, my lord,
Let us
it's gone
exercise.
to them, my lord.
Let
the-
us
the
exercise
trial
it
court,
because
my
now
lord.
you don't need him under for custodial
It
interrogation.
was, my lord, submitted search sheet, my lord.
Heard Mr.
SK
Poddar,
Poddar.
Learned Counsel appear from the petitioner, also heard Mr. MP Goswami, Learned Additional Public Prosecutor for the state. The Learned Public Prosecutor has submitted that the investigation is culminated in charge sheet
Search sheet, my lord.
number
Search sheet number 15026, dated 6/8/26.
Step. The counsel for the petitioner has submitted that since the charge sheet has been submitted, there is no requirement of further custodial interrogation of the petitioner for the time being. Full stop. He has further submitted that the petitioner, on receipt of summons, shall participate in the trial proceedings if any are initiated against him. Full stop. The learned counsel, the learned APP has submitted that releasing the petitioner on bail at this stage may lead to him hampering and tampering with the witnesses or evidences on evidences proposed. Full stop. This aspect of the matter can be tackled by imposing strict conditions upon the petitioner while granting him bail. Full stop. Accordingly, the petitioner shall be released on bail on furnishing a bond of rupees 15,000 with 2 sureties of the like amount to the satisfaction of the
CGM,
CGM
practically CGM Amingaon.
Amingaon.
Kamrup, sorry, CGM Kamrup
CGM Kamrup
at Amingaon.
at Amingaon. To the full stop, the petitioner shall not in any manner interact or threaten the victim or her family members or any other witness proposed in the charge sheet. Full stop. The petitioner shall not leave the territorial jurisdiction of the learned trial court without written permission from the same, full stop. The,
Here, because I'm a resident of Kolkata, Lordship, Borpeta district, Lordship.
you take the permission and you go. What is your difficulty?
Because
While taking bail, you take your permission that I want to go to Kalgachia. Is it not? That is one permission you required. At least the court should know where you are. Stop. You're trying to say something. Bail application is accordingly allowed. The petitioner shall appear before the learned trial court as and when he receives summons to pay for regular bail during the period of trial.
Obliged, Lordship, deeply.
Unfair, my lord, this order may not be a precedent, because
This order has been granted on the peculiar facts and circumstances of the case. Yes,
again, this
in
order-
exercise of my discretion to grant bail.
Obliged.
Should we record that also?
No, my lord,
No.
there will, again, this order will come and.
Huh?
Again, my lord, this order, showing this order, my lord. So
It depends on the facts
that-
and circumstances, sir.
Fine, fine.
See, he is from Kolgochia. Case will go on at. What does he do coming down here? He will not be able to threaten. And if threatening or hampering and tampering with the witness is the only ground we keep people behind bars till that point of time, that this point of time, you will be paying more taxes to feed them. Is it not? When the number increases, you have to pay more to feed them.
Crowded.
If it had been a case of dacoity, if it had been a case of rape,
No.
or forcefully taking away the girl,
So the peculiar-
apparently the girl has gone with him. Only
Yes.
because 16 years he is
That
behind
the-
bars.
That is the main.
2 years later, he would not have been in a problem. No? Yes, next.
Obliged.
68.
May I please,
Mm.
Lordship? Lordship, matter is related under section 87 and due to section 4 FOCSO, Lordship. Kindly produce page number 24, Lordship.
24.
Yes, Lordship.
Who's there?
This is the deposition of the victim, Lordship, under section 183 BNSS. May I read, Lordship?
There is a mistake. You do not want to have it corrected.
Lordship?
There is a mistake in the recording of the deposition. You don't want it corrected. Have you moved any application? No.
Innocent. So,
May I read, Lordship?
Please.
I am in love relationship with a boy named Vicky Boydo since last 3 months. My mother used to torture me at home and kept forcing me to get married. So I wanted to run away with Vicky, but he did not agree to it as I am not of age to get married. I insisted.
Read the sentence again, but
But he did agree to it as
he agreed to it, or he did not agree to it.
but he did not.
Where is the not gone?
But in copy of, I have another copy, Lordship, where they are in Assamese. She said that he was not agreed. Initially, he was not agreed.
No, this is signed by the judicial magistrate first class.
That is true, Lord.
183. The not word has been dropped.
Copy of
The not word has been dropped. You don't want a correction. Oh, it will change your entire story. Yes, sir. You are appearing as the amicus. Huh?
matter.
After this, what remains? Should we grant the bail? No. You are appearing for whom?
Already matter is
Already?
searched, Lordship. Investigation has been completed. On that ground, Lordship, learned. Only on that ground, Lordship, learned the trial court reject my bail petition earlier, Lordship.
Where is it?
29 page number 29, Lordship.
PCR is received.
yes, my lord. On 28/7 charges were paid.
28.
So, my lord, it is pending for, my lord.
Presently, the
Just tell us one thing, Mr. Goswami. Let us be very.
Lordship.
Before the magistrate, the girl says that I went with him.
Lordship.
He has committed an act. If required, if the minority is proved, he will go behind bars, long term, yes? Do you need him in custody now?
No, Lordship.
Her first statement before the magistrate is, I forced him to take me away. Yes? He went away to the mama's place so that they do not have a relationship.
Yes, yes, Lordship. that is
Yes?
Lordship, that is.
Young couple,
Young couple, Lordship.
once they engaged. Yes?
Lordship,
Yes.
You want him behind bars for that? What is his age?
My petitioner age is just attaining 18 years and victim is
granting the
17 years, above 17 years, Lordship.
We are granting the bill. Hmm?
Yes.
Strict conditions, we are granting the bill.
In 16 days, I am
The-
behind the bar, Lordship.
The boy will not interact with the lady in any manner.
No, Lordship.
One complaint and we will recall it.
Yes, Lordship. Any
Heard
condition. Lordship.
Miss,
As
heard-
they will, Lordship.
as the Learned Counsel appearing for the petitioner also heard Mr. MP Goswami Learned, APP Miss N. Hassan Learned amicus appears appears to protect the interest of respondent number 2.
Yes.
Full stop. The case diary, the scan copy of the TCR called for has been received. Full stop. The allegation in the FIR is to a mother application under 483, huh? Allegation in the FIR is to the extent, is that, where is that FIR, madam?
Lordship, after our page
Is that the petitioner had,
10.
that the daughter of the informant had left the home with the petitioner, but could not be traced out after much search, full stop. The petitioner had thereafter been arrested on
2/5.
2026, full stop. The deposition of the alleged victim under section 183 of the BNSS had been given along with the bail petition, and I have gone through the same, full stop. It does not seem to implicate that the petitioner had taken the victim or had used any force or coercion on the victim. Stop. The petitioner is a young boy aged about 18 years. Full stop. The matter has been charge sheeted. Stop. In the present circumstances, I am of the considered opinion that keeping in view the young age of the petitioner and the statement of the and the story projected by the victim before the learned magistrate, there is little the petitioner can be granted the privilege of a bail. Full stop. Accordingly, the petitioner shall be released on bail on furnishing a bond of rupees 10,000 with 2 sureties of the like amount to the satisfaction of the learned session special court, a special judge Pokso Kamrup Metro Gauhati. The petitioner shall not in any manner interact, entice, or threaten either the victim or her family members during the period when he remains on bail, full stop. Violation of any of the conditions aforesaid would lead to cancellation of the bail, full stop. The learned special judge shall be at liberty to impose such other conditions on the petitioner as may be deemed fit to ensure his participation during the trial proceedings. Full stop. Bail application disposed of. 18 years boy, we keep him inside that place. He gets more ideas. Yes. Disposed of.
Yes. Obliged, Lordship. Alia.
Item 70 and 71.
Yes, sir.
Lordship. Issue was your lordship. Whether your lordship, the petitioner will be entitled to get bail, your lordship, in view of the fact that they are produced before the court after 24 hours of detention. That's the issue.
Yes, sir. Tell us.
That is the issue, my lord. By 11 o'clock, all the persons have returned to the police station. And my lord, thereafter, next day, and the arrest was shown on, my lord, night 10 p.m. And
Arrest was shown at
in the evening, my lord,
and produced.
produced next day, my lord.
So the 24 hours period gone.
If we take the apprehension part, my lord,
Should we not?
My lord, if it is
Again, this is also.
apprehension fact.
Hmm?
That is my lord.
What is the recovery?
Recovery is my lord, is a 114 kg of ganja.
From the bed.
Yes, from the house of the.
Not from my house.
One of the petitioner, my lord.
No, not.
Ah,
petition.
this is
that
accused number 5, na?
Lords, I am not.
No, apprehended person number 5. If I'm not
Lordship.
wrong. That case. Rahul Tapte. Who is the
Rahul
other fellow?
Tapte and Babu Ali.
Who is the another?
Owner of the house is Anil Bora.
Okay, not this one. But there's one more matter with this respondent number, this 5 also, accused number 5 also, Biki.
He is there.
Huh?
Yes, my lord.
Ah, you are also there, na? Babul and Rahul. So it is 3, 5 and 6.
Lords.
All of them taken in together, all of them produced together.
Lord.
For this together, for this together,
Produce together.
Huh?
for this together.
Produce together.
Heard Mr. S. Bothakur, Learned Counsel, appearing in
Just
BA
one
number
more- just
2380
one,
2026.
regarding their, my lord, taking the stand at the village stage, not at the stage of remand, my lord. Whether, I don't, my lord, I may be wrong, my lord, whether that will suffice or not, my lord. Here is a case, my lord, where two bail petition has been filed, my lord. They have not taken the ground, similarly, my 24 hours part, my lord. They have not taken the ground on that pretext, my lord. But after disposal of two bail petitions, they have taken the stand that, no, we have been produced 24 hours later, my lord. But that.
This is not a suit kind of a thing where you did not take all the grounds at that point of time and therefore we will reject it
That
now.
is, my lord, the honorable, my lord, court
Ah, yes.
judgments, my lord, just I want to.
Please, please, please.
I was, the first bail petition, neither in the remand nor in the trial court, my first petition.
There was no bill petition on your behalf. That is for number 5. And you
We
had
have,
moved.
your lords, we have.
Kindly-
But your lordship, my submission to that will be, your lordship,
Para
it's
27.
relatable to the fundamental right. And there can be no waiver of fundamental right, your lordship.
Para
That has been
27
held by
kindly
the
peruse.
apex court.
When was this order passed?
Para
Please
27.
teach to Para?
27.
Okay.
No, it was only a doubt expressed about the veracity of their plea.
Veracity of the plea and.
But here in the case of the seizure list,
Yes.
or they are returning back to the police station along with the
No.
apprehended person.
Because
that-
teaser part, my lord,
No,
they are-
here the wrong time shown could not be, was not considered,
No.
or was taken to be that it might not be true. Here from documents you had returned with them from the place of seizure and arrived at the police station. Supreme Court says the moment you stop the movement,
Lordship.
And that-
arrest
that is-
starts. So that is why we had recorded in the last order.
Lord.
Beyond 24 hours may not vitiate the further detention. We'll record. You want us to record this also? Okay. Heard Mr. S. Bothakur, Learned Senior Counsel, assisted by. এইটো আপুনি লিখিব হেৰিত হা 23802026 হা this is an bail application under section 482 in connection with special NDPS case number so and so page 1 আছে where the petitioners had been arrested on 352026 full stop. The learned senior counsel or the petitioners have submitted that it would be apparent from the records that the petitioners had been apprehended at 11 on or about 11. What time?
Your lordship, so far as your lordship records, so your lordship general diary entry at around 4 AM, they have your lordship.
Were apprehended around 4 AM on
Your lordship, that is.
2/5/26.
The seizure is at 11, ma'am.
Seizure is at 11.
7 p.m.
7
a.m.
a.m.
We'll make it 7 a.m.
7 a.m.
That the contraband had been shown to be seized at 7 a.m. along with the arrested accused. Full stop. However, the arrest memo has been prepared on that date to like what at 7 a.m. on
2/5/2026.
2/5 and full stop. However, the arrest memo had been prepared on 3/5/2026. And the petitioners were also produced before the learned remand magistrate on
3, Your Lordship.
on the 3rd of
May.
May 2026. Full stop. The learned senior counsel has submitted that the petitioners having been taken into custody arrested on 2/5/2026 at 7 a.m. in the morning, their production before the learned remand magistrate after 24 hours had elapsed, had vitiated the further custody of the petitioners. Full stop. Accordingly, the learned senior counsel submits that the petitioner may be entitled the privilege of a bail at this stage. Full stop. The learned APP appearing for the state of Assam has submitted that the present ground cannot be allowed to be taken by the petitioner in view of the order dated 3/6/2026 passed in BA number 980 of 2026, where this court had held that had there been any wrong mentioning of time of arrest in the arrest memo, the petitioners ought to have taken up the said ground at the first opportunity, and therefore the petitioners could not be allowed and therefore there was a doubt regarding the veracity of the plea of the petitioners in that particular case. Accordingly, he submits that the prayer for bail of the petitioners in this case be rejected. Full stop. I have considered the submissions made, and I have also been assisted to go through the materials of the case diary. No, of the
TCR.
scan copy of the TCR.
Scan
Full
copy.
stop. In the case referred to by the learned APP, this court had expressed a doubt on the plea of the wrong mentioning of time of arrest being noted in the arrest memo. However, in the present case, it is seen that the seized article, that the seizure of the contraband had been made along with the presence of the apprehended accused petitioners herein at around 7 a.m. in the morning, and there can be no doubt in the mind of the court that the moment the petitioners had been restrained from exercising their right of free movement, the petitioners were deemed to be under arrest. Full stop. In such circumstances, this court is of the opinion that there is no doubt that the petitioners had been arrested at 7 a.m. on the morning of 2/5/2026, and their formal arrest had been recorded at where? At around what time?
Around
10 p.m.
At around 10 p.m. on 2/5/2026. Full stop. The petitioners were produced before the learned remand magistrate on 3/5/2026, and it is not the case of the prosecution that the petitioners were produced before 7 a.m. on 3/5/2026. In such circumstances, I have the considered view that the detention of the petitioners beyond a period of 24 hours from the time of their arrest has vitiated their further custody. However, keeping in view the fact that the petitioners are alleged to be involved in this commercial quantity, to be in possession of commercial quantity of contrabands, the strict conditions are required to be imposed while granting them the privilege of a bail. Full stop. Accordingly, the petitioners shall be released on bail on furnishing bonds of ₹50,000 each, with two sureties of the like amount, one of whom shall be a local surety in the case of each of the petitioners to the satisfaction of the learned
Sessions Court, Your Lordship.
Learned Sessions Court,
Majuli, Your Lordship.
Majuli. Full stop. The petitioner shall not leave the jurisdiction of the learned trial court without the prior written permission. Full stop. The petitioner shall not in any manner hamper or tamper with the prosecution evidence sought to be led. Full stop. The learned session judge shall be at liberty to impose such other conditions as may be deemed necessary to ensure the participation of the petitioners in the trial proceedings. Full stop. And the petition, the learned APP has submitted that the petitioner had earlier moved bail petitions before the courts of jurisdiction, which were rejected, and the ground of the delay in their production for remand had not been taken up therein. Abo? Tarpisot dibo, he has referred to the judgment of so and so paragraph to the disu. Etu dibo, thik ase. Aru, etu hol item number 70. Item number 71 of, item number 71 of, a additional PP to submission je agote bill petition move koriche hetu na lage. Okol prothomte di thwa kini dibo. To counter the same, learned counsel for the petitioner has submitted that this is the first time that the petitioners have moved petitions for bail, petitions praying for regular bail. And therefore, the question of their taking up this, of their having an opportunity to take up this ground on an earlier occasion does not and cannot arise. Done? Two disposals. Okay.
Deeply.
Sub disposal. Tinta mane bill pala jab. Gorchuk, Saurav Kumar, brother of Pandav Kumar. Yes.
My lord, here I have not received and found any my lord CD into when it was produced when from yes, my lord. I prefer tomorrow morning, my lord. If there any report, my lord.
Anyway, this certified copy would not be there in your hands by today evening.
No, this is the original record. So
I'm saying whatever order I pass, you would not have the certified copy today evening. You will not be able to apply. You will apply at 10:45 tomorrow.
But apart from that, other two
At the request of the learned APP, list again, kindly detail. Yes, what are other grounds?
Sir, there I'm informing him today itself. So that first is that merit of the case, Lord, that he was arrested on suspicion because those cartoons were kept in the bus station. He was a hired labor, Lordship. He was standing there, he was arrested. So how he is connected, that he has to answer. And second is that, Lordship, in the
He has
seizure.
to answer in trial. Yes.
No, that to get at 37 attract, Lordship, that they have to prove that I have the connection with the contraband. Lordship. And second ground is that in the seizure list itself, they have mentioned that they have drawn the sample at the PO, which is violation of section 52A. So that they have to answer.
Draw sample at PO. You
Yes.
can only test it there.
Yes. It is there.
Those testing kits, you can test it.
Taste it. But
Can
they
you
cannot
draw samples in the absence of a magistrate?
Seizure list they have mentioned it.
No, that is a sample for testing.
Hmm.
We'll give them the advantage.
They have drawn.
On those two grounds, I'll give them the advantage.
Take from the record if it is there.
Next.
Okay.
Tomorrow. Aloni Begum.
My lord, for the first time, my
Doctor.
lord, my lord, 106, 126, my lord. 103. At this stage, my lord, CD may be called for, my lord.
Huh?
CD may.
CD we can call.
FIR at place, my lord, 8, my lord.
Heard. Application under 482. Call for the case diary. List again on. From where?
7-9, my lord.
7-9.
7-9. 7-9.
Obliged.
Criminal petition 1180/26.
Yes, sir.
May it please your lordship. My lord, this case is a glaring example of, my lord, police atrocity and high-handedness, my lord. My lord, the petitioner before your lordship is an administrative officer of an university. Now, my lord, some dates are important to be noted, my lord, in this case, my lord, for proper execution of the case, my lord. My lord, may I kindly come to page 14.
Page
page
14.
14, Annexure 1.
Ah,
This is a complaint lodged by two girl students whose my lord, attendance were not, my lord, sufficient to appear in the semester. My lord, may I take your lordship through this complaint? In this complaint, my lord, there is no allegation against me. One professor was alleged to have sexually harassed them. That is the allegation, my lord. And I am not an accused, not, my lord, no allegation against me.
okay.
Then, my lord, your lordship may kindly come to page 16, my lord. Sorry, my lord.
The
Yes,
internal committee
page
takes up the matter.
Annexure
Then,
2. Annexure 2, my lord.
internal
This
com-
complaint was lodged before the ICC, my lord, Internal Complaint Committee of the University.
Yes, yes.
Then, my lord, ICC investigated, and my lord, their statements were recorded, and my lord, the accused persons' statements were also recorded. And in the meantime, on the same day, that is 15/6/2026, he was placed under suspension.
Okay.
That suspension order is at, my lord, page 3, my lord, Annexure 3, page 70. And in the suspension order, he was directed not to, my lord, leave the.
Then he gives his resignation.
Then
what
he
happened?
resignation, my lord.
Then what happened?
That time is to be noted, my lord. He submitted his resignation on the next day, that is 16 June at 8:37 a.m.
Morning.
morning.
Okay.
That time may be noted, my lord. Then, my
Then?
lord, by the Annexure 5, the, my lord, ICC passed the order and dismissed the complaint.
Okay.
I have nothing to say on that because I am not, I'm only to, my lord, I brought it record as a, my lord, sequence of events.
Okay.
Then, my lord, when that complaint is, my lord,
The complaint is dismissed.
dismissed by the ICC, Internal Complaint Committee.
Okay.
They found no evidence. And one thing we will observe in this case, my lord, your lordship may kindly come to page 21 of this, my lord, this ICC order. Second last, my lord.
Page 21.
Page 21, second last. The opposite party is also not examinable any further by the ICC as he has resigned from his services with ADBU, that means Don Bosco University, thus rendering any exercise by the ICC to arrive at a decision on the matter futile. And, my lord, the victims were, my lord, advised to go.
What is the allegation against you?
Then, my lord, the one of the two, my lord, that victims lost one FIR. FIR against that accused person.
Then?
That is at, my lord,
26, yes. Thereafter?
26. The content is, my lord, at page 30.
We've seen.
Here also there is no allegation against me. Now, what happened, my lord? On 15th of June, when that ICC took up the matter, in the evening, some student unrest took place.
After he resigned.
No, before his resign. In the evening.
Okay.
In the evening, on 16th morning he resigned. On 15th evening, well, there was a student mob. He in front of his official quarter. That is Dr. Saurav Chandra. Now he called the police out of fear for safety of his family as well as his safety. Police came. Police picked up them.
The students.
No, not students. The accused, Dr. Saurav, and his family. And I, being the officer of the university, I was also requested by the police that you also come to the police station. Accordingly, I accompanied. Now, till night of the 15th, there was no FIR, no criminal case against the accused
you,
person. Then in the night, police released him, released Dr. Saurav. Now they cannot release him so easily because they have picked up if anything happens. So what happened? I was asked to execute a bond by the police. Whenever he is required, you will produce him before the police. My lord, I was
resigned and left.
That I had to execute, I had to, my lord. So I executed that bond. I do not deny that. Then, my lord, what happened? This FIR was lodged in the night. FIR was lost, your lordship will kindly.
Now, because he has left, this Saurav has left, they have arrested you.
Exactly.
Huh?
Well, it's surprising. And Milord, and he has
And,
there, she will kindly see. One of the important thing, on 17th at, my lord, the FIR was lost on 16th at 8:30 PM. Overnight, they came to a conclusion that I am screening the accused person, and at 10 AM
Kindly,
on
sir.
17, I was arrested.
Sir, have a look at page 31, the FIR.
Yes, yes.
Mr. So-and-so does Mr. So-and-so. This man is arrested because has actively harbored, concealed and facilitated the secret evasion. He had resigned and gone. He was there in the university the night before. And then you say violated legal undertaking. From when is such action, persons can be arrested for such actions? By intentionally failing to produce Dr. So-and-so before the police.
And surprisingly,
He has been appointed as the home guard. House guard, I'm sorry, not the home guard, the house guard of the doctor.
and one surprising thing, your lordship will be surprised. Your lordship may kindly come to page 47, Annexure 11. On 17/6, I was arrested, and on 17/6, that accused person filed a petition before the court, praying for permission to leave the station.
And he got the court permission and he got.
Police did not find him. Police found me, but they did not find and he was appearing in the court.
So what is your prayer in this petition?
Quash, my lord, entire proceeding should be quashed against me.
Where is the proceeding there against you? Which proceeding?
That is GR case number, my lord. I have given the, my lord, you also may kindly
The
come.
GR case number is regarding him.
Yes, him, but I am made accused here.
No,
No, yes, my lord.
you are an accused here.
Yes, yes. I'm with the help of section 249C, which is a bailable offense, and my lord, the police arrested me, police produced him
Yes.
before the court with a prayer objection,
Are you
to
on bail now?
No, my lord, I'm on bail now. The magistrate on the same day released me on bail, because this is a bailable section, no? 249C is a bailable section. And why should I face the trial, my lord?
Mr.
Only my lord, the
Lead us, learned counsel.
memo in para 34, that the principal case involves in administrative misconduct, that is there, my lord. Some
What
Let him
misconduct?
lose his job. Who are you to go there? Huh?
my lord,
You will have a very difficult time, sir. Going into every university, finding out every person who's doing some administrative misconduct and then arresting them and keeping them in your.
it's available.
You will have no time for anything else.
Dr. Saurabh is not a bakri ka bachka, दौड़े और पकड़ लिए मतलब the famous dialogue of Sole Milo.
Heard Mr.
My interim prayer is
Didas.
at page 10, Milord. Interim prayer is at page 10.
Heard Mr. Didas, learned counsel appearing for the petitioner. Also heard Mr. K.K. Parasar, learned APP, full stop. এইটো ইয়াৰ পৰা লিখি দিব পোষ্ট এটলত আছে না এপ্লিকেশন আন্ডাৰ 528 BNSS praying for quashing of the proceedings against the petitioner in connection with Sonapur PS case number so and so কৰি দিব issue notice to the respondents
GR case number GR case number is 2315 public 2026.
Everything is here. The respondent number 1 is being represented by Mr. K.K. Parasar, learned APP, and therefore, should we send notice to the respondent number 2, or will you represent?
Well, by name, let's put a notice.
Let notice to go.
Therefore, formal steps on respondent number 1 is dispensed with. Extra copies within a period of 2 days. Petitioner to take steps on the service of notice on respondent number 2 by registered AD within a period of 5 days. Full stop. List again on. 25th of September 2026, full stop. Where is your interim prayer? What have you
Please,
prayed
dear
for?
Milord.
In view of the materials brought on record, comma, it is directed that the petitioner shall not be in any manner, the petitioner shall not be in any manner, that no coercive action shall be taken against the petitioner with regard to the case in issue.
So my prayer is Milord, the proceeding in
No,
here
we,
case number.
we cannot stay the
No,
proceeding
no, I
because it is
pray
not
for
against
entire
you.
proceeding. No, no, only against me, Milord. I do not pray for.
You may have to participate in the investigation.
Yes, yes, I will.
So we do not know. Once we say that everything stays, we are not doing that. We are saying that there will be nothing coercive against you in connection with this case.
No, no, Milord,
You
that-
want to participate, you go and
Milord,
participate.
I am already on bail. I was arrested. So that will not protect me properly, Milord.
They will misunderstand it. They
This
will
is
drop
not
the
a-
whole case.
My lord, even if presuming that I have executed a bond, I have violated that, there will be a separate case against me under section 249. But why should I face the trial of Milord, sexual harassment case, Milord? This is a case of sexual harassment, Milord. Absolutely illegal.
There shall
Milord.
be a stay of the further proceedings of the proceedings against the petitioner in respect of the if the case in issue. In case under reference, sorry. In case under reference, koi dibo, hobo?
GR case number 231.
GR case number likhi dibo.
We'll bring the
One
CD,
thing-
Milord, on 25th, we'll produce the CD.
Bring whatever you want to. I have issued notice to you. This is a criminal petition. Do what you want to do to try and say that this proceeding will continue against him. How can it continue against him?
Obviously,
Nothing.
much.
He's like a bailer, is it not?
Yes.
He gave an undertaking, he broke it.
You raised a different separate case for that.
Yes, madam.
Worship, 482 CRP application, worship.
We are short of time. We will not go for anything else. We'll just extend it.
Yes, worship.
Till when? Case diary. You are
case
required to
diary.
produce the case diary, sir.
CD, not CD from.
Learned APP has submitted that the case diary is awaited. List again on the 11th of September 2026.
Panbajar worship. It is
11th of September 2026. Interim order continues till then.
obliged. Until further, every day I have to extend.
Something comes up in the CD, we may yet recall it.
And then I recall lordship.
We will extend it on a daily
Nowadays,
basis.
very difficult. Every day we have to extend and give the certified copy to some of the lower court also. They asked next day certified copy you give. It is very difficult.
Clerks are earning something.
For me, that is different. Different, but
Let it be to the next day. We have not even gone through the record whether we can do it or not.
he is an advocate of the Gauhati High Court.
Is it? Till further orders kori diyo.
Let the CD come, Milord.
Let the CD come. Again, there is another.
11.
Till next date, yes.
Lordship, you will.
Madam, we are running short of time, madam.
Yes, Lordship.
31.
Obliged, Lordship.
Next date, till next. Day.
It is from interim lordship. It is not yet right. Yes,
Heard Mr. So-and-so learned counsel appearing for the petitioner.
interim.
Also heard the learned APP, full stop. In view of the submission made by the learned APP that the investigation has culminated in charge sheet number
48/2026, dated 3/04/26.
comma, there would be no apprehension on the part of the petitioner to be arrested in connection with the investigation of the case. Full stop. Accordingly, the AB is closed. Petitioner at liberty to approach the learned trial court if, as and when summons are received for trial. Any interim here? Yes. Same order. Same order will close it. Charge sheet has been submitted. CS number?
Charge sheet number 132/2026, dated 3/05/26.
34.
May I please, Lordship? Lordship, interim may be made absolute, my lord, otherwise because the case is session travel case, my lord, and I will get the notice from the, my lord, from CGM, my lord.
Everybody gets it.
This is not an interim, my lord, so it may be,
Huh?
or may give some time, my lord, I will appear and take the bail, my lord, from the
Here,
CGM.
1182.
1 month time may be given, my lord.
Just a minute, he's telling something. Yes?
1 month time may be given, my lord.
Two is there, Sassit one under section 1182. So, without going through the, can be said it is difficult.
Huh?
Without going through the materials, it is difficult, for us also. Otherwise.
He says it is sessions tribal, therefore.
And petitioner upon interim.
So
my lord.
we'll
Till the notice.
till he receives someone. I heard Mr. So-and-so in the council appearing for the petitioner. I also heard Mr. So-and-so and at APP who submits that the investigation has culminated in charge sheet number.
Sassit number 104/2026, dated 23/6/26.
Stuff the learned, in view of the above, the interim protection granted to the petitioner earlier shall stand extended, is made absolute, full stop. It is, however, it is provided that the petitioner shall appear before the learned trial court as and when summons are received in the event he is sent up for trials,
Oblige.
for trial.
May I please, Your Lordship?
Yes, sir.
It was called for. I'm on interim bail.
Hmm?
It is.
Available.
It is.
You are required to appear. If you
I complied with the last order, Lordship. Statement were recorded. I appeared before the.
Yes, sir. Partnership firm removed. Heard Mr.
Taluk.
Learned counsel appearing for the petitioner. Also heard Mr. Vishama, learned additional public prosecutor for the state. The petitioner has appeared before the investigating authority in pursuant to the directions given on 21/7/2026, full stop. The case diary has been received by the learned APP, full stop. Having considered all the materials placed before this court, comma, I am of the considered opinion that the interim bail granted to the petitioner on 21/7/2026 can be made absolute, full stop. Accordingly, the interim protection granted is made absolute. Anticipatory bail petition is disposed of.
Give your words. Give your words.
7:38. Respondent number 2, sir. Received. Let APP submits that the service on the respondent number 2 is complete. None appears for the respondent number 2 today. In such circumstances, yes, this court appoints.
Dr. P.
Agarwal as the learned amicus to assist the to safeguard the interest of the respondent number 2 oblique informant. Learned counsel for the petitioner shall supply copy of the bail petitions upon the learned amicus appointed today. Within 28/8/2026. Stop. List the matter again on 8th of September 2026.
The up-to-date TCR may be called for because, my lord, I have seen the charge sheet copy is not there, my lord, in the TCR.
It has been charge sheeted.
Only.
Then why this AB?
AB, my lord, before filing charge sheet, my lord, we file this AB.
Then we close this.
My lord, then also, my lord, we have to check whether she has been shown as abscond.
We'll say that now the investigation is complete. How can you be under apprehension of arrest?
My lord, if she is, my lord,
That will be for
shown
the
as
trial court to
absconding,
see. That will be for the trial court to see.
If she is,
Whether you are required to be, if you are an absconder and you are required to
if
be
she
kept
is
in.
shown as absconder, my lord, then my lord will consider the anticipatory bail application.
If you are absconder, we will not. In a POCSO matter, how can you be an absconder? What is your role?
Yes, sir. Absolutely, my lord, vague, my lord, there is, my lord, actually, there is civil dispute out of personal grudge, my lord, the present petitioner
Call
has
for
not
the
tracked
updated-
issue, my lord.
She is the main person.
Huh?
She was
My
the
lord,
main person.
allegation is that she is
Call for
white.
the scan copy of the TCR,
My lord, scan copy is the earlier, okay, my lord,
updated.
updated.
Call for the updated, call for the updated portion of the TCR. Scan copy of the updated TCR.
Here also, last occasion, CD was also called.
Which
for.
one?
CD also available here, my lord.
A CD is available.
My lord, only in the last occasion, my lord, in the TCA, only 183 statement was there, my lord. That's why Lordship was pleased to call for CD also, my lord. We have
Give the CD. We'll see on
Well.
7th. On 7th. Duke.
All right.
7, 8, 9, so available date pe 7.
Even
7, 9. 7, 9.
7-9.
So we available date pe 7, 8, 9. So. Yes, sir.
My lord, may kindly see page 10, my lord.
39.
This is a notice, it has come from Bharatpur district in the state of Rajasthan. My account was somebody hacked and thereby some transactions were made in my account. So I has asked me to appear before him to deposit, to adduce my evidence, if any, regarding the development of the investigation. Now, my lord, I am ready to go, but I apprehend that I may be arrested also, because from the notice it appears that I am witness mainly. But even then, we want a transit bail for some time, we will appear before the IO.
You will appear before the learned
IO.
court there to pray for whatever bill you want to.
No, actually, notice has come from IO. That's why we will appear before IO. Then if necessity arises, then definitely we will take bail.
So till the time of your appearance before the IO,
Yes.
give us the date.
Within 1 month, my lord. I am a poor man, my lord. So extremely poor man.
Yeah, a richer man would get lesser time or more time.
Poor man will get.
It is 26th. You appear before the IO on 24th. To remand, কি কয়? Transit bill. We are allowing it. We'll allow him to appear by
24th.
24th of September,
September.
to appear before the IO of the to appear before the
IO?
IO in
Institution house officer, police station, where?
to appear before the SHO, PS WEIR WEIR, huh? Page 10.
Yes, 10.
Habo? District Bharatpur, Rajasthan, huh? By Kinima
Highly obliged.
Mr. Pre-arrest bail, my lord. The FIR, your lordship will find at page 14, my lord. And this time I am not taking the risk of translation, my
Page 14.
1-4, my lord. Here, my lord, lordship will see, my lord, Assami. My lord, I am number 3, Minazul Haq, my lord. সন্মান সহকারে জনাও যে ইংৰাজী ইমান তাৰিখে আবেলি 4 বজাত উক্ত আসামীকৰণে পুৰাব নিম বুলি পেলাই নানান প্ৰলোভন দি ফুচলাই ঘৰৰ পৰা মোক 4জনীয়া গাড়ীত উঠাই উক্ত 1 নম্বৰ আসামী ঘৰলৈ আনি পাছত উক্ত আসামীকৰণে জোৰজিল চৰত লৈ যায় বলপূৰ্বকভাৱে মোৰ লগত মোৰ ইচ্ছাৰ বিৰুদ্ধে উপৰ্যুপৰি শাৰীৰিক সম্পৰ্ক কৰে. Well, this is the allegation of, my lord, gang rape, my lord. Now, my lord, my instruction is that, my lord, the victim, my lord, the informant had been married to the accused number 1, my lord. My lord, and when he went to his house with his wife, my lord, they refused, my lord, to accept it, my lord. My lord, my submission will be, my lord, lordship may kindly have a peruse the statement of the Rijul Alam, my lord.
Huh?
Rijul Alam, my lord.
Just a minute.
Maintainability, my lord. My lord, using the case diary, my lord, lordship will see whether it is maintainable or not.
482 subsection.
My lord, the
No,
fact is that, my lord, the
If
main.
there is an allegation, can we
Yes, my lord, that's
proceed?
why. My lord, what happened, my lord, the main accused, my lord, who was arrested, my lord, the very next day, he was granted bail, my lord. As
Oh,
because
that
he
is
is a
another
ma-
issue.
My lord.
That is another issue.
You
But
understand, my lord, it's a maintainability regarding, my lord.
day before yesterday, yesterday we have rejected one on the grounds of maintainability.
Probably criminal petition to file kora bhal.
482(4).
Yeah.
It is there, but one thing is.
The section is not here.
Section 70.
70, a barred is 70 subsection 2.
This is section 70,
Section 60,
subsection 1.
Section 2 of 70. Here 71.
71.
is
Oh.
important point. Well, my instruction, my lord, if a lordship goes through the statement of my lord that if she is got
Yes.
married with,
My lord, sufficient materials are here, my lord.
no, that I understand, material will be there, my lord.
My lord.
My submission is that, my lord, the victim got married with accused number 1. And the accused number 1 got bail because he is the legally married wife, my lord. His statement, my lord. That much, my lord, nothing more submission.
Follow the এক নম্বর।
Yes.
Ribul.
Ribul Alam statement to Asali be Asa, I didn't know.
Lordship kindly pay this statement.
Accused Ribul, Merajul, Minhajul, Zahirul, Ikramul, two Zahiruls.
Yes,
Okay. Huh.
I am Minhajul, my lord. The statement word is. No, solid statement word. We were never. Huh? Words. 2 times. It is clear. Like a point one.
That marriage part is not.
My lord, what I have been instructed, my lord, the victim statement has been recorded twice, my lord. First, while filing the FIR, my lord, later on she gave my lord another statement where the accused number was granted bail, my lord. Or let him go through the diary, my lord, minutely. I have no problem.
We'll have it on Monday.
Monday, my lord.
Huh?
That is the only submission, my lord.
Whether she has been,
Deposed
her
twice.
statement has been recorded.
But I have found 180.
Huh?
And that I don't know.
No, go for it. I have been instructed wrongly. Order to.
Victim Samim Begum. One is in handwritten and one is a type copy.
Maybe my lord.
Hmm?
And in the meantime, my lord, I'll produce the bail, my lord, order passed on behalf of my lord Ribul Alam.
Yes, Monday. We'll have it on Monday. Whether they have now got married, that is what the Supreme Court had feared. এখন দি দিয়ক ঘূৰাই। Is it not in some judgment it was recorded? First a POCSO matter, then marriage.
Yeah, settle.
Huh?
Settle. Yeah, settlement.
List again on 31st of
I'm all right.
August. In such type of cases, the compensation paid should be
My lord,
recovered
imposed by-
back.
Heavy cost may be imposed.
And the
putting
victim,
the entire system to run.
victim is already a married woman and having a 2-year child. This is a second marriage.
Yes, sir.
Wait, please, Your Lordship. My lord, CD was called for, my lord. My lord, the total cows is 30. And I have given the money receipts, my lord. I am the purchaser of the cow.
They were your cattle.
My lord. So, my lord, here allegation before your lordship, case is registered under 302 VNS. So, my lord, it is regarding stolen, theft. And another section incorporated, my lord, it is regarding the keeping the stolen property. Other sections, my lord, that cruelty, that invited fine only. So cow is seized, my lord. Vehicle seized. Now, my lord, your lordship will consider the point whether my custodial detention is necessary, because everything on record.
Otherwise, the vehicle carrying 30 numbers of cow, 21 of this petitioner and 9 of some other persons.
Two petitioners are there.
Oh, yes, two petitioners.
Two petitioners, my lord.
Petitioner number 121 cow, he is the owner, and 9. In the paragraph 3, he himself mentioned the petitioner entrusted the task to transporting the cow to the driver. Now, the cruelty parts, veterinary officer statement also there, that is there. Without any
Without any documents.
documents are not produced, and 30 numbers of cow
In one truck.
in one truck, and out of the 30, few were found injured. 6 were found injured because of the
We also have to remember that we are sitting in bail jurisdiction, not trial. So 30 cows together, if proved against him, he will face the consequences. But as of now, do you need a custodial interrogation or not?
custody.
Huh?
Custody or he is the owner.
We'll dispose it of, or we'll allow him to appear and call back. Dispose it of. Heard Mr. So-and-so Learned Counsel, heard Mr. Sheikh Learned Counsel appearing for the petitioner. Also heard the Learned APP. The case diary as called for in Sangsari PS case number 176 of 2026 has been received. The petitioners shall appear before the investigating officer on or before the 11th of September 2026 to along with all necessary documents to be produced on their behalf to participate and cooperate in the investigation. Full stop. In the event the petitioners appear before the investigating officer on the date aforesaid, on or before the date aforesaid, the petitioner shall be released on bail on furnishing a bond of rupees 10,000 each, with one surety of the like amount to the satisfaction of the arresting authority. Full stop. In the event of the failure of the petitioners to appear before the IO as per the date fixed, the privilege granted by this order shall stand recalled. AB disposed of.
Commercial quantity, Lordship, FIR is on page, Ejaar is on page number 10. Lordship.
Not the FIR, Ejaar is on page.
Ejaar. For the purpose of the story, Lordship, according to the allegations or instructions of the police, they received some confidential information that Swift Desire with such and such number under Nagaon was carrying some drugs, and the petitioner was doing the operations of the same. Then they went ahead, went to the location. Then accordingly, as per them, the petitioner fled the scene. They searched the house, did not find anything. Then later on, a car was parked in the backside of the house premises, which they searched. Later on, from that, the suspected methamphetamine was established. Now, their case is that nothing was found in the house. Accused was not present, but they have said we fled, whatever the case may be. But the car in question, Your Lordship, we have clear instructions that the car does not belong to us. It in fact belongs to Inamul Haq. I have also brought out this is as per our instruction. If in any case we check the ownership or the vehicle is registered under the name of this, the name is blurred because of privacy reasons. You need the number of the owner to access the information, but it is apparent that it belongs to some person named Muhammad Inamul Haq. The rest, we are only implicated because we have criminal antecedents, which we have accepted in our petition. 4 cases, 1 we are acquitted, 1 we are discharged, 2 are pending. So that is why they have, initially they have maintained that a previous drug peddler.
To search the car, otherwise someone has to give the key or it has to be broken. So seizure witness the main vital part. Seizure witness is the Gauhati Bani. 3 persons were there. I am reading only one Gauhati Bani. Likha by Duiman Bajat, and it is led during night, led by DSP. DSP Dipsina Sara Logot, eta dol ahi muk Gauhati Bani mul logot dujonok মাতি লৈ যায় তেওঁলোকে নাম্বাৰী মনিটৰিং উলফে ইনফৰমেশ্যনৰ ঘৰত ড্ৰাগছ সৰবৰাহৰ তথ্য আছে গতিকে আমি ঘৰ তলাচি লগ কৰিব লাগে আমাক দলটোৰ লগত কিবা আছে নেকি তালাচি ল'ব কয় আমি গাঁওৰক্ষী বাহিনী তিনিজনে আৰক্ষী দলটোৰ তালাচি লওঁ আৰু কোনো বস্তু নোপোৱাত আমি আৰক্ষী দলটোৰ লগত মনিটৰিঙৰ ঘৰলৈ যাওঁ মনিটৰিং দীৰ্ঘদিনৰ পৰা ড্ৰাগছ সৰবৰাহৰ লগত জড়িত হৈ আছিল কিন্তু আৰক্ষীৰ উমান পাই মনিটৰিং কেনেবাকে পলাই যায় পাছত আৰক্ষী দলটোৱে মইনুদ্দিনৰ মাক আৰু ভাই বোৱাৰীৰ সন্মুখত তেওঁলোকৰ অনুমতি সাপেক্ষে তেওঁলোকৰ উপস্থিতিত মইনুদ্দিনৰ ঘৰৰ ৰুমৰ তলা ভাঙি ঘৰটো তালাচি লয়
একো নাপায়
আৰক্ষীৰ সময়ত গাঁওৰক্ষী বাহিনীৰ সদস্যসকল উপস্থিত আছিলো গোটেই ঘৰটো তালাচি লৈ মইনুদ্দিনৰ ঘৰৰ ভিতৰত আৰক্ষীয়ে কোনো ড্ৰাগছ নাপালে কিন্তু মইনুদ্দিনৰ গাড়ীখনৰ চাবিটো ভিতৰতে পায় গাড়ীখন বিচাৰি তাৰ ঘৰৰ চৌহদৰ পাছফালে থকা মইনুল ইছলামৰ ঘৰৰ কাষতে পায় আমাৰ সন্মুখতে তালাচি লৈ গাড়ীখনৰ পৰা 449 grams drugs.
But the same does not find any mention in the FIR lodged by the police themselves. That they say that they offered, as they declined search in presence, during search, no narcotic substances found, so inquired for the vehicle and found parked besides. Accordingly, search was conducted.
Regular search, and now
so if the police itself found the keys, that would have found
that is for the witness to prove. We do not, everything will not be there in the FIR, sir. You also understand.
But Lordship, prima facie is that the car does not belong to us.
Dealing with two trial is going on.
That is not enough to implicate.
Is it a commercial quantity? No. 37 has to be there.
37. Yes.
I am not being able to bring myself to believe that you may have an acquittal somewhere.
There is, Lordship, in 4 cases, 1 has been acquitted.
I am not being able to convince myself that in this case you will go for an acquittal or that you will not involve in similar offense in the near future. Not this time. Heard Mr. Swenson, learned counsel looking for the petitioner. Also heard Mr. K.K. Parashar, learned counsel, learned APP, full stop. Case diary call for has been received on the perusal of the materials on record. I am not satisfied at this stage that the rigors of 37 can be met with to grant the petitioner the privilege of an anticipatory bail. So accordingly, the prayer for anticipatory bail at this stage is rejected. After you can get the car transferred, then you come back. মুখে কৈছে কাইলৈ লিষ্ট কৰিব মইতো শুকুৰবাৰ লিষ্ট কৰিব কৈছিলো মুখে কৈছে যে আজি লিষ্ট কাইলৈ লিষ্ট কৰি দিম বুলি ৰাতিপুৱা আহি মোক খবৰ দিছে হয়নে মইতো শুকুৰবাৰ কৈছিলো একো নাই শুকুৰবাৰে কৰা মোৰ একো দিগদাৰ নাই কনভিনিয়েন্স অফ দি কাউন্সিলটো লৈ ল'ব এজন বাহিৰৰ হয় এজন দিল্লী সুপ্ৰিম কোৰ্টৰ হয় 7:30 লিষ্ট কৰি থব তাৰ বেলেগ কেছ থাকিব স্পিকেনটোত আহিব টান পাব চ' কনভিনিয়েন্সত ল'লে হ'ল অকণ মানে ৰেজিষ্ট্ৰীয়ে তেওঁলোকৰ পৰা লৈ ল'ব ৰেকৰ্ডেড কাউন্সিল যোন আছে তেওঁ ক'ব যে কেইটা বজাত ভিচিটোৰ কাৰণে কমফৰ্টেবল হ'ব ভিচিটো নহ'লে নাপাবও পাৰে নহয় Friday কৰক VC লওক তেওঁলোকৰ কনভিনিয়েন্সটো সুধি accordingly before lunch after lunch will happen.
Lordship, I am for the respondent
please.
number one for, I appearing for the respondent number one.
Hmm.
Today we have received a soft copy of the petition. I have to receive the instruction from the respondent number one.
Why is it taking you 2 years to receive the soft copy?
Lordship, actually, we have filed the Wakalat number on 2025, actually.
You did not give copies.
Lordship, along with this.
Anyway, any interim, any
He was
interim?
there the first day, your Lordship. So
There
that
was
and
there is an interim. We'll have it in the 23rd of September. List again on the 23rd of September, comma, by which time the respondent would be at liberty to file their response to the present petition. Ms.
interim may be-
Bora,
interim may be extended, your Lordship.
Ms. Bora and the council appearing for the petitioner is present. Interim orders passed earlier continues.
Thank you, please.
May I please, Lord?
Yes, sir.
Under section 4 POCSO, it's my lord 10 years conviction. And my lord, today I have a prayer for suspension of the sentence and my lord seeking bail, my lord, bail. Now, Lordship, I just want to show that prima facie satisfaction that whether section 4 comply with or not, my lord.
Have you filed your objection to the petition? Why not? Matter of 25.
My lord, here. Lordship, see that prima facie shows it does not attack section 4, page 30 say medical report. my lord.
There are some difficulties, sir.
But in the last, after 1 year, it was listed, man.
But
After 1 and more than.
what about the service of notice on respondent number 2?
That is also not matter. I have.
Have you taken steps, sir?
Yes, my lord, we have taken.
Taken steps?
Yes, my lord.
I think you'll have to take fresh steps because last time it was taken was on 14/5,
My lord.
2025.
2025.
They will not be able to trace out the
My
record.
lord, no. We'll take.
This matter has been listed. No, steps had been taken by the petitioner in this matter for service of notice on the respondent number 2 on 14/5/2025. The service report is not available as of today. In such circumstances, the petitioner, the appellant, no, fresh steps shall be taken upon the respondent number 2 within a period of 1 week, no, within a period of 3 days.
My lord.
As per the prevalent notification, full stop, list this matter again on the 15th of September 2026 along with service report. In the meantime, the APP shall file objections, if any, to the interlocutory application, praying for suspension of the sentence.
Deeply approved.
Well, Lordship. Pleadings are complete, Lordship. Matter may come up for final disposal, Lordship.
When?
Any date, Lordship.
Any convenient date, sir?
Lordship, family, my lord. Only my lord, since the delivery of the judgment in the lower court, my lord, and also the case is pending here, I have not been paid any single amount.
No, no.
Till now, my lord. Till now, my lord.
No, no, please.
And that is the difficulty, my lord. Only my lord, the Honorable High Court has passed an order directing payment of rupees 10,000 to my daughter, which has been paid, but which is also not regular. Last two, but orders of previous order, it is reflected there, my lord. Which would imply that, my lord, and they have also misled the court.
Heard Mr. Chauhan, learned counsel appearing for the petitioner, also heard Mr.
S.S.A. Rahman.
SSA Rahman, learned counsel appearing for the sole respondent, full stop.
My lord.
Mr. Rahman has submitted that the petitioner has not been regularly paying the maintenance agreed to be paid to the daughter of the parties, full stop.
My lord.
List this matter again on 18th of September 2026, not 18th, 24th of September 2026. Full stop. The learned counsel for the petitioner shall produce before this court the receipts,
I've already.
the proof of regular payment of interim maintenance to the child of the parties. Full stop. It is also made clear that by the next date fixed, any arrears due to the child of the petitioners is required to be cleared, failing which, was there any interim order?
No, Lordship.
They are interim order, my lord.
Lordship,
On a
I have
court
enclosed,
order.
I have filed the additional affidavit, Lordship. I have enclosed the orders of the trial court, Lordship. I have
Okay.
regularly paying, Lordship.
No, my lord.
It is last order is of 13/5/2026.
13/5 to the, yes, sir.
Yes, my lord.
Yes, I have enclosed the orders, Lordship, from
Yes, my lord.
9/2/2026.
But I just want to bring to your lordship.
List again on what did you say? 24.
117, 12/3/2026.
Oblige the Lord.
They have not paid the amount.
12 they have not paid.
My
Yes,
lord.
12 paid.
I have enclosed the documents, Lordship. It
Paid.
is there on record.
Paid, it's a daughter, paid. Your daughter, paid.
I have already paid. I have enclosed the documents. Lordship. That is on record, Lordship.
Obliged.
Yes.
Oblige.
16 minutes, the TCR may be called for. Here with the.
Heard the learned counsel for the petitioners call for the, why should the entire TCR or what?
Lordship, the TCR may not be required at this point.
Why?
It is a revision petition, Lordship. In it, Lordship, with even the impugned order, the reasoning of the trial court, reasoning of the learned district judge is quite clear. And there is no apparent error on the face of the record which requires the TCR to be called. The revision petition may be dismissed, Your Lordship, in that. The petitioners have failed to at any point show the error.
But the trial court initially, my lord, sentenced for 3 months and my lord, 35 lakhs compensation in fail. My lord, 1 month is another assignment.
Increase to 35
And
lakhs.
Now the appellate court, my lord, modified the order and only, my lord, the 35 lakhs compensation may be paid. And my lord, in fact, my lord, here it will take some more time because my lord, the respondent number 2, fine, gave
What
me
was the
loan.
original amount involved?
My lord, actually, my lord, his
25 lakhs.
25 lakhs.
26 lakhs.
26 lakhs.
26 lakh cash or check, it is not even disclosed, my lord. He said that I have given a loan to him.
Then how come a NI case?
Lordship, the amount was repaid back via check, which was dishonored.
Ah,
Lordship, the source of
But
fund.
initial.
your check has bounced.
Yes, Your Lord.
Yes, my lord.
What more is required?
My lord, his case is that he did not issue the check, my lord.
Lord,
35 lakhs, 26 lakhs check you do not know.
But my lord, when he gave me loan, my lord.
Not
As he said.
necessary. Did you give him the check?
But initial
The
transaction.
presumption has to be yes.
Lordship,
You
there
give a
is-
check, it is. And because of this revision petition, you have paid nothing.
No. And I have no interim also. my lord.
Where is the interim?
Interim is not here.
Where is the interim?
Interim is not allowed, my lord. So I am not paying for interim also today. my lord.
You need not. You are looking at this case and you are not paying him anything. We are dismissing it. Pay him, huh? This will not go on. 22nd of September, list again on 22nd of September,
Lordship.
where an
we have
attempt would
25th.
on the 25th of September, when an attempt would be made to dispose of this petition, full stop.
Yes.
It has been submitted at the bar that though the orders of the learned appellate court was for payment of rupees 35 lakhs.
Yes.
No sum has been paid to the petitioners, to the respondents till to date.
Yes.
Accordingly, respondents have prayed for an early hearing of the matter.
Yes, my lord.
Deeply obliged, Lord.
Yeah, please, Your Lordship. Lordship.
What about the confiscation proceedings, sir?
Your Lordship, the proceedings have started now. I have the instruction from the.
Yes.
Yes, Lordship.
No
as per the
question of
section
Jima.
75 and as a provision, Lordship, if the owner is not aware of the vehicle, the driver is using it, Lordship, then vehicle cannot be confiscated as per section, Lordship, 74. Clause D, Lordship.
Kindly go and have the confiscation proceedings stayed or quashed. We can consider the Zima petition. You can have a copy. Do you have a copy of this?
No, no, no. I don't know.
Give him a copy. Learned counsel for the petitioner is granted 2 weeks' time to have instructions on the submission of the learned counsel for the respondents that confiscation proceedings have been initiated with regard to the vehicle involved in the present litigation, full stop.
But they will file
Placed
affidavit.
again on 18th
In the
of September,
shorten will be given, Lordship.
11th of September.
Lordship.
There is a confiscation proceedings going on.
Lordship,
I can have this closed.
Yes, Lordship. But as per the.
And in the
Section
next
74.
3 days, do you actually think that you will be able to get it set aside or cost or
Lordship,
interfered with?
As per the provision of this section 74.
Go and convince it there should be no confiscation, only then I can do something.
No, we can challenge this constitutional proceeding before this
Please do.
also. Lord. We'll file an affidavit challenging this. Lord.
You file an affidavit challenging it.
No, Lordship,
You asked for 11th, we have given you 11th of September.
Lordship.
Next, Kiman. 61. Yes, sir. Instruction.
Instruction, your lordship. If a lordship will give the bank guarantee, then no problem.
Huh?
Bank guarantee, your lordship, in the last occasion, your lordship asked me to take instruction from my client.
Bank guarantee, you are agreeable. Yes, sir.
Lordship, one instruction I have received, my lord. That the money is deposited with the treasury, my lord. Regarding confiscation, there is nothing in the.
Huh?
Regarding my confiscation, there is nothing in the instruction, my lord. But my lord, one thing, my lord, if they could show, my lord, whether because along with the narcotics, the money has been seized.
Would you burn the money?
Money has been seized, my lord.
Would you burn the money in case you confiscate it?
No, no.
What is done to the money?
No, I'm not on that. I'm saying, my lord, that along with the money and narcotics, it was recovered, my lord. If you could show that the money is not from this position, the source of income, my lord.
Along with
that
They are giving a bank guarantee for the amount.
bank guarantee, my lord.
The moment you find that this is the money involved and you require the money, invoke the bank guarantee, take the money. That is what a bank guarantee is.
Not it. That is what my submission. Because they cannot show, my lord, whether from what is the source, my lord, how 2 lakhs rupees came to him at that time. Not so it, as it is, my lord, ascertain, my lord, giving when Dimma is given, my lord, they have to show that at least they owe it, my lord, their source, or my lord, any, if it is.
What is your source? What is your source? He has
regarding
appointed.
source, your lordship, I have given.
What? It was taken on loan 2 days before from
No.
the uncle.
By selling, your lordship,
Might be, my
cattle's,
lord,
your
I-
lordship. This amount.
By selling?
This amount was collected by selling cattle's, your lordship.
Where is the
And the
receipt?
cattle receipt I have given page 1114, your lordship.
Page
Page 1114, your lordship.
11 to 14.
14.
55,500.
And from the possession of the petitioner, no contraband was recovered, your lordship. That.
Contraband, that's the cattle, I think.
No, not cattle.
Yes,
Tracks,
sir.
tracks was recovered from some others. your lordship. And on the basis of a statement of the co-accused.
They came to your house and seized the money.
Money,
The
here.
money, my lord,
Money,
the money.
pankat and.
Yes.
They have placed the.
He has given some source.
They are placing the.
What is the amount?
2 lakhs rupees, my lord. 2 lakhs.
$65,000 and 55,000. 55,000 and 55,000 is 1,10,000. And 90,000 available just like that. Okay.
As per the
Yes.
impugn order, my.
Hmm?
Is there?
You want to verify this receipts?
Lordship,
You want to verify the receipts?
receipts, my lord.
Tell us. We'll try to finish as soon as.
Whether my lord can be my lord sent back to the my lord trial court, they will verify the receipt and if it is, that can be done.
Not
Disposing
without
of,
verification, of course.
disposing of the petition.
Yes,
Herein, your lordship,
we will send, we will ask the learned trial court
Yes.
to verify the receipts produced by you before this court, which you will produce in original before the trial court.
Lord.
And also that you are ready to give the bank guarantee. In case the money is found accounted for and the bank guarantee is reliable, trial court would release it to release the money to you.
Not,
I have no problem, but it will again take time, your lordship.
It is not, can I say the release the money? I do not know. Can I find out this receipts and all?
Because the petitioner, he is ready to give them bank.
He will
guarantee.
do so and he will give these receipts showing that
If
this
any
is the
moment,
source.
your lordship, if any moment, your lordship, it reveals that the money is connected with the drugs, your lordship. Of course, you will.
That is what he will have to take into consideration.
yes.
Yes. Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard the learned APP full stop. The present petition has been filed praying for interference with the order dated 27/11/2025 passed in special narcotics case number 56 within bracket M of 2024 by the learned special judge Bongaigaon, Assam. Insofar as the prayer of the petitioner for Zimma of rupees 2 lakhs seized in connection with MR number 167 of 2022 in connection with Manikpur PS case number 193 of 2022 under section 21B/29 of the NDPS Act had been rejected. Full stop. The learned counsel for the petitioner has submitted that the money which had been seized and of which Zimma is being sought is unconnected to any drug trade and had been earned by the petitioner by selling his cattle.
Yes.
Full stop. The learned counsel for the petitioner has submitted that he is under instructions that the petitioner is ready to furnish bank guarantee for the amount in issue in case the aforesaid amount is released to him and at a later stage, the money is found to be connected in any manner with the trade of contraband drugs. Full stop. The learned APP has submitted that the matter may be remanded back to the learned trial court to verify, if so required, the different money receipts which may be produced by the petitioner and thereafter a decision may be arrived at as to whether the bank guarantee would suffice the bank guarantee would suffice for the release of the seized money. Full stop. Having heard the learned counsel for the parties, I am of the considered opinion that the petitioner be granted the liberty to approach the concerned jurisdictional court, bringing on record the manner in which the money had been earned by the petitioner and further to place place the proposed bank guarantee before the learned court. So, learned court full stop. On receipt of an application along with the aforesaid information, the learned trial court shall take into consideration the veracity of the money receipts produced and the bank guarantee, and thereafter consider release of the thereafter consider giving Zimma of the aforesaid amount to the petitioner under such conditions as may be deemed fit. Criminal revision petition
report
accordingly
receipt
disposed
may
of.
be kept part of the record.
Hmm?
Report receipt may be kept.
The report which has been received, the learned APP,
Report from the IO.
the report
Third
received from the IO is kept on part of record, comma, which states that the investigating agency would have no objection to release the amount on Zimma in the event the accused is able to establish lawful and genuine source of the aforesaid amount.
More orders, 44.
I have filed by the college.
They have given us the notices.
Yes.
They have given us the notices sent by registered AD to the addresses which were given in the application forms. Now, any further tussle required? No further pull and push. What does it say? Very well, that no one got the call letters. Yes, no one got call letters. Now with this affidavit on record, anything remains. One candidate appeared because others were sent letters. No one appeared, and these addresses are not half addresses. Huh?
Address is full.
Who had filed that complaint? Name? Any name? We'll allow the I today to and take on record the different notices which has been submitted. We'll take on record the different notices which has been submitted. We'll allow the I for today. We'll take up the writ on some other day and dispose it of. Heard. Mr. S. Dr. Learned Senior Advocate is assisted by Mr. S. Dr. Learned Counsel appearing for the petitioner. Some other name? Yes. P? As Senior Advocate S. Dr. assisted by Madam on as petitioner counsel for the applicants. Full stop. The Mr. S. Not appears for the respondent number. Oh. You didn't even make him a respondent. Opposite party. Appears for the writ petitioner. Mr. Tohidlar appears for the Department of Higher Education. Full stop. The present application has been filed to bring on record the postal receipts of the call letters sent to the different candidates for the interview in issue in the parent writ petition. Full stop. It has been prayed that the postal receipts be treated as a part of record in the writ petition. Full stop. The prayer is allowed. The postal prayer is allowed. Learned Counsel, the applicants shall file an affidavit along with the postal receipts in the original writ petition for the convenience of the court. List again on 22nd of September 2026, on which date the writ petition shall be taken up for disposal, since the pleadings are complete and all material required have been made available on record. Is that Hagil? Huh? Any
May I please your lordship? Lordship, this matter may be fixed for hearing.
on?
Any date may be given in the past.
Mr. Biswas, you come, your.
4 minutes, October, first week of
No, my
October.
lord, I have objection in this regard. On the last occasion, they took time without taking our consent, my lord. And the main thing is that, my lord, the FIR lost in the year 2011. Thereafter, in the year 2019, the Honorable Session Judge issued summon under section 319 of the CRPC. Accordingly, they had approached before this Honorable Court, and by misleading this Honorable Court, they took stay, my lord.
Don't say misleading.
And
I have got objection. He's
and-
saying misleading. Young
yes, I
boy,
have-
he is saying misleading.
On-
I have not misled the court.
On the hearing date, I will explain how they have misled, my lord. And on each and every date, my lord, they took, they took
Even
time.
after being advocates, we still remain human.
You are
Don't we?
appearing on behalf of whom?
We still remain human.
You are appearing
Don't
on
we?
behalf of whom?
So some statement when an objection is taken by a senior person,
Yes.
the best we can do is, I apologize,
No,
but
no, no.
it was not a correct statement made. That can be done instead of,
Yes, sir.
we don't know, it's up. After all, it's the bar.
Yes,
We
sir.
don't know how you
And
do it.
my lord, the trial court already, evidence was already done.
You are appearing for whom? Please tell me first.
I apologize for.
No, you are appearing for
For
whom?
whom?
For
Respondent
respondent
number?
2.
He is no more. He
Is
is
it?
no more.
Yes, no more. I have filed on substitution petition in the year 2030.
Where is the substitution?
On the last, on 28.
Is
this
it
honorable
here?
court Allowed, yes, already allowed.
Okay.
On 28/4/2020.
Have you filed the,
Substitution petition I have filed.
have you filed the amended cost title?
Yes,
It has been filed here?
yes.
Here in this petition?
No, but it was not substituted
maybe
in the
it was
record.
not in the record, but I have already filed in the
Okay.
section. And on 28/6/2026, this honorable court allowed the substitution petition.
Mm.
And accordingly, the IOA was disposed of. And my prayer is that our name has not reflected in the cost title, cost list.
Mm.
So that may be allowed.
Okay.
That direction.
And we will take it up,
Thought date may be given, my lord.
we'll take it up on the 24th of September.
I have got object.
24th of September. We are trying to,
Hearing date,
it's a hearing.
obligement.
Heard learned counsel appearing for the petitioner, Mr. S.C. This was also heard. Your name is?
Eke Hanuman.
Who has submitted that the petition for substitution had been allowed on
28/4.
28/4/2026, and accordingly a amended cost title had also been filed in the matter. However, the same are not found on
It was not
record.
filed, amended cost title.
The learned counsel shall the registry to trace out the same and bring it on record in the event there are no objections to the same, full stop. There are no filing defects, full stop. Objections nahi likhi ho, full stop. List this matter again on the 24th of September 2026 for hearing.
Hello.
কি এখন ডিলে বুলি ক'লে নে এলাও কৰিলে বুলি prayer for substitution এলাও কৰি থৈছো
May I please, Lordship? Lordship, although I took step, Lordship, that was returned back, Lordship. Lordship,
it was returned back.
returned back, Lordship.
Send it again.
Lordship, as per instruction, Lordship, I got the new address, Lordship.
You have got the new
New
address.
address, Lordship.
Then a counsel for the petitioner has submitted that the new and correct address of the respondents have been provided to him, and therefore he prays for some time to take fresh steps on the respondents, full stop. Accordingly, list this matter again on 23rd of September 2026. The petitioner shall take steps for service of notice on or before 3rd of September 2026.
Obliged.
Yes, Ms. Chaudhary.
May it please your lordship, on the last occasion, there was an order passed, lordship, to ascertain the address of the respondent number 2 to the learned PP, lordship, on 10/8. Order to on the mobile dates. We have taken only.
Any report from the Thupri? Yes?
2-3 times we have taken step, lordship.
Huh?
And lordship, in this case, what happened, the BN College output police called me, lordship. He got my number from the petition itself, lordship. Then he called me, help me, you give the accused number so that we can confirm the address of the victim, lordship. Thereafter, I have given the address, phone number of mother of the accused, lordship. Then they contacted, and thereafter they obtained the number of some uncle of the victim, lordship. Then they contacted, they said that she is living in Gauhati, lordship. But she is denying to take the step, lordship. She is a major, lordship. It's not a POXO case, lordship. 376.
We can take one last attempt to have her serve through the.
Oh, lordship, may I request you,
The trial
lordship, may I submit that an amicus may be appointed in this case?
Unless we get a report that she is refusing or she is not traceable.
Lordship.
You are asking for a stay of the
Stay
trial
already
court
given,
proceeding, huh?
already given, Lordship. There is an order 26/3/2026 in IA, Lordship,
The I
1358.
for me.
1358.
Correct.
IA is also there, Lordship. And stays until further orders, Lordship. But Lordship, the
Miss
petitioner
R.
is
Chaudhary,
suffering.
Miss R. Chaudhary, Learned Senior Counsel, appearing with the assistance of,
E. Murtaja.
for the petitioner has submitted that uh, there have been some indications that that the respondent number 2 is presently residing in Gauhati and not at Dhubri, and has been avoiding service of notice, full stop. The learned APP is requested to have the full details from, to collect the details from the learned counsel from the petitioner and attempt to have the notices served at the known address of the respondent number 2 in Gauhati, if any, and submit a report.
First, they will have to provide us.
They will provide. They will provide you the address, have an attempt there. Get us a report that she is not staying there.
Numbers, Lordship.
Huh?
I can give the phone numbers.
Not
And-
only phone numbers.
No,
How
at least you
will-
can find out.
How will,
No, they will find out in front of you.
my lord,
Your
Lordship.
counsel can assist.
my lord.
Lordship.
Assist him. List again on 17th of September 2026.
Like, right.
It will last matter niki. Now, who will have mercy on whom for the day?
Your lordship has on us.
Lordship mercy. is required.
But this is a leave.
The
Leave
leave
to appeal.
petition and delay condonation is there.
Are you actually objecting to the leave?
Yes, I have to object. Not so far as, but in the record, my lord, I've seen that there is no delay condonation.
No, but it is here.
Actually, there has to be a delay condonation application.
Only for 10 days, your lordship, because of the.
For a
appeal.
day also, madam, we'll allow it on the spot, but there has to be a petition. Even if we grant you this
But
leave,
we have already filed.
we don't have it on record.
The record says I've checked. my
Do you
lord, it
have
says there
any
is-
number
there is
of
no
it?
delay.
Any number?
Yes, your lordship today.
What is what is the IA number?
Yeah, number is there.
Criminal LP 9, criminal appeal
ये number नहीं लिखा।
1287.
There is only a leave petition, my lord, and there is in the observation is there is no delay.
हमारा डायरी में था।
Where is the observation?
But in the appeal, my lord, where they have,
मोर डायरी to आना सो।
There is no delay.
no, there has to be a delay of around 10 to 15 days.
Learned.
Yes, criminal, this is LP is there. One
There is no IA.
criminal. But I am.
Criminal appeal to
is
some?
with me, your.
Appeal of file to some.
Check कर दिया है कि delay है ही नहीं.
अच्छा, observe कर दिया।
What I have checked.
Oh,
It has been observed, there is a no delays as such. I was provided with this delay condonation.
although
with
the
Bangalore.
filing section noting reflects that there is no delay in filing of the
But
connected
they
criminal.
themselves said that is why we have given. And later on, this has been done, which is not in our knowledge. We have filed this one long back, that is on 11/2/2026 on their instruction only.
No, here the noting is condonation petition not required. Although there is a noting by the filing section that a condonation for, that an application for condonation of delay would not be required with the connected criminal appeal, comma, it has been pointed out, it has been fairly pointed out by the learned counsel appearing for the parties that there appears to be a delay of around 10 or 15 days.
10 days.
We'll say he said 15. Okay, 10 days in filing the criminal appeal. Accordingly, the learned counsel for the appellant is allowed to file a petition praying for condonation of delay of the 10 days.
No, there is no, as such, not required then. Because earlier we are informed, that is why we have given. Maybe they have again calculated because when it remain on defect, they used to calculate.
But there is a delay, just I can indicate in 1 minute.
We will deal with the situation which is before us. There is no calculation here
Yeah.
on the date. There is no calculation on any of the pages.
But it's my objection that there is a delay, Your Lordship, my record.
If we record that, Mr. R. Dubel and a counsel appearing for the respondent has also objected to taking out of the criminal appeal on the ground that there is a delay of 10 days in filing the connected criminal appeal. Learned counsel for the appellant may verify and if required file.
Because
And
with me, this office copy is with me. That is the problem. And
I'm
I
giving you
will
the-
take instruction there.
I'm giving you the option to verify and file a petition
Yes,
for
it was.
praying for condonation of delay if any delay is found to be
Much obliged.
there. List along with the IA praying for condonation of delay, comma, if any filed. Full stop. If no delay has been, if the appellants list again on 25th of September 2026. List again on 25th of September 2026 along with the application paying for delay of for condonation of delay if any is filed. Anything more? You have done half of tomorrow's work. Hmm?
I know.